Welcome and good morning to the first hearing of the committee's 2024 review of the Dust Diseases Scheme. I commence by acknowledging the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past, present and celebrate the diversity of the Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today, either who will be with us in the room or joining us over the internet. My name is Greg Donnelly and I'm the chair of the committee. I ask everyone in the room, if they've not done so already, to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they provide to the inquiry. However, it does not apply to what witnesses say outside a hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence before the inquiry. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of the procedures. Welcome and thank you for making yourselves available today. Starting from my left, I'll ask each of the witnesses to state their name, their position title, and swear either an oath or affirmation, whichever they prefer, the words of which should be before you. So we'll start with Mrs. Sorry, my glasses are not so good today. Flores, thank you.
Thank you, Chair. Ms. Natasha Flores, I'm the Industrial Officer for Work Health and Safety and Workers' Compensation at Unions New South Wales.
Thanks very much. I'll get you to make
Sorry.
No, that's fine.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And Ms. Haywood.
Thank you, Chair. My name is Sherry Haywood. I'm a Senior Legal Officer for the CFMEU Construction and General Division. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you both very much. Now, we were to be joined this morning by Mr. Shay DeGura, who was first of all going to be appearing in person, but then we're informed we'd be doing it virtually, but we've been just informed. Oh, beauty, good. Okay, great. DeGura, thank you very much.
Can you hear me?
Yes, please. Welcome, Mr. DeGura.
Thank you. My name's Mr. Shay DeGuara. I'm up here on behalf of the PSA, but my position role is a National Industrial and Research Officer for the Community and Public Sector Union.
Right.
I'll...
Would you like to make either an oath or an affirmation with respect to your evidence? I don't know whether you've got the words in front of you for either.
Yeah, I have, but they're buffering, so I might rely on repeating.
Yeah, no, just do it nice and slowly. We can hear you. So, no, just please proceed.
Yeah, they're buffering at the moment, the words. If I could repeat the words, that would be probably better.
Yeah, no, that's fine. I'll just get the words up. So sorry, did you say the oath or the affirmation?
Oh, the affirmation, please.
Sure, okay. Well, if I read them and you repeat, so is that okay?
That's fine.
I solemnly, sincerely and truly declare.
I solemnly, sincerely and truly declare.
And affirm that the evidence.
And
affirm that the evidence.
And affirm that the evidence.
Now about to be given by me.
Shall
be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Thank you very much, Mr. Gura.
Could I also just say, the reason why I'm actually online today is I've had a specialist appointment which was moved at last minute, and I will have to leave before 10, probably about 10:15. And I'm happy to take questions on notice if it pleases.
No, thank you very much, and in the circumstances, appreciate you making yourself available to be able to participate this morning, and perhaps in light of what you said about having to get away, the witnesses in the room might be able to give some consideration for that in terms of the ordering of responses to parts of questions or other aspects of issues we deal with this morning. Well, I might commence by inviting an opening statement from the witnesses. Just noting, if I could, that with respect to your submissions from each of the organisations being represented here this morning, they've been received, processed and stand as submissions to the inquiry, and they're all very good submissions. That the CFMEU Construction and General Division New South Wales branches inquiries number 15, Unions New South Wales stands as number 16, and the PSA of New South Wales stands as number 17. So take them as read. But if I perhaps start with, well, it doesn't particularly matter, but same with the oath or affirmation with Ms Flores, and we'll work our way through. So Ms Flores, would you like to make an opening statement?
Yes, thank you, Chair. Good morning, and thank you for the opportunity to address the committee today. Unions New South Wales has held concerns about the unsafe levels of silica workers have been exposed to in the tunnelling projects for quite some time now. Under the previous LNP government, Liberal National Party government, myself, Mark Morey, Secretary of Unions New South Wales, and representatives from the Australian Workers Union met with the then Minister responsible for WH in New South Wales, the Honourable Matt Keane, to share our concerns about the amount of dust workers were being exposed to. We provided the Minister with photos that had been secretly taken by a worker in the North Connects tunnelling project. I say secretly because any worker who complained about the unsafe working conditions would usually find themselves punished for raising any concerns. Often this meant assigning them work above ground, which was paid far less than work below ground. For this reason, most workers were reluctant to complain about the conditions underground. The photos this worker provided showed dust so thick it was difficult to see anything but the dust in the photo. The Minister showed concern and handed these photos to representatives from Safe Work New South Wales. I believe one of these representatives may have been Mr Tony Williams, and Mr Williams, who was handed the photo, as he was handed the photos, the Minister said words to the effect, "Please do something about this." The Minister assured us that he took the safety of the workers very seriously and would address our concerns. We left the meeting confident of the Minister's commitment to eliminating this deadly hazard. However, we did hold concerns about Safe Work New South Wales' commitment to ensuring these workers would be protected from this hazard. The article by journalist Max Madison released this week, Tuesday, by the Sydney Morning Herald, along with the submission by the Australian Workers Union, would suggest our concerns were justified. For years now, workers have been exposed to unsafe levels of silica, and the sad reality is many of these workers will contract dust disease. While silica may be named the new asbestos, the risk from asbestos has not disappeared. Given the age of much of the asbestos that remains in our buildings, it is now showing signs of deterioration and will continue to do so. This legacy asbestos will be a hazard for decades to come. The dust diseases scheme will remain relevant for many years to come as a younger cohort of workers with young families seek access to the scheme and people continue to develop asbestos-related diseases and silica-related diseases. And for this reason, this review is extremely timely and relevant. Thank you.
Thank you very much, Ms Flores. If we move now to Ms Haywood.
Thank you, Chair. The CFMEU has always been a vocal advocate in the dust diseases space, offering our members a voice at the table to ensure they're protected from dust exposure and supported into the future. Our highly successful campaign to ban the engineered stone has helped to prevent some exposure, but there's still more to do in this space to protect workers in New South Wales. The CFMEU has and continues to raise concerns about the effectiveness of Safe Work New South Wales in exercising their legislative role under the Work Health and Safety Act. As regulator and educator, Safe Work has and continues to fall short of community standards and expectations. Their response to the emerging silica crisis was called out by the Auditor General, as was the inability for the agency to conduct an effective search of its own database to identify emerging hazards. At the most basic level, even the Safe Work website fails as an effective education tool, with important information hidden several pages deep and few references to legislative provisions and no reference to relevant case law. Given Safe Work's failures, workers need a dust diseases scheme that is flexible and reflects the needs of the workers in New South Wales. The CFMEU and its members would like to see a dust disease scheme that provides appropriate financial support, provides retraining and rehabilitation programs which support a career change into skilled industries, and a scheme that relieves some of the administrative burdens on dependents of deceased workers. A peek over at the workers' compensation laws might assist in developing a benefits regime that adequately supports younger workers and older workers. We would also welcome an expansion of the diseases covered by the Act to include dust-related respiratory diseases, dust-related autoimmune conditions, dust-related inflammatory diseases, and dust-related renal disease. Just recently, 2 of our members were diagnosed with both silicosis and scleroderma, a rheumatic disease. It is common for our members to present with both these conditions following their exposure to silica dust, but the way the Act is set out makes it difficult for them to claim for the scleroderma at a time when they are just trying to get the support that they need. Workers in New South Wales deserve a proactive, well-resourced and committed safety regulator, as well as a scheme that can provide them adequate support and appropriate retraining to incentivise workers to get screened and tested early in their working lives.
Thank you very much for that very precise and clear opening statement. We'll move now to you, if I could please, Mr. Tegura. Would you like to make an opening statement?
We'll mostly rely on a submission, but just wanted to say that we actually had a very well-resourced and sort of proactive dust diseases scheme when we had the Dust Diseases Authority, and I think it worked well in the 90s to basically have a feedback loop with what was work cover at the time, and they were sort of embedded with each other, but they were separately structured, and that sort of has gone to the wayside to a degree. It's now starting to improve again, but there was a really good feedback loop. So with the workers' compensation and with the dust diseases scheme, I know it's out of scope, but and we'd actually look at where injuries were happening and disease and feed that back into the safety systems, and the safety system would then regulate safety properly. So if we could have that sort of model come back, that sort of closes the loop,
yeah.
And that would be a good thing to happen. And bringing it into, I think, eye care sort of made it the dust diseases sort of a secondary or tertiary sort of concern when you've got big issues like the scheme's viability, the novel insurer, etc., and even the TMF. So I think, and always the dust diseases scheme seemed to be run really well as a tripartite body, and its capitalisation, which really worried some governments, was on track prior to its merging into iCare as well. So,
Okay.
Thank you.
No, thank you very much. Well, if the witnesses are happy with it, we pass the questions around in a pretty informal basis. So, represented here at the table today, members of the government, the opposition and crossbench, so we can share the questions around if you're okay with that.
Yes.
So who would like to kick off? So we can step back up.
Thank you very much, Chair. And thank you to our witnesses for your really detailed submissions and for appearing. I just wanted to ask, perhaps I'll start with you, Ms. Hayward. We've heard a lot, and this comes back as well to this this story that came out in the SMH about the tunnelling. I understand that there are rights for workers to request data on site about air quality. What are the practicalities around actually doing that? And I'll also come to you as well, Ms. Flores, because I know that you talked about, the sort of fears of punishment. Can you talk us through the reality of what it's like to call out air pollution?
It's a very difficult thing because tunnelling is such a high-paying industry because of the risks associated with it. There is a lot of fear from workers on the ground about how far they go in requesting information, even HSRs. So there is a requirement under the Act for the PCBU to consult with all its workers about any hazards and about how they might manage those hazards. And the point of the Act is that the workers and the employer work together to manage the safety in the workplace because we have safer workplaces when everybody's working together. What really happens is the HSRs will contact their union, and the unions have rights under the Work Health and Safety Act to enter into a workplace to investigate suspected contraventions of the Act. And as part of exercising those rights, they're entitled to request documentation about the hazard. Air monitoring reports would squarely fall within that category of documents that would be related to a suspected contravention. Unfortunately, when you try and request those records, the PCBU claims that they're legal professional privilege. Now, even though they wouldn't ordinarily fall within the gambit of what is legal professional privilege, in order to enforce the right to have access to those documents, you would have to look at bringing proceedings. And you need those documents at the time, not 3, 4, 5 months down the line. And we've seen, in other spaces in the work health and safety space, other cases in the work health and safety space, going to the IRC to get your hands on those documents is a very lengthy, protracted and legal process. So it is extraordinarily difficult to get your hands on any reports that would be relevant to just tracking exposure.
Okay, so that's incredibly useful, because I think we have a situation then where the Act is implying that it's quite easy to get this data, when in reality it seems to be incredibly hard. What could we do, I guess, from a regulation perspective then, to ensure that that data is more readily available?
The big issue is the way that SafeWorks rights under right of entry are handled. So they can only facilitate the resolution of a right of entry dispute. They can't force anybody to hand over documents if they think that it's relevant. So SafeWork can turn up and say, yes, those are the documents that could be produced under Section 117 of the Act. But if the PCBU says no, there's very little we can do about it, you have to go off to the IRC and get an order to that effect. We would like to see a little strengthening of SafeWorks roles in that space. Air monitoring results, if a report is done, they are supposed to be available for the workers. They are meant to be put up in a place where the workers can access it. We'd like to see a little bit more of enforceability around that. If you are doing air monitoring, which you should be doing, you should be putting it up in the training rooms. You should be putting it up in the lunch rooms. You need to make it available to workers so that they know, hey, there's a problem here. Maybe we've got a solution for how we can fix it. And to ensure that those workers know they have a right to consultation as well.
And is it easy to work out, I guess, so there's two things, is having the data available, readily available for people to see,
Yeah.
But then also, I guess people need to understand it as well. Is there any regulation around that and sort of how it might be? I mean, I kind of imagined it would be some sort of flashing board or something when it got, like, when the air quality got so bad. But from what you're saying, it's more about sort of sticking something up, piece of paper.
Yeah, it's the air monitoring devices are getting better about how quickly you can get the data and how accessible that data is. There is a requirement for silica awareness training, and I know that a lot of enterprise agreements, particularly CFMU agreements, but I do believe others as well, require an employer to undergo or to provide silica awareness training. I would think that part of that training would be understanding what you're looking at, particularly in terms of the workplace exposure standard, so the workers can go, hang on a minute, that's a problem. But we're not even at that point. The reports aren't even being made available, let alone whether the workers know how to read them.
And then if there was a problem, there's then those issues about how do you raise it without consequences, and then if you raise it with your union, how do they then get the information, etc., etc. So, okay. Sorry, I'm hogging questioning.
No, that's... so we just share it around. Deputy Chair, I'll look this right.
I suppose just following on from Abigail's questioning, why couldn't the air monitoring data be published in real time? Like, why couldn't it be? I think you mentioned, why couldn't it be like on boards, like in the, like on screens in the staff cafeteria, or the, in the staff room or something like that, so that people can see it in real time? Like, why is it so opaque?
To be honest, that would be everything that we could ever want,
Yeah.
to make it that readily available. That is a question that you, with respect, might need to check with
Safe Work.
the Safe Work and
Yeah.
the employers. I suspect the answer is going to come back money. And but if there was a way that workers could see that in real time, I mean, one avenue that we do see it and is methane in the air in some mines. Since the Pike River disaster in New Zealand, you can get those real-time reports. There's no reason we can't be doing it for dust as well.
And yes, sir.
Can I jump in
Yeah,
and
yeah.
just follow on from yours?
Yeah.
Thank you both for appearing. Look, I have no experience in tunnelling whatsoever, right? And don't want to profess that I do. Following on from Chris's thing, right, and the old canary in the coal mine type thing, is there equipment available in terms of air monitoring that would flash a red light, for example, if certain levels, or dangerous levels, were reached? So in other words, rather than real time appearing then in the cafeteria, in the staff room, but in the actual workplace, for want of a better word, in the actual tunnelling area itself, if the dust level, or the quarry, wherever it is we're at, if the dust level reaches a dangerous level, that an alert sounds immediately and people are aware of it. Does that type of equipment exist at all?
I'm not aware of it, but I would think the occupational hygienist might be able to answer that question.
Thank you. Sorry,
Can I
Chris, to
just-
interrupt.
That's okay.
Can I add something?
Yeah.
Sorry. Just to your question, Abigail. Unfortunately, the photos that I saw, you didn't need a dust monitor to see that those levels of dust were exceptionally dangerous. You couldn't see your hand if you'd held your hand up in front of you. These workers were working almost blind in the dust. So we're at, in some cases, such an incredibly hazardous stage that it's even beyond just, reading the levels. We know the levels are catastrophically high. What I was told at the time was the management of that hazard was very much dependent on perhaps the site manager at the time and the shift, and sometimes that site manager would take the time to put all the correct measures in place to clear the space of putting in the filtration or systems, and the workers would obviously they need properly fitted equipment, etc. So what I heard was you could have a good shift or you could have a bad shift. If it was a bad shift, it was a shift where things needed to be done really quickly and you were on a time schedule, so there was pressure to get things done. We've got to get this much done in this time, so we don't have time to worry about the dust. We've just got to tunnel through. You'd have to ask my colleague, who I believe will be appearing after us from the Australian Workers Union, but if you saw those photos, you don't need a monitor to see that those conditions are incredibly hazardous. And you will ask, obviously, Mr. Donovan questions about that, and he'll be able to give you more information. But I'm not an expert in any of this. I'm not an occupational hygienist, but I looked at those photos and was horrified. So knowing that people have been in that condition for some time, you will have a dust disease. And any thoracic specialist will tell you that really nothing other than oxygen is appropriate for your lungs. So even when we're looking at minimum levels, we're being generous, because really the only thing our lungs like is oxygen. So we really want to eliminate it as much as possible. And in this case, these workers were just coated in it. So it was extremely hazardous, and I don't know that it's changed a lot. I hope it has. I hope it's not as bad as what I saw, but it was horrendously bad.
And can I just ask on the back of that, you mentioned the properly fitted equipment.
Yes.
What are members telling you about that?
Again, I think Mr. Donovan can give you more information about that, but again, I think we hear that it comes down to time and money, and it obviously, to get the right equipment, it can be expensive. People need to be properly fitted for their own body and face, clean shaven, etc. And that comes down to making sure that, you know, the workers are clean shaven, etc. Because if you've got a big beard, that will affect the mask. So time and money, I believe.
We have a lot of disagreements with PCBUs about fit testing. It's one thing to provide the PPE, but if it's not fit tested, it's not going to work.
Is
Chris,
there,
yeah, back to Chris, yeah.
is there also an issue of not enough air monitoring being done at the moment, or is it more of an issue of the opaque nature of the data, or is it a bit of both?
It's a bit of both, and I think we've seen in previous inquiries just how unclear the legislation is about the requirements around air monitoring and when it needs to be done. In fact, this committee is differently constituted, but has twice made recommendations that those provisions be made clearer. So there's always a disagreement about whether or not air monitoring should have happened in the first place. The new regulations that were inserted for the crystalline silica go to manufactured stone workplaces and not necessarily tunnels. So it's not as mandatory as we would probably like it to be. Whether or not it's being done, I think you can see from the AWU submission, it's very unclear because that data is not released to anybody. So we couldn't sit here hand on heart and say it's not being done, the same as we couldn't say it is being done.
And in your submission, you spoke about like portable air monitoring devices, and you can use your like electronic devices or mobile phones or something. Can you run that through with us a little bit more as well in terms of what you're recommending or suggesting?
Yeah, so there's been a bit of a disagreement in some of the tunnels from some PCBUs in relation to right of entry, so the ability to go on and investigate. Some organisers have personal air monitoring devices. They're not perfect, but they might give you some indication that there's something more you need to be looking at. There has been an argument from those PCBUs that the Work Health and Safety Act does not permit those devices from being used when you're investigating a suspected contravention. Is the same argument they have about mobile phones and whether or not taking pictures or videos is not permitted under the Act. The argument from the PCBUs is because it is not explicitly stated that you can do those things, therefore you can't. We don't necessarily agree, but to the extent that that is true, the legislation needs to be amended to take into account that, because if you're there to investigate whether or not the workplace exposure standard has been breached, having a personal air monitoring device is going to make that investigation much clearer. And I know ACT has changed its legislation to allow for things like mobile phones to be used as part of those investigations. We would say, well, if we're having this argument on a daily basis about whether phones and personal air monitoring devices can be used, maybe we just make the legislation clear that they can.
Can I add to that in, I think in around about 2018, Unions New South Wales tried to work with Safe Work New South Wales with a memorandum of understanding that would assist union officials with their right of entry, but unfortunately we weren't able to reach agreement with that. Safe Work would not really commit to anything beyond the wording of the Act, and we had requested that they would assist us in facilitating right of entry where there was a suspected breach, but unfortunately that didn't occur. So anything that could be done in the legislation to make that more solid would be very helpful.
Can I just ask about that? It seems extraordinary, I have to say, that that PCBU could say you can't use a particular tool to conduct an investigation? I mean, like arguably pen and paper is a tool. Can they say, oh, we can't use that? Okay, has this question been litigated in any way?
There've been situations where union officials have been sat on a chair with literally tape around them and told that's as far as they can go. And we had that argument with SafeWork during COVID where we couldn't get access to a particular abattoir, and the union official who went in to conduct an investigation was taken to a chair with a bit of tape around that chair and told, sit there, do not move. So that's the reality.
As I understand it, the AWU had sought to bring proceedings in relation to the personal air monitoring devices. I'm not sure where that got to. It's one of those situations where, as a union, you need to consider what's the consequences if you're wrong. And so a lot of thought goes into bringing right of entry proceedings about how sure are we about what the legislation says and what is the prejudicial outcome if we're wrong. So I think it's one of those areas where there's a lot of reluctance, and I know as somebody who runs a lot of right of entry litigation, there's a lot of reluctance to push that point. We'd rather have the discussion with the PCBU on the ground and try and come to some arrangement. But it is an area that probably needs to be spelt out a lot clearer.
Is this something that could be remedied through immediate regulatory action, or is this something that would require legislative?
It would require legislative
change?
Reform. It would need a change to Section 118 to explicitly allow for things that are necessary to conduct the investigation. So you would have to explicitly call it out. That's what the ACT did in their legislation.
Can I come back to this question about legal privilege on air monitoring results?
Yeah.
Can you just explain how that... I don't really understand how air monitoring results can be the subject of legal privilege.
You and me both.
It just seems...
This is the subject of many letters I write on a regular basis. The purpose of acquiring the air monitoring report is not for the purpose of litigation. Therefore, legal professional privilege should not attach to that report. These are arguments I have on a regular basis with PCBUs. Unfortunately, SafeWork is of little assistance in that space. Again, it's one of those things that you would have to consider litigating. Litigation is not cheap, and it is not quick.
Does the HSR, surely the HSR has a right to that information?
It's the same thing. They'll claim legal professional privilege over it as well. In saying that, there is no, under the Work Health and Safety Act, legal professional privilege is not a reason to withhold information.
The purpose of the Act is to fix the situation and to create better, safer environments. The Act, I don't believe, was ever written to be something that was litigated heavily and argued over. It was meant to keep workers safe, and the objects of the Act clearly state that all parties should be working for continuous improvement in safety. But unfortunately, PCBUs get extremely defensive and worried, and we get locked out and told to go and sit on a chair in the corner.
So, I mean, there is, as I understand it, there is a specific capacity for HSRs to access information about the safety arrangements in a workplace.
Yep.
How much more specific can we get, like, to overcome a problem like this? When does it become obstruction?
Well, and that's the thing, like, this is why I think the way that we talk about SafeWork's role under the Act, everything is facilitation. So if there's an issue on the site and they're called out to help with the issue, it's just facilitation. They don't issue decisions. They can't say to a PCBU, you must do this. All they can do is educate them. It's then up to you to enforce the legislation. If I was sure that SafeWork would go and enforce the legislation on these smaller things, then we'd be in a different situation. But they really only go after the big fish, when really they should be looking after all the aspects of the Act. I'd like to see SafeWork prosecuting for lack of consultation. I'd like to see Safe Work prosecuting PCBUs for hindering union officials in the exercise of their duties. It shouldn't be up to the CFMEU to prosecute builders for their failure to comply with the Act.
You've been very critical over a long period of time of the regulator. Obviously, the government's making changes to the structure of the regulator. What more needs to be done? What would you recommend that this committee recommend coming out of this inquiry in terms of measures that need to be taken to make Safe Work a more effective regulator?
Safe Work, I think there are cultural issues, and I do believe that the core purpose of any safety regulator is to keep workers safe. Now, under the previous government, there was a heavy focus on education, but unfortunately, that didn't work as far as we saw. That didn't change things. It didn't improve safety. As Ms. Hayward said, we need some stick, a little bit less carrot. That's what we've had for a very long time. I would also argue that back in the day, unions had power to prosecute in some cases under Category 3, and that was something that, you know, a union could easily do and quickly do to remedy something, whereas now prosecutions are extremely difficult for unions and they don't do it. It's expensive and you can only do Category 1 and 2. But that was under the previous Occupational Health and Safety Act. So in that case, you sort of via past the regulator when the regulator's not going to do something. I would argue that could be helpful because there were unions, and I was in one, that used that regularly. And that were, you know, we were looking at outworkers in clothing factories where there were horrendous trip hazards, and out, you know, backyard factories and garage factories and things like that, and quick prosecutions were easy and you could rectify a situation quickly.
I think from our perspective, look, I will give some credit to the acting Deputy Secretary. He is actually starting to have discussions. We've at least had a discussion with him about, you know, the relationships between unions and Safe Work. But it's more fundamental than that. Like, we've got individual inspectors deciding which sites they're going to go to, which ones they're going to look at. I've got inspectors that are too close to the PCBUs, and because they're providing them with advice on Monday, they don't want to do anything when they do the wrong thing on Tuesday, because there's a perception then that, well, did I tell them to do that? Because I can't give them a notice if their defence is going to be, well, you told me to. I think the one area that I think Safe Work should be focusing a lot more on is enforcing the consultation requirements. The entire purpose of the Work Health and Safety Act is for consultation. It is for the workers and the PCBUs to work together to make a safe workplace. If Safe Work is not forcing the PCBU to talk to the workers about their safety hazards or how they might resolve those safety hazards, they're failing in upholding the fundamental principle of the Work Health and Safety Act. So you should be prosecuting these particular assets. Yes, we should be prosecuting fatalities. Yes, we should be prosecuting serious safety issues. But we wouldn't be at that point if the consultation was fixed first. I mean, for myself, we've had a few issues up in the Hunter Valley in a particular site up there. I've specifically requested Safe Work to help facilitate consultation on that project. And we're heading in that direction, but we're getting there slowly. But for me, the fundamental issues on that project are the consultation between the three entities. If Safe Work enforced consultation, we'd be in a much better position.
And strangely, as a person who has trained health and safety representatives and is a qualified trainer under Safe Work, a large part of the training that you deliver to health and safety representatives is about the Act being all about consultation and the HSR's pivotal role in that in consultation. So, you know, you have a HSR to assist in facilitating consultation. So that's a very important point. This Act was built upon that, and it was built so that we all work together harmoniously to create safer workplaces, not fight constantly and dispute and find loopholes. This seems to be where we've got to, but really the objects say we work together for continuously improving. I think it's continuous improvement of health and safety.
I might go to Honourable Susan Carter. I think the Honourable Rod Roberts might have had. But anyway, Honourable Susan Carter.
Thank you. Thank you both for being here. Ms Hayward, if I can go back to the legal professional privilege argument, I believe you said that it was possible to get an IRC order. I'm just wondering what timeline and costs involved in that.
Yes, so Section 142 of the Work Health and Safety Act allows a person to bring a dispute about a right of entry matter to the Industrial Relations Commission. What we've seen is, and then there's a particular nurses matter that the litigation was drawn out quite significantly. The hospital in that matter had engaged a very large law firm to help draw out the matter before, and it took more. I think it took more than 12 months in order for a resolution. There are no costs in filing at the IRC itself. There are time factors. You might want to engage legal counsel to assist with that matter. If you know your public hospital is engaging with a very large law firm, you might also want to consider getting somebody who's a specialty in that area to do it as well. So it can be quite prohibitive when you should be spending your money, your members' money on other things, just to get access to a document.
And is that just for right of entry, or that would be for air quality monitoring reports?
If you're requesting them under right of entry.
Right, okay. And given that there seems to be this attitude that they are privileged documents, is that what would be standing in the way of making them publicly available in canteens and other areas for workers?
That's the excuse we've been given, yes.
Right. And has that ever been tested?
It hasn't. Sometimes a nasty letter can get a long way. So, you know, a lot of communication backwards and forwards. Eventually, the PCBU might relent, or it might be that safe work comes on and after a number of weeks and gets it that way. We haven't. Again, it's one of those things where you've got to think about what are the consequences if you're wrong, because right of entry is a difficult process. It can be quite an argumentative process, and any court decision can severely restrict the rights of a permit holder when all we're trying to do is keep workers safe. So it's always a cost-benefit analysis when we're looking at bringing right of entry matters.
And the legal professional privilege claim, is this a new issue or has this been long-standing?
It's been this way basically since the tunnels started.
And so it's a specific tunnelling issue rather than other
It's not
areas?
just a tunnelling issue. I have that issue in other places as well. It is more pronounced in the tunnels though.
Okay. And is there any other safety documentation about which these claims of legal professional privilege are made?
Any report that might be damning. So I've had reports around E. coli exposure that have been legal professional privilege. I've had engineering reports, so in relation to the building of buildings. Engineering reports have been said to be legal professional privilege. Hygienist reports in general on any construction site. I've had builders say that they're legal professional privilege. I've had assessments over whether an emergency response plan is sufficient be deemed legal professional privilege. It really depends on who's educating the PCBU and who's been engaged to assist with the matter. It comes up in the context of right of entry for us, and right of entry is there are a lot of law firms in New South Wales that think they know right of entry very well. They don't. And they try and use the legal professional privilege as a way of preventing union officials from exercising their lawful rights.
And so these documents, like an E. coli report, has it been prepared by
Yes.
a lawyer?
No.
And there's no ongoing litigation in respect to that matter? It's not being requested after a letter of demand or some initiating process has been sent?
No.
Okay, it's very interesting. Thank you.
Yeah.
Yeah, I find that surprising.
It's very frustrating.
Yeah.
I'm just conscious that it's nearly 10 to 10 and Mr De Guerra may be having to go about 10 o'clock or so. Mr De Guerra, you're still there, I gather? Oh, he's left the building. Okay, sorry, I just missed him. Okay. No, that's okay. I'll just jump in and then I think back to Ms Abigail Boyd. When this committee, under the chairmanship of Honourable Chris Breath, dealt with the manufactured stone issue, which has been addressed, although not absolutely, but we know what's happened and we don't need to go through that. Sort of observation I think that could be made, and people might have different views, is that on a state-by-state basis or jurisdictional below the Commonwealth, different states were doing different things and it was patchwork. It really wasn't until at the national level, I used the sort of vernacular, they started to get their act together on this, that it moved what seemed to be relatively quickly to get to the banning situation, although the banning matter had been raised and prosecuted over a period of time. It seemed to require that, I mean, it might be wrong, but it seemed to require that sort of movement nationally, and what obviously was the consensus that was achieved by the states and territories of the Commonwealth to deal with it. But that took some time. Surely there is a fear, potentially, that that same plan follows. The states are doing the different things, and eventually the Commonwealth will get the states into a room and they'll come to a consensus position, and then some of these things may fall into place. Now, none of us have a crystal ball, but do you have any insights into what's actually happening at the national level that you might be able to share with us and explain to us where that might be? Or are we still in a situation where we've got the states referred to the ACT, other jurisdictions doing their own thing, and we're looking at something that we might get 2 years down the track, which of course would be something we'd be very concerned about?
I think it's the problem we've got in New South Wales is tunnelling. We've got the most tunnelling infrastructure compared to any other state.
Yes.
And so it's not really an issue that every other state is looking at as an emerging crisis for them.
As a distinction,
Yeah, and I think that's why it is being raised, I'm aware, because Comcare has jurisdiction over a particular PCBU who does tunnelling work. And I'm aware that they are doing investigations into the tunnels. I think I've put some of that data in my submission. But whether or not it's on a national agenda for tunnelling in general, because it seemed to be a New South Wales issue with the amount of all the tunnelling we're doing. There's nothing to prevent New South Wales going alone. In fact, I mean, we've seen today the Queensland government has just brought in a new bill to change work health and safety laws. So there's no reason we can't be looking at this issue separately, but it's not going to be dealt with nationally because it's not seen as a national problem.
Principally New South Wales, with some Queensland and Vic probably added in there.
And on that too, tunnelling is something that sort of comes and goes, and an ex-colleague who was a tunnelling specialist many years ago, who's since retired from the Australian Workers' Union, said there'd actually been quite a lapse in time since we'd had such a large number of tunnels built. And so we had a generation of workers who were quite experienced in tunnelling and controlling the hazards in tunnelling, who were no longer in the industry. So the workers who are in the industry now are a newer generation of workers. So that knowledge and that from the previous generation who'd tunnelled throughout Sydney had disappeared and not been passed on. So it comes in fits and starts. You know, so the government will say, well, let's build lots of tunnels, which is what's happening now. So hence this issue, and I guess why we're here today.
Also, New South Wales, its geology is unique. We've got the sandstone.
Yeah.
So it
Ideal.
creates... Yeah, so I think we're sort of on our own in dealing with this problem.
Yeah, no. And just one quick final one. With the PCBUs, which have been sort of referred to throughout the evidence, for the unions, when they have members on a site beneath the ground in tunnels, when they're endeavouring to deal with matters, do they find themselves dealing with one or multiple PCBUs in endeavouring to deal with the issue itself? In other words, is it the typical situation that there is one key contractor that's got the work, a large construction company, and they're the ones that they deal with? Or for the purposes of the dust issue, there could be multiple subcontractors working with the primary contractor, and therefore that's an added complication to get all those ducks in a row.
It's the latter. Construction is built that way,
Yeah.
where there is just too
Multiple.
many people.
Yeah.
So one example was when the Haberfield hole was being dug to start the
Yes.
construction there.
Yeah.
We had some crane operators who had raised with their employer the dust exposure
Right.
and whether or not it was safe for them. And while it is an employer's job as well as the builder's job to ensure the health and safety, we had a situation where for 4 months we had the employer saying, no, it's the builder's job, the builder saying, no, you're the employer, and then we had a dispute about who was going to pay for the screening for the workers, because it's, employer subsidised screening in New South Wales. And this went on for 3 to 4 months while these workers were just trying
And I
to
believe
get
the
the
community-
PPE, just to get screened, just so they had that peace of mind. So
In that case, I think the community also got involved.
the community
No,
did
that's-
get involved,
yes,
yeah.
I do remember that, yeah.
Yes.
Yeah, so it is a bit of a hierarchy problem, but everybody has a responsibility.
Oh, yes, no, I wasn't
You have a lot
guessing
of,
that point, but I'm
Yeah.
trying to understand the complexity, yeah.
It's very complex. You
Yeah, no,
have a lot
indeed.
of trades. You've got
As it was,
electricians. You've
yeah,
got plumbers.
as
you've
I
got,
expected that it would be, yeah.
So
Yeah.
quite a network of different trades that need to be there at different stages to obviously you've got the people tunnelling through, but you've got electricity, you've got plumbing,
Myriad.
engineers, lots.
Go board.
Thank you. Just looking at the sort of, I guess, the other focus area of the inquiry, I think you both mentioned, and there's been a lot of submissions have been talking about our new understanding that these dust diseases are not just lung-based, but a myriad of other types of diseases as well that currently aren't covered. Can you talk to us a little bit more about that? And I guess from the evidence we're hearing in relation to the tunnelling, is there going to be this new generation of workers who are going to present with these illnesses?
Absolutely, there
And
will be.
Are we not prepared?
We're not prepared.
For that.
We're not prepared. Look, the system was built for asbestos. It was built for older workers. It was built for those who are ageing out of the workforce. I think the average age, and iCare can get you the correct statistic, but the average age of the person in the scheme is about 80 years old. But we are seeing these people in their 40s, their 30s, starting to come through, and it's not just from the manufactured stone; it's also from the tunnelling. And what we've learned is silicosis can evolve, and yes, you might have silicosis, but in a lot of examples, you're also going to have something else. So, as I said in my opening, 2 workers in the last week, they've got scleroderma as well, which is a rheumatic disease.
And it's a fatal disease, I believe, too. So
And then there's a discussion about, well, what is covered by the Act and what isn't covered by the Act, what incapacity is related to silicosis, what incapacity is related to the scleroderma, and it becomes quite a stressful process for people. I know that having had the privilege of sit on a medical panel looking at some cases, one of the things they were looking at was can you find a connection between rheumatoid arthritis and silica exposure? So as medical treatment moves forward, as we learn more about these illnesses, we start to see that they do evolve in these other ways into autoimmune diseases, inflammatory diseases. I know that ADRI is also doing some research in this space to work out, is it more likely that you're going to end up with these illnesses as well? The scheme's not built for that. At the moment, you can do some tricky word play with it to see if you can get it in there. You've got to have the silicosis first in order to bring these other things in, but even then it's still a fight. So I think we're at the stage where we're learning more about what silica exposure can do to the body, and we may not be ready for whatever comes next. And that's why I think looking at the recommendations from some of the lawyers that have made submissions to this inquiry, expanding the definition is the only way we can future-proof the scheme.
And so, okay, and then I guess from the perspective of the modelling that presumably Sarah's doing in relation to...
It's not, Sarah doesn't have control of the dust scheme, so they have a very limited role. They only collect the levy.
Okay.
So the dust scheme is administered by iCare.
Right. So does iCare then model?
Yes.
In terms of, right, so it's them that would need to increase the levy if they thought that...
They would need to apply to have the levy increase, yes.
Okay.
I will say the dust scheme is doing better financially, significantly better financially than the nominal insurer is. So we're not talking about, if we're expanding it, we're going to suddenly run out of money.
Yeah.
That doesn't mean the levy may not need to go up, but it is already a small proportion of the money that is being collected. It's not going to be a big hit if it does increase a little bit.
What's the relationship between the dust scheme and workers' compensation? I assume there would be workers that would traverse between the two, depending on...
Until you get an award, as I understand it, it's not my specialty area. The Dust Act piggybacks off the Workers' Compact in some respects, the pre-2012 Act. But if you've got a diagnosed condition, I think, and don't quote me on this, you might need to check with others more expert, you jump over to the dust scheme.
That's my understanding.
It's the benefits are different as well, because there's no time frames in the dust
more
scheme.
generous in the dust disease scheme than
Well, not financially.
No.
So the weekly benefit amounts are based on the pre-2012 provisions, and so you have the 26-week step down to the statutory rate, which is, I think, about $590 a week, whereas over in workers' comp, the maximum you can receive is $2,523 a week. So from a weekly benefits perspective, yes, you'll have access to benefits for longer, but what you're receiving each week is about $2,000 less than what you'd get if you were under the workers' comp scheme. And for these workers in particular who work 50 hours a week and are almost always hitting the cap in workers' comp, this is why they don't make claims. Because if you're going from $2,500 to $593, you're thinking about your family, and you're not going to take that hit.
It's a loss of employment essentially, and your income and your. My understanding too is it should be less. There should be less disputation in that model, because once you have a dust disease, that shouldn't be disputed. But unfortunately, there are still disputes, and they happen still, literally on people's deathbed as to whether they're entitled to compensation. That's one of the jobs of, one of the things I do know the organisation ADFA does is advocate for patients who are dying.
Donald Cisco or Rod Roberts. Yep.
I might just backpedal a little bit.
Yeah, sure.
To your knowledge, has Safe Work ever launched any prosecutions in relation to exposure in tunnelling?
Not in tunnelling. They have only just recently done manufactured stone, given their 8-year lag in dealing with it. Not in tunnelling that I'm aware of. There is that jurisdictional issue between them and Comcare, and who would be responsible, given that there is one tunnelling employer that does a lot of tunnelling who has a Comcare licence.
Okay.
Can I take you into the submissions? I think both of your submissions raised the issue of, I guess, jurisdictional conflict between Comcare, so Commonwealth and state, and when you've got different workers. Is there opportunity, is there room, would it be desirable if, for example, Comcare took responsibility for all workers on the one site, or that's not possible?
That would not be our preference.
And we wouldn't.
Okay, because
It's not a very good scheme.
First of all, it's not a good scheme, but secondly, they're not resourced to do it.
Yeah.
So Safe Work already has limited resources. As I understand it, Comcare has a small team of tunnelling experts, but to get to every state to do this is just not something, I think maybe 7 at most. It's just not possible.
I don't think it was a scheme that was designed for that sort of environment either. It was a public sector coverage and probably largely office work based. So it's very limited in its resources, and you do, as was discussed, have multiple PCBUs who may not be covered by Comcare.
Our preference would definitely be for Safe Work because of the amount of subcontractors on the site. It would just make sense that this subcontractor's used to dealing with Safe Work. 95% of the PCBUs on this project would be under the state-based legislation. It's just that one half of the joint venture has a Comcare licence.
But is there any way, and I'm just thinking aloud here because it's not an area with which I'm particularly familiar, but is there any way then of that joint venture partner coming under Safe Work New South Wales, so there's one umbrella organisation looking after safety?
That would
be
certainly be what we would like, but
Okay.
that I don't believe is the key. I think that the benefit of having a Comcare licence is you're out of the New South Wales system. I think it's the same thing. Our employers are used to dealing with Safe Work. This employer is used to dealing with Comcare. If that was the case, it would be absolutely great. I think it is. Safe Work is in a much better, and I can't believe I'm saying this of all people, is in a much better position.
Don't worry, it's
to
only on
be-
hand, so we won't be repeated.
Well, they're in a much better position to be dealing with this issue than Comcare, and it would be our preference that Safe Work takes the lead and reports to Comcare on what they've been doing. I don't know what the memorandum of understanding is between the two agencies at the moment, but that's how we would like it, to keep that relationship, New South Wales employers dealing with the New South Wales regulator.
So is it just an administrative issue with some people reporting to one regulator and others reporting to another, or does it impact on the safety of workers?
It could potentially, but I don't believe that's the main barrier. I mean, Safe Work could go in there tomorrow and enforce safety if they chose to. There are enough subcontractors in those projects that are covered by Safe Work for Safe Work to walk in the door and say, measure the levels of dust and say, this isn't appropriate and you need to fix this. So, it's not an ideal situation having the two regulators, but I think it isn't our main issue of concern, if I'm correct. It's
A little bit more transparency about how the two of them are operating in conjunction would be good, because we already have delays with responses to notifiable incidents. If the person is notifying the wrong entity, how quickly does the inspector come out? if the Comcare, given they've only got a small team, if the Comcare inspector's not available, does that then fall to safe work, or are we waiting 3 days for Comcare to come out? I think that's why I put it in my submission. It just would be nice to have a little bit more transparency around how they work together in the tunnelling environment, because not all tunnels have that particular PCBU. We've got others. Obviously, the Snowy Hydro Tunnel doesn't. It's a safe work project, and there are other ones in which that PCBU is not involved. Given it is a New South Wales problem, the New South Wales regulators should be dealing with it.
So if I can summarise, it's a federal issue. We're used to dealing with these, but it doesn't directly impact on safety of workers. So it's a second order issue.
Yeah, I'd say that's probably correct, yeah.
Yeah, okay, thank you.
Could I just pick up on another aspect that's come out in a lot of the submissions, is the realities of workers after they've been diagnosed, then leaving the environments that they are, continuing to be exposed in. So the realities of these relatively well-paid workers not then doing what is best for their health because they sort of can't be returned to another well-paid position. Can you just talk us around that sort of it's a bit counterintuitive. You would think that there would be encouragement under the scheme.
People are reluctant to come forward and get tested to begin with because they don't want to know, because if they do know, well, it's a terrifying thing to have a disease like that for a start, but it also will end their career. So it's a twofold sort of situation where I don't really want to face the fact that I might have a disease that's going to kill me, and I won't have an income as well. So it's not often until that worker has to come and go or has to get tested because they can't breathe and the symptoms are quite to have reached such a point that they can't ignore it anymore. That's my understanding, and I think we had a similar situation probably still do in the manufactured stone industry, where we had workers who just didn't want to know because it would end their career. We have to have a system that can move people, as Ms Haywood said, into meaningful, well-paid work, and can assist them in training, education, whatever it is that they need to do that. Obviously, we want to prevent them in the first place from getting these illnesses and diseases, but we also have to make sure that we move them into work that is safe for them, but is meaningful and also well-paid. If they've been, in a well-paid industry, they shouldn't have to go and work in something that's not well-paid, and they've obviously developed skills in that industry that are required for that industry that give them that pay. So why should they be punished on another level?
I think I struggle to convince my workers to make a workers' comp claim, let alone a dust diseases claim, because of the financial hit they're taking even in workers' comp space. To know that you're going to be paid maybe a quarter of your wage, that sits over people. And I get a lot of phone calls where people are trying to decide whether or not they're going to make a claim. And no matter how many times you tell them it's about your family, it's about your health into the future, it's about being there for your kids and your grandkids, the system will take care of you in terms of your medical support. At the end of the day, it comes down to money. I can't pay my mortgage if I go and claim for a dust disease. And then it is that issue of, well, what do I do next? Unfortunately, when we do vocational assessments in this state, we have a work capacity sort of ideal about it. Instead of dealing with a dust worker, we're dealing with them as a generic workers' comp claim. And so any job is a job. Rather than being, what if I get training in this, I might be able to pick up a job that's similarly skilled any job's a good job. So you see people with these high level skills who could probably go off and do engineering or something in different industries, maintain their income level, being sent to be courier drivers.
Courier driving is a very popular thing, it seems, in the workers' comp scheme, and it's ridiculous because courier driving is a very physical job where you're jumping on and off a truck, but that seems to be the go-to job. I've heard it time and time again. You can go and drive a truck and deliver, packages. It's not a job that someone who's had a dust disease should or could do, and it's not a highly skilled job. And as Sherry said, a lot of these people could be trained into engineering and other such fields, but that does cost more money.
And the problem we've got is the workers' compensation legislation allows CIRA to set up programs, and I think I've got a table in my submissions about all the different programs CIRA has available. And while Dust Diseases Care has been doing a good job on an ad hoc basis on getting people rehabilitation and looking at retraining options, we need something more stable. We need something that's more certain, so that every worker knows what it is that they can be requesting. And we do need to be looking at, well, okay, this person is highly skilled. What else can they do? What other training can they have? They've got a long work career ahead of them if we just get them in the right space. But unfortunately, and this isn't everybody, but a lot of vocational assessments come back with just the bare minimum. And I do wish in both spaces, even though this isn't about workers' comp, but that we look a little bit more about, okay, it's not that person's fault they're injured, it's not that person's fault that they've got a dust disease. We're robbing them of what they feel is a meaningful career and sending them off to do something they don't want to do, they've never wanted to do. I've got all these skills, why can't I get a skilled job? But at the same time, while they are getting that retraining, they need to be properly supported financially. I don't know whether or not the scheme, and this is not me thinking anyway, I'm just saying I don't know if the scheme can support a new PRW system or a new weekly benefit system, but I think we should absolutely be investigating whether that's an option and how we can go about it, because at the moment it's fine if you're at 60 and you're being paid, well, it's not fine, but there's a big difference between being 65, your kids have grown up, they've left home, and you're being paid $590 a week, and being 33 and your kids are just starting school and you're being paid $590 a week.
Could I just jump back to the CompCare matter? And Ms Flores, in Unions New South Wales submission on page 4, could I just take you to that, please? You probably got it in front of you. If you haven't, it doesn't matter, but
I do somewhere.
just
yes.
halfway down, just over at about point 7 on page number 4, there's a paragraph that commences
Okay, yes.
many of the current projects. Do you have
Oh,
that
yes,
paragraph?
yes,
Yeah.
yes, the John Holland
So,
projects.
yes,
Yes,
so
yes.
many of the current projects are
Yes.
run by John Holland.
Yep.
John Holland holds a CompCare licence, so SafeWorks jurisdiction does not extend to these projects. Just want to elucidate on this, because in terms of, and I don't speak for other members, but helpful to sort of try and understand that, do we have multiple, if we take New South Wales, state New South Wales and its laws and regulations and what the state government could or couldn't do in terms of those matters, and the agencies, relevant agencies. You've got CompCare and you've got John Holland with its licence. I'm trying to work out, does and forgive me, I should know this probably, but does this licence cover the field or cover a large field which sort of overlaps the whole area of occupational health and safety, or is it just butting up against New South Wales, if I could. I know it's a
I
very
think it's
sort of awkward way of
butting.
describing
Yeah, I
it.
know what
Yeah.
you mean. I think that you're right in that it's sort of butting up against. You've got the two sitting alongside each other. So John Holland, they would employ people directly, and that those people would be covered under that scheme.
Yeah.
Then you've got contractor, subcontractor. They may be covered under safe work. So there is a sort of sitting alongside each other.
So it's
and
almost
it's
parallel.
not ideal.
No,
it's
no.
not
This is
ideal.
what I'm trying to understand
Yeah.
from the point of view of trying
Yeah.
to come to terms with how this might be dealt with.
And look, as we'll be quite frank, unions, and again, I'm surprised that we're saying it, but we'd be life would be easier if we did have everyone under safe work, because it is the New South Wales scheme, and we're not generally great fans of Comcare. So,
And if I can just add to that, often these tunnelling projects are joint ventures. So John Holland will have its Comcare licence, and whoever its joint venture partner is would have a safe work licence. And the question becomes, who is the primary entity in the joint venture? And that's not always super clear. So that's why having more clarity about how the two agencies are working together can only assist workers in who do I call if this is a problem.
and we know that the
Just
WA.
jump in on this. So
Yeah,
how does
sorry.
it work? John Holland, the Comcare licence surely only applies to John Holland's employees.
Yeah,
Yes.
this is
Its direct
something.
employees would be
Yes.
tiny in terms of the
Yes.
overall
Yeah.
employment in a project.
Yes, but because they have the Comcare license, the the Safety and Rehabilitation Act is the act that governs the Comcare arrangement.
Sorry, could you please repeat that?
It's the Safety and Rehabilitation Act.
Piece of
I may
Commonwealth
have
legislation.
somewhere
Yep.
around
Yep.
those.
No, that's fine. Yep.
Yep.
And what happens is, because John Holland has the license and they have the Comcare scheme, they automatically had their safety regulator becomes Comcare. So it's all connected together, because like with a self-insurance license in New South Wales,
Yeah.
safety is an important factor in getting your Comcare license.
Yeah.
And they connect together. So that's why it would apply to them. So their workers' comp is just their direct employees. Their safety actions are Comcare. How that works with the joint venture partner, I'm still trying to figure out, and it's
And-
been all these years.
And we
Presumably
have
there'd
a
be
work-
some other corporate entity that would undertake the joint venture, and it wouldn't have a Comcare license.
Except that that's not how it's been working in practice. So I think that needs to be drilled down a little bit. It's not very clear to me how they operate that way.
I mean, the Work Health Safety Act of New South Wales does require all PCBUs to work together, and it doesn't say, well, that doesn't include a Comcare PCBU. So you could say, well, the Work Health Safety Act does require joint work, but again, that's not very clear. It doesn't really tell us what to do in this situation.
I mean, in some sense, this is a wicked problem in that you've got, like the construction industry, you've got the structure, which I won't say always, but perhaps always, nearly always, has this economic imperative that sort of makes the sort of structure work and be probably most beneficial for the actual body that's sort of been given the job of completing the project, if we sort of put it that way. But this is sort of a very unusual industry in that it's not as if it's in any sense of free market. There's certainly one, but maybe a very small handful of entities that are capable of even tendering for such projects with the capacity to deliver them. And even as you've described, manifests in joint projects that it just seems that it almost is inviting that there be a big nudge, dare I say, by the government of the day, and let's just forget politics and say any government of the day, whoever's in power, to say to these large companies, and this might sound a little bit naive, that listen, there's been a whole lot of stuff going on in here over a long period of time, and it's just not up to scratch. And either get your act together and perhaps have a period of time to sort of work through what I'm not denying are a myriad of issues, or that, you know, that'll force us to come in and you know, regulate formally. And maybe they jump to the regulation straight up. I mean, I'm not forecasting what the government may or may not do, but you know, this is just ripe for ducking and weaving. And much of the evidence this morning has been describing your frustration of the ducking and weaving.
Some of my colleagues have suggested that that might be why some companies do take out Comcare insurance.
Well,
And
yeah,
I'm-
I mean, one can be a cynic, and in terms of the whole economics of it, I suppose in terms of the detailed, fine, granular analysis of costings, that may well figure into the into the consideration. I mean, I don't know that. I'm speculating, but at the end of the day, and either way, it's still not addressing what are not insignificant issues which are staring us in the face.
I mean, there's definitely a role for government, particularly where there's government funding involved.
Well, that's the other point to
Yeah.
this, isn't it?
Yeah.
These are
Government projects.
multi-billion-dollar
Yes.
contracts.
Yes.
Multi-billion-dollar contracts.
And that's a whole discussion about procurement, but absolutely these
Yeah.
things should be worked into the contracts. Yeah, okay, the Work Health and Safety Act says you should do air monitoring if you think there's a serious risk to workers, and it's up to you to determine what that serious risk is. What you could put into the contracts is air monitoring is mandatory on all New South Wales government projects.
Yeah.
And needs to be reported back.
Yeah.
Correct.
Instead of having these sort of
Not just
almost
monitored.
buts or maybes in there, which sort of are in effect
What do you do?
a way which
A way
one
out.
path can be the least form of resistance versus one that it might be considered resistance, and therefore we're not going to take it. I mean, I suppose I'm thinking out loud, but there seems to be some obvious things that could be done. Just conscious we've got 5 minutes left. I don't know if any of the members have any final.
I was just going to
Yeah,
ask
go.
about that point on the procuring agencies. Do we know if there are any conditions put in these agreements with these contractors that oblige them to do better than what they're doing?
I do know there's been consultation on the procurement policies under this government. We have not been involved for some time for reasons.
Is there any impediment to the state government I mean, all these projects are state government procurement projects, stipulating that they have to be within the New South Wales, like they can't be, the entity that undertakes the project can't be a Comcare licence holder?
I think you're going to have a competition problem if you do that. The ACCC might knock on your door.
Yeah. Well, it's probably perhaps the case, but nevertheless worth giving a bit of thought to.
Thank you.
I mean, making these as conditions. I mean, given that, you know, there is pretty good evidence over a period of time about the threats, I'll use the word threats deliberately, threats and the impact of Chris's silicon dust impact on workers, be it manufactured stone or the manifestation now in the tunnelling work, that whoever's writing the contract has almost a vested interest to ensure, particularly the impact of what might be over time, a long period of time, not just years but decades, to be doing a lot more through that contractual process to set in, to wedge in very clear standards.
I mean, if I think back to when I did torts, I think the New South Wales government should absolutely think about what it's doing about it, because if you're aware of the issue and you're not doing enough to fix the issue, you could have a negligence problem.
Yeah, they're all.
Can I just jump in? One last question. Just on that ACCC point, have either of you got any experience of authorisations being sought for conditions of that type on a public benefit outweighing any anti-competitive effect approach?
No,
No,
it's
I
just,
don't.
Okay, because I think that's an avenue that could be explored.
yeah.
Well, if there's no more questions, can I thank you most sincerely? I think the submissions were good, but I've got to tell you, the oral evidence is very rich and detailed.
Thank you.
Both,
Thank you.
Very knowledgeable, and I appreciate the work you've done over a long period of time as the specific union and as the peaking body in the state, because I went back and looked at previous reports and names keep coming up of people giving evidence, and it must be a source of great, well, probably more than frustration, deep frustration, that these issues seem to take so long to get
They do.
resolution in the sense of law and regulation, which sort of is going to mitigate as far as practicable the
I
effect
think
of
frustration would be putting it mildly.
No.
But the
You've been
committee
very,
does-
very measured and considered, but very thorough in your evidence today. So
But
thank
on
you.
that, the committee does do good work, so for that we thank
Well,
you.
thank you, and
you know.
we'll. And I think there was probably, I didn't hear any questions on notice being taken, but there may well be supplementary questions arising from the evidence once members have a chance to read Hansard. So
Very happy
be
to help
open
where we
taking
can.
them into account, and the Secretary will liaise with you. Once again, thank you very much,
Thank
and
you.
appreciate all the work
Thank
you're
you.
doing. Thank you. Okay, well, we're on track. Got 2 minutes off. If
Let's
you want to
take a break. If
Oh,
that's
what,
possible.
take a break, so I know what that means. So, being a yeah, short break, but we've got our future witnesses or next witnesses, so people just stretch their legs. So, yeah. Slowly, and by that time the members should have got back. Back, so that's fine. So we just don't want to hold people up. So swear you in, and then we can move on to the next part of it. So thank you both for making yourself available to come along today. So what I'll do, starting from my left, Ms. Cole, then moving across to Ms. Donovan, ask you to state your name, your position, title. For the purpose of this particular piece of evidence today, particularly with respect to Mrs. Cole, who's appearing this afternoon with a different hat on, and then swear either an oath or an affirmation, whichever you prefer, the words of which should be before you. So we'll start with Mrs. Cole.
I'm Kate Cole. I'm a PhD researcher at the University of Sydney. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And Mr. Donovan.
My name's Chris Donovan. I'm the Assistant National Secretary at the Australian Workers' Union. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. So I commence by, once again, thanking you both for coming along, acknowledging your respective submissions, and noting, of course, Ms. Cole, you've got 2 submissions for the different hats you're wearing today, if we could use that description. So Ms. Donovan, for the purpose of the AWU's submission, it's submission 14 being processed by the committee, uploaded onto the website for this inquiry and forms formal evidence to this inquiry. And Mrs. Common, yours is number 6, and that's been processed by the committee, been uploaded, and will also form formal evidence for the inquiry, in addition to what obviously you're going to provide now orally, and what may be questions or notice and supplementary questions that could arise. So perhaps if I commence by inviting you both to make an opening statement, just in terms of recognition of the parties at the table, so that the union is here in its capacity, and Ms. Donovan is the National Assistant Secretary, and Mrs. Cole. Should I be sort of together as working as one and the other, working co-jointly? How should it be really it's Australian Workers Union and Mrs. Cole as part of some formal project, or how best should we see this?
I think separately.
Separately, but of mutual interest on this particular matter, and obviously working co-jointly on some aspects of it. Okay, well that's okay. So if we start with you, Mr. Donovan, you'd like to make an open subject, and then we'll go to Mrs. Cole.
Sure, thank you. I welcome the opportunity to give evidence to the Standing Committee on Law and Justice as part of the 2024 review, the Dust Diseases Scheme. The AWU represents members across a diverse range of industries, among these tunnelling, quarrying, cement work, mining, civil construction workers face the greatest risk from dust exposure and dust-related diseases. As the union that represents tunnel workers across the country, the AWU is particularly concerned about the risk faced by these workers. Today I'd like to use my opening statement to focus specifically on the experiences and risks of tunnel workers. As this committee knows, the past decade has seen a surge in tunnelling projects across the country, particularly in Sydney. Thousands of workers are responsible for constructing the tunnels that countless number of commuters now use and will use. It is undeniable that these workers have been exposed to respirable crystalline silica, a carcinogen. A carcinogen is defined as a substance, organism or agent capable of causing cancer. Recent reporting in the Sydney Morning Herald has highlighted that the AWU uncovered thousands of silica dust monitoring records held by Transport for New South Wales. This data pertains to Sydney's tunnelling projects. I want to clarify a few key points for the benefit of this committee. Number 1, the AWU utilised the Government Information Public Access Act to request silica dust monitoring data held by Transport for New South Wales. As a result, Transport for New South Wales provided data from projects using tunnel boring machines. Tunnel boring machines generate less dust compared to road headers. The data revealed that 1 in 3 air quality tests exceeded the legal safety limit, with some tests exceeding the limit by up to 208 times. While this data is deeply concerning, Transport for New South Wales should be commended for its transparency in releasing the information. Number 2, the AWU also submitted a GIPA request to Safe Work New South Wales to obtain silica dust monitoring data from projects utilising road headers, projects such as North Connects, West Connects, M6 Stage 1, Western Harbour Tunnel, for example. Road headers are known to produce significantly more dust than tunnel boring machines. Unfortunately, Safe Work New South Wales refused to release the data, in part due to concerns raised by contractors CPB and John Holland that argued that releasing the data would damage their public reputations. The AWU submission called for the use of Standing Order 52 and SO 52 to compel the release of this data. And as this committee is aware, the SO 52 motion passed in the upper house last week thanks to Mark Benaziac MLC. This refusal to release this data underscores a critical failure of our state safety regulator. It is unacceptable that Safe Work New South Wales, an organisation charged with protecting worker health and safety, would prioritise the reputations of corporations over the health of workers. This lack of transparency is deeply troubling and directly undermines efforts to assess and mitigate the risks faced by tunnel workers. The data Safe Work New South Wales is withholding is essential for understanding the extent of silica exposure and the number of workers who may develop a silica disease or a silica-related disease in the coming years. This is a matter of profound importance to the dust diseases scheme, which exists to support workers impacted by these preventable diseases. The AWU urges this committee to consider the critical need for transparency and accountability in safeguarding workers' health. The information currently withheld by Safe Work New South Wales must be made available to fully understand and address the risks faced by our tunnelling workforce. I thank the committee.
Thank you. I've got an immediate question, but perhaps let Mrs. Cole give her opening statement. Yep.
Well, I'd like to first acknowledge the traditional owners of the land that we're meeting on today and pay my respects to elders past, present and emerging. Thank you for the opportunity to give evidence at this very important review. I am a Winston Churchill Fellow, a consultant occupational hygienist, and I've worked in the construction and tunnelling industry for decades. This morning, though, I'm here solely in my capacity as a PhD researcher at the University of Sydney, where I'm undertaking my PhD under the supervision of Professor Tim Driscoll on the topic of respirable crystalline silica exposures to tunnel construction workers. The majority of all tunnelling in Australia happens here in New South Wales. Sydney has the highest amount of crystalline silica in the rock that we tunnel into in comparison to anywhere else in the country. And so while every tunnel worker is at risk, tunnel workers in New South Wales are at the highest risk. The most prevalent work-related disease reported in tunnel workers globally is silicosis, and the main factor that determines the risk of developing silicosis is cumulative exposure to respirable crystalline silica dust. Over the past year, I have been applying to access silica dust in air data from tunnel projects for the purposes of research through Freedom of Information requests and through direct requests to stakeholders who also hold this information. And I have received silica dust in air data from New South Wales tunnel projects. That information demonstrates that tunnel workers were exposed to silica dust at very high concentrations. Exposures were higher than have been reported from engineered stone workers, and those tunnel workers were not protected by the use of masks, and therefore they breathed in a very large amount of respirable crystalline silica dust. Most concerningly, the size of the tunnelling industry is much larger than the size of the engineered stone sector. Based on the information that I have received, the New South Wales Government should expect a large number of cases of both silicosis and lung cancer as a result of building our infrastructure. The initial recommendations that I have for the committee are to significantly increase prevention efforts by Safe Work New South Wales, and that we need active case finding, a targeted case finding program for anyone that has worked in tunnel construction. With those opening remarks, I thank you again for the opportunity to be here and to take any questions.
Thank you very much. We'll move the questions around. There's representatives on the committee from government, crossbench and opposition. Do that shortly, but Mr. Donovan, just going back to your opening statement, if I understood correctly, you're saying that Safe Work, or you believe that Safe Work currently has some information in its possession which you're looking to seek access to enhance the work you're doing on this particular issue. But that's not the complete picture, is it not? Because is there not, I mean, we don't know what we don't know. So in terms of the PCBUs and sort of the subcontractors operate doing this work, would some of this information be domiciled inside those respective organisations, and Safe Work don't have it? So you need that as well, if we sort of use the vernacular, to sort of complete the picture of what's going on in the tunnelling industry?
Yeah, really good question. I understand that Safe Work New South Wales doesn't have all of the information from every single subcontractor or company that's operated in the tunnelling space. Right. But what we do know is that they do hold a significant amount of information from some of the key contractors from major projects such as WestConnex, NorthConnex, M6 Stage 1 and others. And so it's not the full story. So Safe Work New South Wales don't hold all of the information.
And just one final question before I pass on. With respect to the collection, storage and analysis, such as it might be with respect to information collected about monitoring, Are you in a position to give us some explanation or insights into what is required? Or is that too much of a long explanation and we perhaps should put that one on notice? In other words, what are the obligations in general terms for the collection of this information?
The collection from Safe Work New South Wales? do you mean?
With respect to a tunnelling project, pick any one if you like, to look down at that project and say, what is the obligation that legally operated for the collection of information around dust, silicon dust on that project, over its extended project completion, from start to finish?
Yeah, that's right. So I can point you to the New South Wales WHS regulations 49 and 50, which call for which are a requirement for companies to undertake dust monitoring.
A requirement.
Yes, they must undertake dust monitoring if they believe it's a high risk environment.
Right.
And they must do that. But the problem with that certain provision is it sort of stops there. It doesn't sort of detail how often the monitoring requirements should be.
Right.
It doesn't detail any further information around how the company should go about conducting it. And the problem is, what we find is, and what I've found throughout this entire process is, the companies are ticking the box of, we've done section 49 and 50, we've monitored, but really what they're doing is they're only conducting monitoring once a month.
Right.
And when they do conduct that monitoring, it's a type of monitoring called gravimetric testing. So that's sort of, there's a bit of an apparatus attached to a worker, and they go around for the day and it's monitored, right, because it's in the breathing zone. Yeah. And so what they do is they go and do that once a month on any one particular day or a couple of days, and they get back information. But the problem with that, again, is it takes about 2 weeks to get that data back. So while a worker might be exposed to a toxic dust, they won't actually know until 2 weeks, which doesn't leave any sort of time for the company to react quickly to changes.
Looking in the rearview mirror,
Yeah.
What
Chris Rouse,
what reason was given to you by Safe Work New South Wales for why they don't want to publish this information? Obviously, you've done your freedom of information, your GIPA, you've requested the SO52, which we've now done through our chamber. But what was the reason or the hesitancy from Safe Work to provide the information that you're looking for?
They provided a few different reasons, but one of the reasons was the companies, CPB and John Holland, had stated that releasing the data will adversely impact upon their reputation in the general public forum, including because it is reasonable to expect that the reports will lead to adverse media coverage in respect to the management of respirable crystalline silica dust. So that's what CPB and John Holland said. There were other companies as well that we tried to seek information from, such as Acciona and I think Samsung was a company. They did not object to the release of information.
Can I just clarify that point, though, because my understanding is under the data that Safe Work had obtained was under notice, and because of that, they are restricted under the legislation that they got the data under from providing it to anybody else unless there is approval from the companies involved. And I absolutely take your point that then we hear back from these companies that they no thanks, because it might adversely reflect on us, which is terrible. But do you accept that position that Safe Work had no option because they were obliged under the law to only release the information if they had permission from the companies?
Well, a really good question. I'm not a lawyer, but I could just point you to Transport for New South Wales releasing practically the same kind of information. So I don't know what the standard is in relation to what these departments can and cannot release, but Transport for New South Wales released the information.
This was because the air monitoring data that Safe Work holds, they hold because they had issued a notice to get that data, and because of that, under the Act, they're then restricted from releasing it unless they get permission.
Mrs. Cole might have some insight.
Yeah.
Maybe I can provide some insight because I have been applying for freedom of information, requesting information from different work health and safety regulators across the country. So I did apply for access to Comcare as well, because as the committee has heard, Comcare regulate at least one tunnelling contractor in the state of New South Wales. So I applied to access silica dust and air data through Comcare, who also obtained the information under notice, and Comcare granted me that information.
So, and that's really interesting because that clearly then there's a different legislation applying to Comcare than there is to New South Wales. So should we be changing our provisions to allow Safe Work to release this sort of information?
Well, potentially, but the heart of it comes down to the decision maker within that government department, their decision as to whether it's in the public interest to release that information. And obviously, the decision maker will consider a range of factors and apply weight to those factors. And those factors and the weighting applied are not consistent across the jurisdictions in Australia. So as Mr Donovan has said, one of those factors was the reputational impact of the contractor, and that was considered, and in Safe Work New South Wales's case, it was given, I think it was moderate weight, so it was actually given a weighting by Safe Work New South Wales in their public interest text. But that weighting was not applied within Comcare.
Yeah, because I read the GIPA response and I had a similar view, and I was like, what's going on here? But then when I asked further questions about it in the context of the SO52, I was told actually it's a bit misleading the way it's written because they're just not allowed under the law. If that's not the case, then we can ask them this afternoon. But I'm trying to get to the point where it seems ridiculous to me that we don't have a regulator that can just get this information and then make it public. And if that's because of the way that our laws are drafted, then perhaps we need to change them.
Yeah, it could have unintended consequences.
Agreed.
So who would like to go? Honourable Susan Carter, perhaps start with you. Yep.
Thank you. Thank you both for being here. If I could ask perhaps a hypothetical question, not asking you to draw on your own particular experience of anywhere you've been. So occupational hygienists have access to the monitoring data that companies acquire. What then typically would an occupational hygienist do with that data?
I can answer that, being an occupational hygienist. So occupational hygienists that work for tunnelling contractors, or indeed most businesses, are bound by confidentiality agreements. So we must not talk about our engagement, the levels of silica dust in air that we monitor, or indeed anything with the results, because we work for the PCBU. So the occupational hygienist attends site on a day that's directed by the contractor, to work fronts that are directed by the contractor, to collect data for workers that are provided to us by the contractor. We then collect that, put pumps on workers and collect the samples. It does come back about 2 weeks later, and then a report is provided to the contractor with the results of the air monitoring. Occupational hygienists will have the air monitoring reports, but we are prohibited from doing anything with those reports other than providing it back to the tunnelling contractor.
But those air monitoring reports would have recommendations as to safe and unsafe levels of exposure?
Absolutely. So those reports will go through the types of workers, the work activities that people were performing. It will explain if the level of silica dust in relation to the workplace exposure standard and if that has been breached or not. And it will include a series of, most importantly, safety control measures that need to be implemented or recommended to be implemented short term and long term.
So the PCBU would receive a report with an indication that there had been unsafe levels and an indication of what safety measures need to be taken.
Correct.
And then is that report available to another occupational hygienist who might come in, let's say, 1 month's time, 2 months' time, to check whether the levels have been breached again?
The scope of work of an occupational hygienist is determined by the contractor. And the information that's provided to the occupational hygienist is determined by the contractor. So occupational hygienists typically don't have the ability to go and access additional information, can request it, but may not be provided. Typically it's the same hygienist that will go to the site each time, but if recommendations are not acted upon, they have no authority or jurisdiction or influence in that regard.
So is there any mechanism to check whether recommendations which have been made with respect to safety have been acted on by the contractor?
Visually, sometimes, yes. So if we're going back to the same workplace, and a previous recommendation may have been around improvements to ventilation or improvements to dust suppression, then you could visually observe if those improvements had been made.
And what options does an occupational hygienist have if no action's taken in respect of the recommendations?
Very little. Can raise it to their client, the tunnelling contractor. As I said, bound by confidentiality provisions which restrict an occupational hygienist from talking about the specific workplace conditions any further.
And what, if any, is the mechanism to make sure that the information gathered as part of the monitoring process is actually acted upon for worker safety?
That is the responsibility of the tunnelling contractor.
And if the tunnelling contractor does not act on that?
That's why we need improved intervention by Safe Work New South Wales in this sector.
Because would that give rise, I mean, action after the event is not desirable in this circumstance, but would that give rise to negligence actions in respect of the employer because if they knew of a risk and they failed to act to address that risk?
Potentially.
Okay, thank you.
Is the hygienist liable as well? I mean, do you have any advice about your own exposure in the event that you've been providing advice that's knowingly ignored and you continue to engage and provide that advice?
In my experience, the occupational hygienists that I know, that I am familiar with, that work in tunnelling, work incredibly hard to do everything within their power and within their realm of influence to make a positive change on every single project that they work on. It can be challenging on some sites, and on other sites it can be less challenging because you have an engaged contractor that prioritises worker health and really does go above and beyond to try to put the right control measures in place. But if we're talking about tunnelling, I will say it's inconsistent. So it's not as though every workplace will be abhorrent or every workplace will be great. There is huge inconsistencies, and that brings about the challenge when this is a very large industry. Occupational hygienists are engaged to do air monitoring, to provide advice on control recommendations, maybe to run an occupational hygiene program that doesn't just include looking at the risks of dust diseases, but also welding fume, diesel particulate, occupational noise, thermal heat stress, other hazards as well. And in my experience, are working very hard. But ultimately, the onus to protect workers, to create a safe work environment, so far as is reasonably practicable, with all the right control measures, is the responsibility of the PCBU.
And what about whistleblower protection?
Yeah, it's a good question. I haven't had any experience in that. I can't answer it.
Can I just one follow-up? If somebody was to be a whistleblower, they would blow the whistle to Safe Work, or where would they blow the whistle to?
Hypothetically.
Yeah. Safe Work.
Probably Safe Work? I don't know.
Probably Safe Work, I guess, yeah.
Thank you.
Honourable Rod Roberts.
Where it would be
Thank
hidden
you,
away forever.
Chair.
Sorry, just what was that last bit?
Oh, no, it's just a smart alecky comment. I said where it would be hidden away forever and no one could ever find it.
Okay.
Smart aleck, or perhaps quite.
You might
true.
suggest Australian Workers Union as a place where the information could be.
We would love to receive information from hygienists that want to listen to it. Yes.
Yeah.
Thank you, Chair. Mr. Donovan, in your opening remarks here, you talked about obtaining from Transport for New South Wales under the GIPA process air quality monitoring reports, and that those reports showed a number of high exposure rates. To your knowledge, has Safe Work investigated those clear breaches that have been recorded?
No, not to my knowledge.
Okay. And I'll certainly ask them this afternoon, but I just wanted to know from you. Now, I stand to be corrected here. I'm somewhere in the evidence from either Mrs. Flores or Ms. Hayward earlier this morning. There was some mention of some photos that had been taken in tunnelling process that was showed to a previous minister. And I think my interpretation was that perhaps you had those photos at some stage. Is that correct?
Yeah, I believe those are the photos that were held by a former tunnelling organiser in the New South Wales branch, yes.
I'm wondering, is it possible on notice if we can actually get those photos, if they could be tabled and presented to us as an inquiry?
Certainly.
Because they sounded from the evidence that they were quite
revealing, yeah.
Yeah, horrific, if I can use that as an example of how much dust there was. So to us as the common man that has no experience in tunnelling, I think it would be very helpful to us if we were to obtain those photos. So can I leave you to take that on notice?
Certainly, I'm more than happy to do that, and I can send you more than just photos. I can send you videos of some very shocking scenes that are taking place in the tunnels.
Well, we're unaware of that, but now you've brought that to our attention. I think we could get those too. Could we, Chair?
No, I think so, and perhaps the Secretariat will get through the Secretariat liaising with you after the hearing over what might be in your sort of content of possible pieces of additional evidence. So, yeah. Sorry,
Great,
please
thank you.
continue.
Yeah, and just one final question while on this line at the moment. Page 5 of your submission, Mr. Donovan, the last paragraph, talks about workplace entry permits, etc., and we talk about there being no explicit right to take measurements or record information and stuff like that. I find that, as somebody that's come from an investigative background, a complete anomaly that work health and safety officers can't take measurements, record dust, for example, take photos, etc., etc. Would it be your opinion and your evidence that that needs to be changed in legislation?
Yes, it certainly is, and I think I do touch on that for a further recommendation in my submission. What the current situation is that if a union official who is a registered permit holder under the WHS Act seeks to conduct a safety visit at a work site for which they need a reasonable suspicion that there is a breach of the Act, they can't just willy-nilly go and do it. There has to be a reasonable suspicion. Their powers are to basically investigate what is the suspicion. Now, it has been the case that because the powers under the Act do not allow for the permit holder to take videos, take photos, take measurements, so measure levels of dust exposure. It might not even be dust, right? It could just be temperature. We just be going in there measuring the temperature, anything, sound, whatever noise, is that those provisions are not currently in the WHS Act, and they certainly should be, because it is a lot of the time that the union's actually going in and doing the job of Safe Work New South Wales, or at least collecting evidence to provide to Safe Work New South Wales to say that there was a breach here. And this isn't a radical thing. This already exists in South Australia and Queensland. And it is unfortunately the case that many permit holders, at least in the AWU, have been denied access to site because they are seeking to conduct either or take photos or to conduct some sort of measurements. So it's something that we definitely need.
That's it for me at the moment, Chair. Thank you.
Thank you.
Applicable, yes, please.
I just wanted to ask then about, I guess we know that that this is a more concerning issue in New South Wales because of the geological aspects, etc. But in terms of what other states and their regulators are doing in relation to air monitoring more generally, are there other states doing it better? Are there things we can learn from other jurisdictions that we should be sort of importing here?
Yeah, that's a good question. I might have to take it on notice. I think it's pretty poor across the. If you're looking at tunnelling, then it's pretty poor across the board, and it is the case that in New South Wales it is a very dangerous situation because of the earth that we're tunnelling into. That doesn't mean we should be taking anything away from the other states. It's still extremely dangerous as well. Dangerous work in the first place, and dangerous because of the dust. But I'm happy to take that on notice.
Yeah, thank you. And I guess I'm interested in, and I don't know, apologies, Mrs. Cole, if this is a question I should be asking in the later session, but I'm interested in the exposure of workers, not just at the, and again, I'm not an expert in tunnelling, so I'm not quite sure about the terminology, but obviously there are those workers who are using the machinery at the front. But I understand there's also, people in trucks and other things. How is the exposure different for those types of workers, and is there an understanding that across the board there is that exposure?
Yeah, so different tunnelling methods result in different levels of risk of dust diseases to workers. Arguably, the use of tunnel boring machines, which is the primary tunnelling method actually used on Sydney Metro, is the lowest risk. And using road headers or mine tunnels, this is what it's called mine tunnelling, is the highest risk, as is drill and blast, which is used on, say, Snowy 2.0 or Coffs Harbour Bypass. So mine tunnelling, yes, it's a very large risk at the front, the face of the tunnel, because there's a lot of dust that's being generated. And to capture that dust, tunnel contractors will use sort of large filtration or extraction systems to capture that dust. But the efficacy of those extraction systems is reduced the larger the diameter of the tunnel. And we do have very large diameter tunnels in Sydney. North Connects is a great example, or a bad example. West Connects is a similar example. And so we know that those workers that are at the front, that are involved in mine tunnelling, were at the highest risk, hence the need, and I'm very grateful for the order for papers to get that information from those tunnel projects, because we're most concerned of workers in mine tunnels. But it's not just the workers at the face. When that dust is not adequately controlled at the front, it obviously then travels all the way back through the rest of the tunnel and puts other workers at risk. And, going through the information that's been obtained by GIPA, even though there were, a large number of samples or results from the City and Southwest project that were very high, it's very clear that those very high results are repeating again in very recent tunnel projects as well. So this issue has not gone away, unfortunately.
So when they do the air pollution monitoring, are they taking it at just at the front of the tunnel? Are they taking it further back? And is there a standard way to do that monitoring so that you can then compare?
Oh, sorry, I understand your question now. So we do air monitoring by assessing the amount of silica that a worker is exposed to. So it's actually fixed to workers, which is really important, because that's the only way that we can demonstrate, or a contractor could demonstrate, compliance with workplace exposure standards, because it must be collected in a worker's breathing zone. Now, occupational hygienists will collect samples of silica dust in the highest risk workers. So the ones closest to the face are the ones doing the most dustiest activities. So it's not a stationary point at the front or the back of the tunnel. A key gap that we have, though, is that even though air monitoring is required, particularly now we have the new crystalline silica regulations, which makes it a little bit clearer, even though arguably it was already law to do this. What we don't have is a code of practice or minimum frequencies of that air monitoring. So we have seen some large projects actually do a small amount of monitoring and not very frequently. And there is no standardised approach. Safe Work New South Wales in 2022 announced that they were going to review and revise the Tunnels Under Construction Code of Practice, and at the time they had said that that was incredibly urgent and they wanted to finalise that within 6 months.
Sorry, what date was that again?
In March 2022,
Right.
they announced.
Thank you.
And so unfortunately that hasn't progressed, and we don't have a Tunnels Under Construction Code of Practice, and it's that type of document that would go to that level of granularity around air monitoring, the type of air monitoring, the types of workers to be monitored, how frequent that monitoring would be conducted, how that monitoring is conducted. Because whilst, and just getting to your question, personal monitoring is really important, other types of monitoring, like real-time monitoring to supplement that monitoring, is also really important. And because that's not a legislative requirement, it's seen sometimes as a bit of an add-on or a nice to have without it being something that's done routinely. So that is a key gap that we have at the moment.
Because you'd think with today's technology you could have constant monitoring.
Yeah.
Correct.
Yeah, so you can use real-time dust monitoring. I will say that it supplements what we collect, because that real-time dust monitoring just helps us understand if we have a problem. And I think the committee heard in the previous session that when you can see workers in clouds of dust, you probably don't need a real-time dust monitor to know that you have a problem. But the challenge with silica dust is that it is invisible. So when you're underground and it looks clean, it may not actually be clean. So that real-time monitoring supplements the monitoring done every, month or week in real time to make real-time improvements.
And is it is it the case now, or at least I believe it is the case, that technology has evolved enough to actually do live testing for crystalline silica as well?
Right.
This was which is only a recent development, is my understanding.
Can I just press you further on that? I mean, are you able to point us in the right direction in terms of where we might be able to provide or obtain more details about that? Is that something you'd be able to, I notice?
I can probably answer.
Yeah, please.
So
Ms. Tom,
there is real-time, we call them respirable dust monitors, and that has been around for a long time. And respirable dust is the fraction of dust that crystalline silica is in. So that is used, quite a bit in tunnelling, not consistently. There is a device that's manufactured by Trolex in the UK that's marketed as a real-time silica detector, the accuracy of which has been questioned and is the subject of a review by the Office of the Chief Scientist in this state. So it would probably be appropriate for me to hold comment until the outcome of the review by the Office of the Chief Scientist. The challenge with that device, though, is that it's stationary.
Right.
And when you have a stationary device, people can put it somewhere where it's not dusty and think that it's okay. So that's why monitoring of workers is important, because it goes with the worker.
Chair, may I just...
Please.
To that regard then, and because I certainly don't know your role, Ms. Cole, as a occupational hygienist, the equipment that the worker wears, who provides that? You as a hygienist, or the employer, or the PCBU?
Are you referring to the masks?
You said, I think in your evidence, that it captures what the worker at the workplace, the air that they breathe.
Oh, yes.
That sort of equipment. Who provides that?
So the air monitoring equipment is provided by the occupational hygienist.
Right, okay.
And then the result or the report is, provided by the hygienist back to the tunnel contractor. And just to close the loop, Safe Work New South Wales then will go and obtain a copy of that if they are, maybe under notice or for other reasons. And sometimes also that is provided to the client, which is how the AWU has the data as well. So that's sort of the flow.
Now, I just wanted to know about the equipment itself. Who provided that? So you provide your own then?
So it's standardised to an Australian standard. There's a lot of requirements around it, so it will all look the same on every tunnel that you go to. The monitoring equipment, that's separate to sort of the respiratory protection and other controls, which is all provided by the contractor.
No, that's fine.
So how do you, because I understand that the data that's then produced, it has a discount on it to cover the effect of the PPE. How is that factor calculated, and is it going to be accurate?
Yeah, so great question. So there is an Australian standard that specifies a minimum protection factor for different types of respiratory protection. So for example, a P2 respirator, which you might call it like a paper dust mask, has a minimum protection factor of 10, and the powered air purifying respirators, the very large sort of hoods, would have a minimum protection factor of 50. So what can happen is that an occupational hygienist will collect a sample of air, from a worker, and we will do our best to observe that worker while they're doing their work activities. We will check if they've had a respirator fit test, if they're clean shaven in the case of a P2 respirator, and if that has been the case, then the level that the worker has breathed in would be reduced by a factor of 10. Equally, for a powered air purifying respirator, it would be reduced by a factor of 50. However, I must caution the committee in assuming that the reliance of masks or PPE is appropriate, because in the information that's been obtained by the AWU and shared, respirators or masks, at least on one project, were only found to be adequate around 70% of the time. So when you hear people say, but they're wearing masks or there's masks there, you have to understand that it's the lowest form of control. And so when we're making recommendations as hygienists, we're focusing primarily on ventilation, dust suppression, other higher order controls, because masks generally are not effective 100% of the time.
We're nearing the time. I've just got a couple of quick ones. I probably should have said this at the beginning. With respect to the submissions themselves, there were what might be described as attachments or the accompanying documents. So starting with you, Mr. Donovan, we had your submission 14, but then there's two what we're calling attachments which have been published as part of the submission. One's on Safe Work New South Wales letterhead, and it's a letter under the name of Deanna Bowling, Senior Coordinator, Right to Information, Safe Work New South Wales. And accompanying that is a very short, small type, but what might be described as an Excel spreadsheet type document with a lot of dense information. In regards to those two attachments, is there anything that you'd like to reflect on or comment on or draw to our attention that we perhaps should look at more closely, or just read them in conjunction with your overall submission?
Yeah, well, they are to be read in conjunction with the submission as further evidence of some of the claims that I make. And when you look at that data, and it is an Excel spreadsheet format as well, and you'll see, I think there's a few thousand records of monitoring data that's been collected. And what you see in there is, and this is in my report as well, is 1 in 3 of those were actually above the workplace exposure standard, and some of them were in excess of the workplace exposure standard by around 200 times. And look, I thought it was, on me to provide that data with my submission as evidence for it, rather than just simply relying on my
assertions,
word.
No, that's appreciate the explanation. And Mrs. Cole, with respect to your submission number 6, attached to it is a document which runs from page 5 of your submission through to 15 inclusive. Is there anything within those 10 pages that you'd like to particularly draw to our attention, or read that in conjunction with your submission overall?
The main thing I wanted to bring to the committee's attention is that there's evidence of very high exposures to tunnel workers to silica dust, and there is a lag between the time of exposure and the development of disease. And a lot of the data that's been released was collected between 2018 and 2020. So that's around 4 to 6 years ago.
Right.
And we typically see cases of chronic silicosis after 10 years of exposure. So when I talk about expecting waves of disease, please appreciate that the exposures that are happening now, or indeed 4 to 6 years ago, have actually mostly yet to be realised. That's not to take away from the many cases that already exist in tunnelling from projects prior to the recent infrastructure boom. And so I hope that provides evidence to the committee as to why active case finding is so important, because we only found the cases in engineered stone through active case finding, and no active case finding has occurred in the New South Wales tunnel construction industry. And until that occurs, we won't have an accurate understanding of just how big the current issue is. And thanks to, the order for papers, we will have a better indication of the future burden. But arguably, there is a lot of tunnel construction workers that are already at risk of being diagnosed with silicosis and lung cancer from building government projects.
Those workers, they're subject to health monitoring though, aren't they?
Yeah, so workers that are currently engaged in work that would be considered high-risk work should be receiving health monitoring on an annual basis. So workers that have left the tunnelling industry, and maybe they only worked in tunnelling for 1 or 2 years, and now they work in another industry that may not be considered at risk, do not receive ongoing health monitoring and assessment, but they like in some of the cases here, and particularly looking at road header operators, for example, the highest risk tasks,
Yeah.
these workers have received what we would consider more than a 10-year dose of silica in less than 1 year. So they have already been exposed to a very high concentration, thereby increasing their risk. If they're not in tunnelling anymore, or if the employer is not providing health monitoring, they're not getting any of that screening.
Well, on that very sobering note, I just draw this part of the hearing today to conclusion. Thank you both very much for the professional expertise, obviously, deep professional expertise, and the work of the union in terms of looking deeply into and opening up this issue, which surely needs to be given a lot more consideration and look to see what needs to be done to deal with it. So thank you both very much. I'm no doubt there will be some supplementary questions. Sounds like you might have a bit of a treasure trove of photographs and videos there. We might liaise with you over, and that'll be done through the Secretariat. So thank you very, very much. Thank you.
Thank you.
We'll break for morning tea now. We're running about 5 minutes late, and I appreciate the next round of witnesses have arrived, but perhaps we just need a 15-minute break, so we won't be 5 minutes late to start. So we'll break now and come back in 15 minutes. Thanks. the next panel of witnesses. Thank you all very much for coming along. I have to say I went back to look at previous inquiries for the supervision of this scheme and noted all your respective organisations were represented there, and I think probably the one before that. So can I just open by thanking you all? And you may not have been giving the evidence back then, but it just shows there's been a very strong and consistent longevity from your respective organisations on what is a very important matter, as being those with legal expertise, you're able to bring a high level of sort of intricate knowledge into particularly the schemes and the aspects of the schemes. So I want to thank the law firms and the Alliance for that contribution. It's greatly appreciated by the whole committee itself, so thank you for that. There are some gaps in the room. It's not because people are seeking to ignore you in any way. One person's had to go off and deal with an urgent matter, and another person is participating virtually. So that's why there are a couple or so gaps. But we'll get on though and have you respectively sworn or affirmed to give the evidence, and we'll get things underway. So from my left, moving across, could I get you each to state your name, your position title with respect to your organisation, and swear an oath or an affirmation, whichever you prefer, the words of which you should have before you. So perhaps we'll start with... Yep.
Thank you. I'm Joanne Wade. I'm from Slater and Gordon Lawyers, and I'm the head of our National Asbestos and Dust Diseases teams.
Yes.
I swear the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Ms Wade. Ms Valentini.
Hello, my name is Nicole Valenti. I'm appearing on behalf of the Australian Lawyers Alliance today. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Great, thank you very much. And Mr McGinley.
Good morning, my name's Timothy McGinley. I'm a Senior Associate at Morris Blackburn Lawyers. I'm also a member of the Australian Lawyers Alliance, and I'm appearing in my capacity both for Morris Blackburn Lawyers and the Australian Lawyers Alliance.
Right.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much for that. We might open up with the opportunity to make an opening statement. I might just confirm that with respect to your submissions, and they've each been received, processed, we appreciate the detail contained within. Slater and Gordon's is marked number 3 to the inquiry, Morris Blackburn's number 7, and the Law Alliance number 2. So they've been all processed, uploaded and stand as submissions to the inquiry. And of course we looking forward to be able to hopefully ask you some questions to elucidate on your opening statements and material in your submissions over the course of the next hour or so. So perhaps if we start moving from left to right again, if it's easiest, with an opening statement, and we look forward to what you've got to say.
Okay, thank you, Chair, and thank you to all members for inviting Slater and Gordon Lawyers to appear at today's public hearing for the 2024 review of the Dust Diseases Scheme. I'd like to acknowledge the traditional owners of the lands on which this public hearing is taking place, the Gadigal people of the Eora Nation. I pay my respects to their elders past and present, and to any Aboriginal and Torres Strait Islander peoples taking part in today's public hearing. My name is Joanne Wade, and I am the head of our National Asbestos and Dust Diseases team. Slater and Gordon are a plaintiff law firm with extensive experience in dust diseases claims throughout Australia. I've worked in this field now for 28 years, and our firm represents clients affected by silica-related diseases, coal-related diseases, and asbestos-related diseases. I note the focus of this review is the support available for younger workers within the scheme and other risk areas for silicosis. Our written submission outlines key recommendations for the Standing Committee to consider based on our experience in helping young workers diagnosed with silica-related diseases. The scheme established under the Workers' Compensation Dust Diseases Act 1942 does not serve this cohort of young workers in the same way it does for those suffering from asbestos-related diseases. And some of these young workers are presenting with autoimmune diseases such as rheumatoid arthritis, which are not covered by the scheme. Young workers need to leave their jobs, they then face financial distress, they need support to retrain, and the scheme should support at least 52 weeks of fortnightly pay at what was their at what was their income, including regular overtime, so that the financial burden is minimised whilst they undergo retraining. Workers would also benefit from improved rehabilitation and retraining services, and mental health has a really big impact on these workers, and the scheme should approve upfront mental health sessions so that they can access psychological services earlier. Tunnelling and quarrying industries are also exposing workers to silica dust, and these workers should also get tested regularly for silica-related conditions. Slater and Gordon continue to support these workers, and I thank the committee for the opportunity to appear today, and I'm happy to answer any questions.
Thank you very much. Ms. Valenti.
Thank you, Chair, and thank you to all members of the Standing Committee on Law and Justice for inviting the ALA, the Australian Lawyers Alliance, to appear at today's public hearing for the 2024 review of the Dust Diseases Scheme. I'm Nicole Valenti, and I'm appearing today alongside Timothy McGinley. We are both senior members of the ALA's Dust Diseases Special Interest Group, and we both represent clients affected by dust diseases to make claims so that they can access the treatment and support they and their families need. I too would like to acknowledge the traditional owners of the land on which this public hearing is taking place today, the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present, and to any Aboriginal and Torres Strait Islander people taking part in today's public hearing. The ALA is a national association whose members are dedicated to protecting and promoting access to justice, human rights and equality before the law for all individuals, including those who have developed diseases as a result of exposure to toxic dusts, primarily in their workplaces. The ALA is represented in every state in Australia, and we estimate that our 1,500 members represent up to 200,000 people nationally each year. We note that the Standing Committee's focus for the 2024 review is on support available to younger workers within the Dust Diseases Scheme, as well as risk areas for silicosis. Our written submissions have addressed these focus areas for the Standing Committee's consideration, and I will now hand over to Tim, who will briefly outline some of the points which the ALA would like to emphasise.
Thank you, Nicole, and thank you to the Standing Committee for this opportunity. Our written submissions include reflections from ALA members, as well as case studies demonstrating the experiences of our clients. Those clients are greatly affected by diseases like silicosis, and what those clients have experienced within the Dust Diseases Scheme underscores the urgent need for legislative and systemic reform within the scheme in New South Wales. The scheme is ill-suited to address the needs of younger workers diagnosed with accelerated forms of silica diseases, including younger workers in the stonemasonry and tunnelling industries. Even before they are able to receive an accurate diagnosis, some of our clients have been misdiagnosed. This has compromised those workers' access to comprehensive medical treatment and support within the scheme, and they are not reassessed for several years. The ALA has made recommendations in our submissions that we believe will ensure younger workers and their families can be supported through the scheme. The scheme must adapt to the new reality that workers are being diagnosed with dust diseases earlier in their lives, when they have many decades left of their working lives. iCare should support and provide a range of services for affected workers wishing to explore alternative study and employment opportunities so that they are not forced to return to workplaces where they are further exposed to toxic dusts. Further, the scheme must offer those workers, who are primarily young men, access to psychiatric and psychological services to assist those workers in navigating a life-changing diagnosis, medical treatment and career changes. Nicola and I are happy to answer any questions from the Standing Committee. Thank you again for the opportunity for the ALA to appear before this public hearing.
Thank you very much, and those great, succinct and clear opening statements. So, open it up.
I apologise, Chair. I've also got some separate opening statement on behalf of Morris Blackburn Lawyers. I apologise.
Most certainly.
If you
No,
indulge me.
please proceed. Sorry, I shouldn't have cut you off. Too quick. Please proceed.
Once again, I'd like to thank the Chair and all the members of the Standing Committee for inviting Morris Blackburn Lawyers to appear at today's public hearing for the 2024 review into the Dust Diseases Scheme in New South Wales. I will again take the opportunity to acknowledge the traditional owners of the lands on which we meet today, the Gadigal people of the Eora Nation, and I pay my respects to their elders past, present and emerging. I'm Timothy McGinley, and I'm a Senior Associate at Morris Blackburn's Dust Diseases Practice in New South Wales. In my everyday work, I represent and assist clients who've had their lives severely impacted and often cut short by entirely preventable dust diseases. In recent years, this has included an ever-growing cohort of younger workers suffering from an array of silica-related diseases. The members will have before them a copy of Maurice Blackburn's written submissions. Our observations and recommendations, like my colleagues appearing beside me today, are based on the extensive expertise and experience advocating for persons affected by dust diseases. Maurice Blackburn believes that the national ban on engineered stone is a welcome development in the law since the previous review of the scheme. However, while the ban is a necessary first step, we are of the view that further work needs to be done to protect the lives of Aussie workers and to provide necessary assistance and recompense to those affected by dust diseases. In particular, our submissions include the following major recommendations. Firstly, we recommend that the scheme be improved by empowering and resourcing iCare to provide more extensive career and educational counselling services to workers to assist them in identifying, training for, and transitioning into new career paths. Secondly, that there be a substantial increase in the quantity and duration of income support provided to affected workers to give young workers the freedom to undertake further education training in new career paths. Thirdly, that iCare be properly resourced to provide assistance and support to service a cohort of young workers that are increasingly coming from culturally and linguistically diverse backgrounds. Fourthly, that the scheme be amended to ensure that workers who have had multi-jurisdictional employment and exposures to dust are not at disadvantage by having their benefits reduced. And finally, that the nominal insurer scheme be amended to ensure that workers are not deprived of valuable common law entitlements due to unscrupulous employers failing to take out any or insufficient workers' compensation insurance. I again thank the committee and would be happy to answer any specific questions the members have regarding Maurice Blackburn's submissions.
No, very good, and thank you very much. And as I said at the commencement, the submissions are rich with very useful information and thoughts and reflections, and indeed some specific recommendations, which I'm sure the members will follow up. So we have members on the committee from the government, crossbench and opposition, and it's pretty free-flowing. The Honourable Anthony Adams participating remotely. There he is. So Anthony, can you hear us? We can't hear you.
He's on mute.
Can we? Yeah, we can't hear you. Anyway, we'll let Anthony deal with the technology to help get him online. But perhaps we'll start with Honourable Susan Carter, then Abigail Boyd and Roy Roberts. So if that's okay.
Thank you. Thank you all for being here. Appreciate the submissions and making yourselves available today. In all of the submissions, you've flagged the issue that we're looking at a younger cohort of workers, and therefore we're looking at, with happily, longevity, and so we're looking at retraining and reskilling. And the answer that appears to be given routinely by iCare is courier, truck driving, something which has significant income impacts. You also flag that a lot of these workers have low levels of English proficiency. So I don't know whether you can answer this question or whether this is an issue we need to explore, but are there other employment opportunities that they can transfer across to at the same level? Is it possible for them to do the type of university retraining that you're contemplating without extensive language training? I mean, what other pathways are available to these workers so they can maintain their income levels, support their families, but also not progress the silicosis disease?
I might answer that. For some of these workers, where English is their first language, it is easier to be retrained. But the rehabilitation that iCare tends to direct them to is to courier driving or truck driving. And for someone who's been the breadwinner, they've had a career because they've progressed through their stonemasonry career, and then to just sit in a truck or to be a courier driver can be a bit demoralising, and also their pay is a lot less. I've had a few workers who have actually gone ahead and done an adult apprenticeship. Now that means for 4 years they're going to be earning a lot less than what they were earning, but it's giving them a career. And so I've got one worker who's doing an adult apprenticeship in carpentry, another one in electrician, and to take those steps they have to, earn almost half what they were earning for 4 years to then start off with their trade certificate. I think another opportunity could be to explore TAFE certificates with these workers, your certificate 3 and 4. I've got a few workers who have gone into the gym industry as personal trainers, but we are talking about a cohort of workers who have generally left school at age 15, 16, and in order to then do a university degree, that would be a bit more difficult. But it's not, you can't overlook it as a mature age student. But it means supporting them for longer to get them through that. With the cohort who English is not their first language, and there are quite a number of these workers who come through who can't speak any English at all, they would need extensive English lessons to then assist them in that retraining process. And again, they've left school very young. I recently only saw one last week, Vietnamese worker. He's actually aged 50. He left school at aged 8 in Vietnam before he came here. So his skills to be retrained are very limited.
So I guess what I'm asking, is it realistic to assume that they can be assisted to find work at a comparable income level, or are we looking at income supplements for an extended period of time?
I was going to say, I think it's both.
I think it's entirely realistic to assume that they can be retrained, and we do have evidence of that. I have one client who did a university degree and is retrained as a social worker, but he was only able to do that because his injury occurred in Queensland and was supported under the Queensland system, which provides him with that sufficient level of support that he was able to undertake a university degree, and now he's a practicing social worker.
Can I just ask you, does a social worker earn what a stonemason earns?
He's earning comparable money, yes.
Okay.
That's right.
Thank you.
And in regards to linguistically diverse backgrounds, they will probably require more training in English, as my colleague has said, but it is entirely reasonable to expect they'll be able to do it. A lot of these workers actually did train with limited work experience, went through TAFE and similar certificates to get their stonemasonry education. Now, if they want to go on and get a university degree, they probably will need to get better education in English training. But we envisage that should be part of the system for those individualised care plans for those sorts of people.
Just in terms of recommendations we may formulate, should there be an upper limit of the type of vocational support and assistance that's available, or how would we set guidelines for that type of process, bearing in mind we're dealing with a younger cohort of workers?
I think that's a really good question, but if you're thinking about a university degree, that could take anywhere from 3 to 4 years. Similarly, with an apprenticeship, we're looking at 3 to 4 years. And so if there is an upper limit, I would say it would have to be to support them through their education, through their university degree or TAFE qualifications or apprenticeship.
And I believe you flagged an issue with some workers needing to return to their country of origin. Is that because their visa requires them to, or because they have more family support available to them?
It's both. Sometimes because their visa requires them to return to their country of origin. Other times, if they're struck down with a life-changing illness, particularly a terminal illness, they might want to return both to be with the family for emotional as well as physical support that they need as their disease progresses and while they're not able to work anymore.
And clearly visa issues are Commonwealth issues. Are you aware of any conversations with the Commonwealth Government about that issue?
Not aware of any, no.
I'm not aware of any.
Okay. And sorry, one more question if I may.
Please.
You talk about extending the range of recognised diseases, recognising that not everything is... Silicosis isn't always diagnosed first. Are there any issues with... Are there any multiple causation issues with, for example, autoimmune diseases? Where is the medical science? Are we sure these all flow from silicosis, or could they be comorbid with silicosis and have other causes?
The fact of the matter is that when the original diseases were added to the schedule of the 1942 Act, it was at a time when the medical science was not advanced to realise that there are certain systemic diseases that relate to dust exposure. At that time in 1942, the medical science was at that stage that dust caused lung-related diseases. It made sense. But the medical science has moved beyond that now, and there is very good causative evidence to show that there are a range of conditions outside of the lungs now that can be caused by not just silica, but exposure to various dusts. And the evidence, and the medical evidence is set on now. It is something that is diagnosed by treating practitioners as being causative. Yes, there are diseases that can have multiple causes, but a well-trained treating practitioner, whether that be a rheumatologist or immunologist or a respiratory physician, is able to look at a person's entire history and work out what the cause is.
So, is dust the only cause of, for example, rheumatoid arthritis?
Not at all, no. But it is a cause, and it certainly in a particular patient, a trained medical physician will be able to determine if this is rheumatoid or arthritis caused by dust exposure as opposed to anything else.
And would reasonable medical opinion vary on that, or it would be fairly conclusive?
There can obviously be a range of opinions when it comes to medicine, but but there is medical evidence, scientific and medical evidence to show the link between the two, and there are tests and systems that doctors use in order to work out if a disease is related to a dust exposure.
Okay, thank you. Thanks, Chair.
Thank you. Thanks for your submissions and all the work that you do. There's a couple of points I wanted to touch on. The first was in relation to this comment in the Maurice Blackburn submission that there's a growing number of smaller employers who are inadequately insured or hold no insurance whatsoever despite it being mandatory. What is the flow-on effect of that in terms of them then being able to claim, of workers being able to then claim under the scheme?
So while it hasn't been conclusively determined yet, the problem is that the way that the interaction between the 1987 and the 1942 Acts means there's a potential reading of the legislation that if a worker is not adequately if an employer is not adequately insured, then if their employees get injured, they might not be able to claim invaluable common law entitlements. That includes damages for their pain and suffering, damages for loss of wages into the future, damages for care and medical expenses that they require. Now, this seems, on the reading of the 1987 Act and the reading of the Hansard around that time, it doesn't seem like that there was that it was Parliament's intention to rob these workers of that right, because the right to the entitlement to damages still exists for workers of non-dust diseases who have uninsured employers. It just seems like that there's a defect in the legislation, a gap, and it's got to do with the interplay between the meaning of the word injury within the Acts and how it excludes dust diseases, that has led to a situation that a certain reading of the Act would mean that these people are that employees of uninsured employers may not have access to common law entitlements the same way as sufferers of non-dust diseases or injuries would be. And that's problematic because it should not be the responsibility of an employee to check that their employer has sufficient insurance before taking on a job. They should not be punished with their if their employer has not taken out adequate insurance. And if you speak to any sort of small or medium business owner, they will tell you that one of the major overheads that they have is workers' compensation insurance. And that has to factor into the cost of the services and the products that they provide. And that means if you've got an employer who is not paying for insurance, it has a commercial advantage over over other businesses who are doing the right thing because they can undercut them on price. And we should not be giving a commercial benefit to employers who don't follow their obligations under the law and get insurance.
So which regulator would be responsible for checking on that then?
That would be CIRA.
It would be CIRA.
Yeah.
Yeah, okay. So there seems to be two elements here then. It's getting CIRA to actually go out and monitor and enforce that, but then also a clarification in the legislation.
The clarification in the legislation would have to be passed by the Parliament to make that clear. Yeah. So that's first. And then second of all, there would have to be more work done by CIRA to make sure that these businesses are being properly audited and that punishments are being handed out to employers who are skirting their obligations to get proper insurance.
The other legislative change that has been suggested, apologies, I'm not sure which one it was in, it might have been in your one as well, is in relation to the requirement that a worker must get 100% of their exposure in New South Wales. And as I recall, the submission was saying this isn't the case in any other state or territory. So do you know why historically it's been like that? And
I don't know the reason why, but the way that the legislation is in New South Wales, and this is the 1942 Act, is that a person's benefits are reduced proportional to how much of their exposure occurred outside of New South Wales employment.
Right.
So where you have, and this is quite common, particularly with road tunneller workers, where they've worked in projects in multiple jurisdictions, if they bring a claim under New South Wales legislation, that will be reduced commensurate to how much of their exposure occurred.
Is the idea that they then go to the other state for the rest of
I
their...
don't know if that was the idea under legislation, but the problem is a lot of these schemes are mutually exclusive. So if you apply for benefits under one scheme, you can't go for benefits under another scheme. Whereas if you look at schemes in other jurisdictions, say like Queensland, all you have to prove is that there was a material contribution to your disease, and you'll be entitled to 100% of your benefits.
So effectively then Queensland or whichever other state is picking up the tab for New South Wales, because you'd expect people to go to Queensland to get 100% cover, even if they've only had 20%
Exactly,
or 30%
yeah,
of
exactly.
exposure.
And even if a person had entitlements in multiple jurisdictions, it is quite burdensome and high in legal costs to require them to go around different jurisdictions to get all of their entitlements when they all have different procedures that have to be and different methods of proof that have to be satisfied.
And if it's a New South Wales resident and we have an interest in getting that person back to work, then you would want them to be covered really within the New South Wales schemes.
That's exactly
and not, yeah. Okay, thank you. Can I also just touch on, this was mentioned in a lot of the submissions from yourselves, but then also from others, is this reluctance to necessarily get a different job because of it's high paid, doing particularly tunnelling work. Is there a need for, I note your recommendation around getting that psychological support at the beginning and how vital that is to stop that kind of secondary injury or to reduce the psychological injury from the diagnosis. But is there also a need for some psychological support or counselling before you even get to the point of having made a claim, to talk people through that decision as to whether to actually make a claim and then lose your job and all of those sorts of things? Has that ever been
That hasn't been explored, but in order to get access to the scheme, you need to make a claim. So it's very difficult to get that support without actually putting in a claim. So
I guess there could be sorry, I'm thinking out loud, but I guess you could still have Safe Work or whoever providing that as a service to people before they even make a claim, just to allow them to talk it through and perhaps make...
I was going to say, we would be talking it through, but added to that might also be some financial counselling, because to face that decision about giving up work and not knowing what will follow, maybe some financial counselling would help that cohort as well in making that decision.
Thank you. I'm aware I'm holding in a question.
I might jump in. Particularly, Ms. Wade, I think you've given evidence to inquiries before, haven't you, over the years?
Yes, I have.
Yes, so 28 years is a wealth of experience, and
showing my age.
No, well, that's all right. Well, some of us have been at those inquiries as well, so we know how you feel. I was going to make this point that, it's an observation, I'm not asking you to specifically agree with it, but dealing with the manufactured stone matter, which is not fully resolved, and obviously certain things and important things have been done, like banning, but obviously we've got a tail of workers that have been exposed, and notwithstanding the ban, there's going to be, obviously, until it's completely stopped at the border, so to speak, and no more comes in, full stop, there's going to be those being exposed to it who might be even cutting it still today because it was in stock in some warehouse somewhere. So the tail of this is a very long one, and it can be argued to get finally on top of the manufactured stone, which did happen. It took national intervention. It was sort of the movement at the national level which once it started to coalesce, appeared to move a lot quicker than otherwise was the case over a long period of time. The fear that I sort of expressed to some witnesses earlier today is that, and I'll just draw your attention, and you would not have this in front of you, but I'll just draw it to your attention. It's the submission from the Australian Workers Union, submission number 14, and on page number 4 they've got a very useful illustrative table of the tunnelling projects, and a large number are still ongoing. They're under construction. They're taking place still, and of course we know over the last dozen years or so there's been a lot of tunnelling work done. So we've got quite a large cohort of workers out there that have been exposed to the respiratory silica dust from specifically tunnelling work. Do you have a fear, and I know lawyers always use very considered and measured language, and not asking you to change that approach, but is there potentially a concern or even fear that if we don't bring a particular sharp focus and attention and willingness to deal with what seems to be, and I think we can reasonably say is an issue there that's manifesting, this is really problematic, that government, however we might like to describe it, and whoever comes in and goes out of government really needs to move on this, because if not, we're just going to have this misery just running. In other words, what I guess I'm saying is we don't want to repeat the manufactured stone long tail timeline. So that was a long way, more of a statement, but welcome any thoughts.
Well, with the tunnelling, as we know, we're digging into sandstone. A lot of the time it's sandstone that's being dug through to build these tunnels.
Yeah.
And they're really big infrastructure projects compared to maybe 50 years ago.
Yep.
And so on top of that, you've got machinery that is different to the machinery that was used before. And these workers do need to be protected. And why are we not protecting them when we know the damage that silica can cause? And they're getting exposed. So I think we do need to really look at this at the moment and have whether it's increased safe work inspections, whether it's improving the cabins that they're sitting in. It's something that really needs to be looked at. Otherwise, these workers in the next 10 years will continue to come forward with silicosis.
And in particular, the problem posed by tunnelling is a very different problem to the manufactured stone, whereas banning manufactured stone is quite a simple solution in a way. We cannot ban road tunnel projects ultimately. They're going to be necessary with our sprawling cities, with the transition to low carbon future where we need trains and other modes of public transport. So we're not going to be able to ban road tunnelling. Instead, the answer is going to come by better regulation of these industries and bigger penalties for those who breach it. And that is a harder thing to do than simply just banning something, and it's going to require consistent effort over many years.
And just following on then, that we do know that tunnelling is done in other jurisdictions, much less in New South Wales, but in Queensland and Victoria and perhaps elsewhere, but at least in those two jurisdictions. And we know that other jurisdictions other than those, WA South Australia for example, and others, have passed legislation to deal with the dust associated with the manufactured stone, but by virtue of what's happened, that's going to be essentially dealt with. Is it important that New South Wales and New South Wales government be approaching this with a thought that there needs to be this concern for comity between the jurisdictions as far as practicable, and have that influence their decision making about pushing to get this moving and ultimately done, or that the reality being New South Wales does the preponderance of tunnelling, that we're, dare I say, big, bad and ugly enough to take the lead and get stuck in?
look, ideally, you'd want a national approach to this sort of thing to make sure that all Aussie workers are protected. But I think in New South Wales there is a need that New South Wales move ahead as quickly as possible, even in the absence of a national approach. And there's two major reasons for that. There's, first of all, as you've identified, the sheer number of tunnelling projects that we have had and that we'll have in the future compared to other jurisdictions. There's also a problem with New South Wales specific geology. We sit on what's known as Hawkesbury sandstone, the whole eastern seaboard here, also known as Sydney sandstone. It's a type of sandstone that is very high in silica compared to some of the stones in other jurisdictions. So if you go down to Victoria, there's a lot more shale, lower silica content down there. And the problem with that is that our tunnelling projects are therefore going into a type of stone that is naturally more toxic to workers. And so so regulations that might be suitable for going through the geology in another state just might be insufficient in New South Wales for that. And so there is a need for New South Wales to go ahead and have the best standards in all of Australia because of that.
Can I just ask, it just occurs to me on that jurisdictional issue. Obviously, we have quite a lot of Commonwealth land within New South Wales and Commonwealth projects. How does it work when you've got exposure on those? So, for example, I know that the Department of Defence is still using manufactured stone, and they have sites within New South Wales. If a worker is exposed, is that then necessarily a Commonwealth responsibility, or how does it work?
It's a mix depending on the particular project. So even though a Commonwealth, a project that's ultimately run by the Commonwealth, say Snowy 2.0, is being run in New South Wales, that a company there might still be subject to New South Wales regulations, and a person who is exposed to this still may be entitled to New South Wales based compensation, whereas a person who's working on sort of a defence establishment who's injured in that way are more likely to be entitled to Commonwealth based compensation. So it's a kind of a mix of the two depending on the particular projects.
Yeah, okay. Interesting.
Welcome your thoughts about whether or not there is a dichotomy or not between looking at the manufactured stone industry and particularly the way in which the work was done in cutting and installing, where you effectively had a contractor for a project and then the work subsequently subcontracted down, which is very commonplace and virtually the norm in the building and construction industry. And then in the tunnelling, the reality is there is a very small handful of enormous constructions, engineering companies capable of doing projects and ultimately capable of making tenders and being successful. But equally, various functions subcontracted down. Do you see a parallel that's quite a good parallel analogy, or and it's quite a true analogy, or that there are some fundamental differences in the way in which work is organised and conducted in one versus the other? And particularly interested about, are there some particular aspects in tunnelling that we should be aware of that we just don't assume as we can carry across the sort of manufactured stone model and apply that?
The first difference is that the size of these projects is obviously you're dealing with much more people and much bigger projects than you were dealing with engineered stone. If you look sort of 10, 20 years ago back to projects sort of like the Blue Mountain sewerage scheme, back in those days it was common that were just a couple of companies working on it and they would be direct employees to everybody on site. But obviously the way that the industry has moved now for cost purposes, these tunnelling services, yes, there'll be a couple of big head contractors on there, but they are still serviced by a mishmash of different contractors and also increasing labour hire firms. So you might have a person who is working for a subcontractor to a main contractor, but is not employed by that subcontractor, is actually employed by a labour hire firm who's lent him out to the subcontractor, which creates a whole host of problems. And it plays into that issue again of some of these employers not being properly insured, especially when you get down to the smaller micro levels.
And that's right. There's a real myriad of arrangements, and one of the points that got raised in the discussion back and forth with previous witnesses was that the capacity of, or the ability of the state, that is the state of New South Wales, in entering into these contractual arrangements for the building of large tunnel projects, that embedding in those contracts are provisions which very explicitly deal with and elevate occupational health and safety to a very clear, unequivocal level and standard. And notwithstanding the fact, obviously, that there's legislation and regulation at the state level, and then, as we've heard from other witnesses, CompCare even sort of being involved as the licensed provider of workers' compensation in some of these projects. So we've got that issue there of law and regulation at the state level and the Commonwealth level, but this possibility or potential of the state through its contracting arrangements perhaps to intervene. The reason I'm sort of raising that is that, once again, just thinking that the manufactured stone took place over a period of time and ultimately laws got passed, but heavens, that can take a period of time. Are there levers that can get pulled or pushed that may have an accelerating effect on being able to bring pressure to bear on dealing with elevating the occupational health and safety standards in the tunneling industry?
I think it's still going to come down to enforcement. I mean, you can still put it in. You put it in the contract, but it's still got to be enforced.
Yeah.
Someone's got to be inspecting.
You've got to have it
the
enforced
sites.
too.
Yeah.
Yeah.
And as Ms Wade said, it's all well and good to put it in the contract, and the New South Wales government should be putting in those
And
contracts.
they may do.
But unless someone's
wrong,
enforcing
yeah,
it, we don't know what's happening. And there was a submission from an anonymous member who's working on Snowy 2.0 at the moment, saying that, they have a team meeting every morning where they say, safety before everything, and where standards are put in, but when it comes down to it, they're just not enforced.
Yeah. So, so just to follow that point through, and I appreciate we've just gone beyond time, with your experience and dealing with clients over a period of time, clearly in this area, specific with respect to silica dust and related matters, the enforcement is very, very important. And unless there is firm, clear, and dare I say, strong enforcement of standards, we're not going to get ourselves on the way to dealing with this, are we? What you're saying?
I think that's correct.
Yeah. And that really can only be done through the state having the will to put necessary resources into the regulation and the enforcement of regulation, or legislation as well.
Correct.
Other than the state, not that I don't think that there's anything quite like the capacity like the state to compare with, but other thoughts, if any, or taken on notice about ways and means of bringing pressure to bear, or that's probably, it's really up to the regulation.
Yeah, I think it's the regulation and the enforcement.
And the enforcement.
And by the state, where a contractor or a company fails in its obligations on a project, making sure that they're never given any projects by the state in the future again.
Yeah. And one final point, a number of the witnesses, particularly unions earlier today, expressed concern about, I don't think they used the word the vagueness, but the generic nature of some of the language in the legislation and regulation, which creates slipping and sliding opportunities to avoid or take the time to deal with, or whatever the case may be. So that the use the word, the phrase tightening up, or the clarification of specificity of language inside laws and regulations can only but help in dealing with having the obligation that can be then enforced. Because I think some of the enforcement issues flow from the fact that the legislation in some areas had sort of generic features to it which provided sort of opportunities to slip and slide. Any other final comments or observations, or?
No, thank you, Chair.
Well, thank you once again. I'm sure there's going to be some follow-up supplementary questions. I don't think anyone took questions on those, but if so, they'll come through. The Secretary will liaise with you. And once again, on behalf of this committee, I'm the chair at the moment, although as the chair, the deputy chair was the previous chair, to thank the two firms and the ALA very much. It's always quality material that we get in terms of your submission, but also the very precise and thorough oral evidence today. So thank you all very much.
Thank you.
Okay, well that brings us to the lunch break, and we're not back to 1:45. Thank you very much. Thank you. Our first session after lunch today, so welcome back. Changed the hat, Ms. Cole, this afternoon, so it was very valuable to hear from you this morning with one hat on, and of course you appear this afternoon in your capacity as Chair of the External Affairs Committee of the Australian Institute of Occupational Hygienists, so welcome back. Now, because you were sworn or affirmed this morning, you were sworn, there's no requirement for you to be sworn again, so that stands. With respect to the submission, of course, from the organisation, it stands as submission number 1 to the inquiry. So it can be taken as read. It's been processed and uploaded onto the inquiry's webpage, and is very valuable evidence that we'll be looking at. Now the members, some might be just arriving a bit late, forgive them, but we'll get things underway because we don't want to cut people short this afternoon. I'm sure there'll be some questions flowing from the submission and perhaps your opening statement as well. So I'll invite you to, again, make an opening statement in your capacity in the role of the organisation you're representing this afternoon.
Well, thank you very much. To clarify, I am here to represent the Australian Institute of Occupational Hygienists as past President and Chair of the External Affairs Committee. We are the largest organisation representing professionals in this field in Australia. As occupational hygienists, we are the ones who assess the risk of exposure to silica dust. We're the ones who measure silica dust in air. We make recommendations on safety control and verify if safety measures in place are enough to prevent dust diseases. I presented to this committee on behalf of the AIOH in 2022, and I would like to acknowledge the improvements in place in this state since that last review, including the ban on the manufacture, supply and installation of engineered stone, and the adoption of the model crystalline silica regulations. Our on-the-ground experience has prompted us to raise key areas worthy of the committee's attention, and these are that we need improved guidance on returning to work to support the increasing number of workers where dust diseases occur. We need more options for extended support for medical assessment for workers who leave employment in at-risk industries. Our state is in critical need for a tunnels under construction code of practice, as it is a code to address the requirement for basic competencies of those who undertake air monitoring for silica dust, along with the processes and interpretation of monitoring and applying those results. We also recommend that government employers and those private entities who receive government funding be required to use the services of eye care rather than private medical providers. With those opening remarks, I thank you once again for the opportunity to appear in front of the committee, and happy to take any questions.
Thank you very much. Well, I might kick off just with one question and share it round, and it goes to some evidence that was provided by yourself this morning, but I'm sure still is, I know is relevant to the submission you've made for this afternoon's part of the hearing about the tunnel under construction code of practice.
Yes.
And that importance of it and an explanation of its need, why it's needed now, and perhaps in broad terms what it would involve.
Well, it's very much needed now because we have more sophisticated processes for tunnelling, and we have more sophisticated control measures to apply in tunnelling. Whilst I recognise the strength of the new crystalline silica regulations, and they're very much welcomed in many industries, including tunnelling, there is a gap. From the perspective of an occupational hygienist, there is a gap specifically around controls, and there is a gap specifically around air monitoring. So at the moment, the frequency of air monitoring, whether that's daily, weekly, monthly, 6 monthly, annually, is not specified. Neither is the specific work groups that should have air monitoring undertaken. Neither is the competence of the person who does the air monitoring, for example. So there's quite a number of gaps, and I note that, I think I said this morning, very early in 2022, it was around March, that Safe Work New South Wales initially proposed the update of the Code of Practice, and unfortunately nothing really happened until May of 2023, when SafeWork decided to review some pre-WHS legislation codes of practice, and they put 5 codes out for consultation. One of those was the Tunnels Under Construction Code of Practice. And then we continued to provide feedback that this code was very much needed, as did other stakeholders, I understand. Then unfortunately, in October of 2023, so last year, SafeWork wrote to us and members of an advisory group that they had put together initially, and they said that they were now considering escalating that code of practice to a national level. And whilst that might seem like a good idea, what that does is it delays the implementation of a code of practice. So we wrote back very forcefully and said that we did not see the benefit of changing it to a national code unless the intent was to delay the implementation of the code of practice, waiting for the tunnels that are currently being constructed to be completed. And I understand in January this year they advised us that they were now going to have the code reviewed at the state level and then submit it for consideration at the national level. That was in January, and we haven't been able to get an update since that time. And obviously we are in November without a code of practice.
Can I ask, have you sought an update formally to them by contacting them?
Yes, we sought an update early this year by contacting them. I also contacted them by phone in the middle of this year, and unfortunately was unable to receive an update.
Okay, it's interesting. Might then move the questions around now. So,
Can I
jump in. Go on.
Thank you. Can I just pick up on one of your recommendations in relation to the private clinics? Can you just talk us through what the issue is there and why we need the change?
Yes. So with regards to health monitoring, a tunnel contractor or indeed any PCBU can use the services of whomever they would like. If they use iCare, then the New South Wales government gets information about the number of workers that are being screened through these projects and through that process. And you need that number, you need that denominator to know what the prevalence of disease is in a certain industry. When you go to a private medical provider, of course, there's still the legal requirement to notify the regulator and indeed the National Registry of a disease, but you don't have an understanding of the number of workers that have been screened. In addition to that, there is no requirement or mandate for tunnel workers or indeed other at-risk workers to receive CT scans. So the minimum health monitoring requirements include spirometry and chest x-ray and some questionnaire type paperwork. And we know that using lung function testing and chest x-ray can underdiagnose cases of silicosis. We've seen that in engineered stone, and concerns have been raised in at-risk industries like tunnelling as well. iCare is more likely to recommend CT scans in those types of scenarios, and private medical providers, their scope is limited by that is given to them by a PCBU or a tunnelling contractor. The difference as well is that by centralising it to iCare, those workers' records are always in the same place. So the medical professional can look back at previous health monitoring scans and previous health monitoring assessments to see progression over time. With private medical providers, those records are contained in the different medical providers that are used by the contractor. And lastly, iCare do follow up. So every year after you've had health monitoring, they contact the worker for repeated follow-up after they've had a screen.
So is there any good reason to continue, I guess, the use of private clinics at all? Are they quicker, or is there some sort of benefit that a worker would have being able to go to a private one?
I don't see a benefit, particularly from my perspective, from a worker's perspective. There may be a benefit from an employer's perspective because they may do audiometry and other types of tests at the same time. There may also be challenges with trying to get appointments in iCare that might be easier in a private medical system. But I don't think that that's a good enough reason not to use it. I think that the services that we have in this state of eye care are world class, and we should be encouraging and requiring employers that receive government funding to use their services.
Ms. Cole, and thank you, Ms. Ward, if you don't mind. From somebody that lives in a rural area, from that perspective, and I'm certainly very supportive of the eye care model that you're talking about, and I know that we're focusing a lot today on tunnelling in Sydney, but as we know, this dust disease can come from quarrying and mining and all sorts of things that happen in regional areas. So is it possible, though, for ease of access, that maybe a private provider in a remote area is easier than coming to Sydney for eye care? And we've had this discussion with eye care before in terms of remote testing, but the lung bus that they call it doesn't seem to get anywhere. And I'm not a fan of the lung bus. We learnt that through our silicosis in manufactured stone, that CT scans. And I argued, why don't we have mobile CT scans? But they tell us the equipment's too precious to move over long distances. But so again, I don't want to create the impression I'm not for eye care. I am, for those reasons you stated, but sometimes it's probably more practical to use a provider in the regions, do you think?
Yeah, I understand that concern. I think the lung bus, as it's colloquial called, is fantastic. I think we need more of them. In our submission, we have identified that may be a challenge in terms of capacity or even in location. So we have suggested that a secondary measure could be that any health monitoring screening data undertaken by a provider other than eye care be required to be submitted to eye care on a routine basis. Thereby, at least you would have an idea of the prevalence in certain industries.
Yeah.
And sorry, well, how would we enforce that? What would need to be in place that the private provider is therefore legally obligated to pass it on to eye care?
I think that would be a legislative change.
Okay, thank you. Sorry to interrupt.
No, not at all. Thank you. There's some pretty worrying statistics that you've provided in this submission, particularly the one that talks about in the construction and tunnelling sector, less than 10% of respondents to your survey, presumably they were occupational hygienists, reported that exposures were less than the WES. So presumably over 90% then are not compliant. Is that what we're saying?
Yes, we did a survey in 2022 of occupational hygienists who were members of the Australian Institute of Occupational Hygienists about their practical experiences, and yes, less than 10% reported that all exposures to respirable crystalline silica were less than the workplace exposure standard. So that just highlights how common it is for exposures to workers to be above the current workplace exposure standard, and we know that the current workplace exposure standard is not protective enough of adverse health effects. And so it is highly concerning. From a person that works in construction and tunnelling, it's highly concerning, as it is for hygienists that work in mining and quarrying and stonemasonry as well.
And you talk there about 20% of respondents in construction and tunnelling reported that air monitoring is seldom undertaken appropriately, and that sort of keys into the bit of the information you give a couple of pages earlier, which talks about the frequency of air monitoring and the time basis, resulting in practice it could constitute as little as one full shift sample of a worker's exposure in a 3-month period. Is that common to only be monitoring every 3 months?
Different industries, different sectors may have different standards, and it highlights why we so desperately need a code of practice to standardise this type of air monitoring. When you're in an industry like tunnelling and construction, things change very rapidly. So monitoring a particular work site every 3 months would arguably be insufficient where things are changing all the time. Currently, the standard in tunnelling, sort of the industry standard, is around once a month. But we've seen in recent years that trend be go from once a month, including maybe 50 to 60 workers, to once a month being only really 10 to 12, workers. So the amount of air monitoring is reducing, and anecdotally, we anticipate that trend to continue if it's not proactively addressed, because as you would probably know, the new crystalline silica regulations requires the PCBU to report the result from air monitoring to Safe Work New South Wales if it's above the workplace exposure standard, and yet there's no requirements around how many air monitoring samples should be taken by an employer. So we're seeing the number of samples being collected be less to lower the chance in some circumstances that there will be an exceedance.
Interesting.
Can I ask, just for the record, what is the workplace exposure standard at the moment?
So the workplace exposure standard at the moment is 0.05 milligrams per cubic metre as measured over an 8-hour shift.
So there's the measurement actually. So how does that work if you have to measure for a full 8 hours in order to establish the benchmark? But surely there must be. You can't just take one sample over an 8-hour period. It has to be.
Yeah, so we're collecting that sample. We're attaching a pump and a sample device to a worker in the morning at pre-start, and we're collecting it at the end of the shift, and that might be 8, 9, 10 hours. Sometimes in construction and tunnelling, workers are working a 12-hour shift, so we're trying to get as much of that shift as possible. But you are right to imply that one sample of one worker on one day is not appropriately representative of what might be happening. So what occupational hygienists do is we measure similar exposure groups. So we measure groups of workers over time repeatedly to try to get a better understanding of what's happening in that work group. So as you may have seen from the data this morning, there's lots of samples and they're categorised in groups. That might be labourers, that might be shotcrete workers. The hygienists trying to figure out the level of exposure and how different that exposure is in that group as they go on. But the workplace exposure standard is something that is not to be exceeded anyway. There's no it's not okay to have one sample exceed and everything else is fine.
There was a suggestion, I think, in a previous inquiry that the standard, as it currently set, is still not a safe standard. Do you agree with that?
There is evidence, scientific evidence, that has repeatedly demonstrated that the current workplace exposure standard is not protective of adverse health effects. Correct.
And so I think one of the issues that we grappled with in a previous inquiry was about if you lowered the standard to a safe level, the monitoring technology is not sufficient to actually detect at the lower standard. Is that correct?
That was correct in 2022.
Yeah.
Thankfully, there has been significant progress made in that area. I'll refer to TestSafe Australia, who's a highly respected, very large analytical laboratory that is based here in New South Wales. And recently, experts from TestSafe Australia and respected occupational hygienists from Safe Work New South Wales published a paper in a well-respected, peer-reviewed journal where they reported a technical solution to actually measure silica dust at levels at or below the lower workplace exposure standard of 0.025. And the solution was as simple as replacing the type of filter that we use as occupational hygienists, just a different type, and using one particular analytical method. At the moment, we use one of two, so that the second analytical method, known as X-ray diffraction, which is commonly done already. So by doing that, the authors were able to demonstrate that measurability was no longer a concern.
Right, okay, so there's no impediment now then to lowering the exposure standard to a safe level?
No, well, I will note that my own organisation, the Australian Institute of Occupational Hygienists, did publish a position paper last week that suggested that measurability may have been an issue, and they were suggesting that it may have been an issue because other constituents, other things in the sample might have interfered. So I took it upon myself to contact the senior analytical chemist from TestSafe Australia last week, who was the primary author of that paper and that method, to determine if that was the case. And she confirmed for me that in the vast majority of cases that issues around interfering constituents is actually not a method, so not an issue for that method. So on that basis, measurability does no longer appear to be a concern.
Right. There was another issue that sort of surfaced in terms of the properties of the particulates generated by manufactured stone versus sort of natural stone, and whether there was a higher degree of carcinogenic sort of qualities for the particles generated by manufactured stone versus natural stone. Can you shed any light on whether there's been any further developments in relation to that?
Yeah, so as part of, I guess, our work in advocating for the important need for the ban on engineered stone, we spent a lot of time trying to understand the science behind the dust that was generated from engineered stone. We know that the size of the dust generated from engineered stone was much smaller than the size of dust generated from other types of stone materials that contain silica. We also knew that there were other constituents in that dust that may have made it more toxic. I personally have not researched the chemical physical properties of the different types of dust from engineered stone or natural stone. I do know other researchers are looking at that, but what I will say is that respirable crystalline silica, once it's respirable crystalline silica, no matter the particle size, is carcinogenic. So it was designated a Group 1 human carcinogen 27 years ago. So we know that exposure to respirable crystalline silica increases the risk of developing lung cancer.
The smaller the particle, though, the more difficult it is to use, PPE to protect yourself. Is that fair to say?
The smaller the particle size provides a few challenges. One is that it will stay in the air for a very long period of time. It's already invisible, so you can't see it. Over time it will settle, and that's when you'll start to see it on surfaces. So it does present some challenges with controlling the dust, which is why when we look to control dust, we always want it to be controlled at the source, so on tool extraction or extraction close to the face of tunnelling, for example. We always want to control it at the source, because once it's uncontrolled and it's in the general working environment, that really fine dust is very difficult to capture and knock out of the air. And so our last resort is to provide workers with respiratory protection or masks. And we know that that's the lowest form of protection. I guess, think about how challenging it can be to work a 12-hour day, and 11 of those hours are spent wearing a paper P2 dust mask. It can be very, very challenging. And this is why they're commonly removed to talk or have a drink or just to adjust it, because it can be very challenging. It's not to say that they don't have a place, but to rely on it to reduce exposures to the workplace exposure standard day in and day out is very hard.
So what is it about tunnel boring machines that make them safer than the alternative forms of...
So tunnel boring machines are like a really large worm that is underground. It's about 100 metres long. It covers the whole sort of footprint of the tunnel itself. So there's not a lot of, space for the dust to escape to, because it has extraction systems on the tunnel boring machine that are generally very good at extracting the dust from the cutter head as it's tunnelling. Mined tunnelling, if you imagine a very large cavern and a very small machine that's tunnelling at the face, that dust can go anywhere within that cavern. So if it's not appropriately controlled at the point of dust generation, if the ventilation system is over here and the road header is over here, it's relying on the dust travelling all that way, and we know that that in many cases is not very effective. It's just a difference in the method.
Just one last question. So the other thing that sort of is in my mind was about, is it the case that what would cause fluctuations in the amount of particulates in an environment in tunnelling? Like, it seems like, so while the machines are operating, then you get a consistent level of dust, and so you kind of have a constant environment. So testing, air quality testing doesn't matter when you do it, if it's pretty consistent, then the amount of particulates in the air would remain relatively constant.
Actually, it's the opposite. It's very variable. So you have road headers that will mine, and then they will pull back, and then you will have a bolting rig that goes in, and then you will have a shotcrete crew that go in, and the process continues. So in my experience, and in the experience of others that have spoken to me, and I'm sure maybe Safe Work New South Wales can share some of their experiences in tunnelling, sometimes when we will go and do air monitoring, the machinery is not working. And so maybe on that day that the air monitoring was done, it was not representative about what was happening on that day. So that's why a bit more prescription around air monitoring and tasks that are occurring at that time while that air monitoring is being performed is so important, because dust levels do fluctuate depending on the method used, depending on the time of day, depending on the tasks that are being undertaken at that time. And there's a lot of things that happen in tunnelling that aren't just at the face. So there's other back-end works that are happening in parallel, but all that air has to flow past the workers to get out of the tunnel.
Of the big infrastructure projects that we know about in Sydney, what ones are using the boring method and which ones are using the cutters? So is it the Metro's doing the boring and then the road projects is doing the cutters? Is that?
Sydney Metro, West, Sydney Metro City and Southwest will use tunnel boring machines.
Yeah.
And every other project will use mined tunnelling, except Coffs Harbour Bypass, I believe, is using drill and blast, and Snowy Hydro 2.0 would use drill and blast.
No. And I don't know if you want to answer this question, or if you can, but when you, at your time in Sydney Metro, was there anything there that you could tell us about? What was your role there, and was it in the tunnelling, work health and safety space?
I've worked on many projects, and one of them has included Sydney Metro. Definitely not authorised to speak on behalf of Sydney Metro in the capacity that I sit here. I will provide some publicly accessible information for you. So Sydney Metro was the first project that had an occupational health standard in place. It was the first project that put minimum mandated contractual requirements into tunnel contractors' contracts that required air monitoring. It required air monitoring results to be sent to Sydney Metro. It required minimum mandatory controls. And from my perspective, did a lot of things from a client to try to improve conditions in tunnelling. So as Mr. Donovan said this morning, even though this data came from Sydney Metro, they should at least be commended for sharing that information. And the information they did provide demonstrated that the highest risk is actually in mine tunnelling, and there is a significant amount of mined tunnelling happening in Sydney, of which we do not have publicly accessible data from.
And that's the non-metro projects?
And that is the non-metro projects.
Yeah. Okay, thanks. No, this is interesting.
Susan, do you have any questions?
I just got one follow-up from your original opening statement, Ms. Cole, and that was, and again, I don't know if I heard this correctly, and please correct me if I'm wrong. I got the inference that you talked about the monitoring of air samples by the PCBU themselves. What level of competency must there be for the person that takes that actual sample at the workplace?
That's a great question. So at the moment, there's no minimum mandated competency for persons that do air monitoring. Obviously, us at the Australian Institute of Occupational Hygienists have made recommendations about those minimum standards, because it's not as simple as going to a store, getting monitoring equipment and putting it on a worker. And even if it was, there is a lot of skill that is involved in understanding how to interpret that information. And it is more than just air monitoring. It's understanding where the sources of exposure are coming from, and most importantly, if there is an issue, understanding what the appropriate control measures are to keep workers safe. Myself and many occupational hygienists have been incredibly busy since the implementation of the new crystalline silica regulations, and the majority of our time has been spent helping businesses understand how to control the risk. Not so much air monitoring, but how to most importantly get on top of it to minimise the risk as much as possible, rather than just going and putting pumps on workers and measuring the dust that we know
prevention's
is probably
always better than cure.
problem.
But for us as a committee then that will be at the end of the day making recommendations to government, going back to that where the PCBU is taking samples themselves, what could we recommend in that field to ensure the integrity of the samples that are taken?
One of the best recommendations would be to require that all air monitoring for silica is done under the governance of a certified occupational hygienist. That means overseen by a certified occupational hygienist. And it's done by what we call an MAIOH, a full member of the Australian Institute of Occupational Hygienists, because we have a competency scheme, a certification scheme. Occupational hygienists have to meet minimum education and experience requirements before being awarded certain statuses. So, it is tertiary education, it is experience in industry. It is not as simple as assuming that because you've done air monitoring for methane that you can go and do air monitoring for crystalline silica. They are very, very different things.
Okay. Thanks, Chair.
Just a couple of quick questions, if I may. So I understand when you were talking to answering the questions from the Honourable Anthony D'Adam, you were talking about PPE, perhaps user fatigue or lack of comfort, or that PPE isn't perhaps the solution to managing risk. Is that an accurate summary? Or
PPE would not be the first choice in managing risk. So it is something to supplement other, what we call higher order control measures. So there's a hierarchy that we would follow. We want to eliminate the generation of dust, substitute the product we're trying to work with, or substitute the method that we're using to do the work.
If we're talking about silica, is it possible in tunnelling? Is it possible to eliminate the production of dust?
I don't think it's possible to eliminate the production of dust, but it's definitely possible to minimise and reduce the amount of dust that is in the air. Yes.
And that's where you're talking about using different types of machinery.
Maybe I'll give you a really good example. So there is a large number of workers that work underground in heavy machinery that have the benefit of closed cabins with windows, and you would expect that a typical underground piece of heavy machinery is appropriate to use without having to wear a dust mask. That's not always the case. Increasingly, we have seen some very good tunnelling employers retrofit underground equipment with pressurised systems, which therefore removes the entire requirement for a worker to wear a dust mask at all, because they've put engineering controls on the cabin. So whilst there is dust outside, there is not dust in the worker's environment. So while systems like that might be mandated in coal mining, because we don't have a code of practice that requires minimum standards, sometimes these are things that are seen as best practice rather than minimum controls. Appropriately, our regulations, work health and safety regulations, allow some flexibility, and that is appropriate to allow employers the flexibility to apply certain control measures. But when we have a known safety control like HEPA pressurised cabins, and we know that that's been used in other industries, and we know that that protects workers, that should be a minimum mandatory control when you're working underground, for example.
One hopes that the welfare of the workers would be the overriding consideration, but are there other incentives that you can think of that could be offered to PCBU so that they would be actually implementing these best practice measures?
It's a good question, but it might be a question for the PCBUs rather than, I don't think I could appropriately answer it. I'm sorry.
No, thank you very much.
Can you just open out a little bit beyond the tunnelling to quarrying work and workplaces like cement factories as another example. I think we're hopeful that in this inquiry, which is looking at the whole review of the scheme amongst other things, that our second subpart is to sort of go beyond the manufactured stone, clearly into tunnelling, but also really wherever there's a manifestation of dust. How do we keep abreast of what we need to as a committee to make sure we're always on the front foot as opposed to being reactionary to things? I speak for myself only here, not other committee members, but obviously the manufacturing stone has the tail I've described earlier, which has been a long tail. We're now confronted with obviously what's happening with respect to the tunnelling. Sort of a sense of all the very rich evidence today, feel like we're behind the eight ball, arguably in quite a significant way, which is not where we want to be. But other manifestations of dust and its implication for workers, how do we keep abreast of that as opposed to sort of hearing from experts like yourself once every cycle of when we do the review of the dust diseases scheme?
Well, I acknowledge the work of Safe Work New South Wales in the context of their silica dashboard. So they update that quite regularly, and that includes information around prosecutions, it includes information around notices, and importantly, cases of dust diseases. One wonderful and welcome improvement to that dashboard, which would inform members of the public and indeed the committee and future trends in terms of dust diseases, would be to update that dashboard to include information about overexposure to silica. Now that the new crystalline silica regulations require PCBUs to notify Safe Work New South Wales when there are exceedances, they would then have this information. So to be able to stratify that, categorise that information into industry about how many exceedances are actually coming through to the regulator, I think is really important information, because that would give you a bit of a snapshot and you can start to see the level of risk in different areas across the state.
And on the example that I've given with respect to quarrying, for example, and obviously many quarries around the state, often those quarries, and I don't have detailed knowledge, but they often can be quite small, and there might be just a very limited number of workers on the site. But nevertheless, if there's exposure issues there which are consequential, it's important that this be sort of attended to as well. Is anybody doing sort of expert work, if we could use that phrase, on the matter with respect to quarrying and the matters we need to confront there?
I would have to take that question on
Sure,
notice.
take that on notice, yeah. Maybe that might be for your second PhD when you've gone through your first one. In terms of, and this may be beyond your practical knowledge and expertise, and please feel free to say so if it's the case and it's no reflection on your particular expertise, but with respect to the dust disease scheme in New South Wales, remit of this inquiry is to really have a good look at that, and many witnesses have talked about obviously the how that's progressed or arguably regressed depending on a point of view over time, and what we have now is what we have now. But you standing back with your expertise and looking at the scheme, are there any headline observations that you'd like to make about where you think the scheme might be attended to in terms of some improvements?
I think as has been raised before, it is becoming increasingly challenging for younger workers.
Yeah.
And I know at least one example of, younger workers with a young family that may be female when the scheme was set up to look after workers that were significantly older and male only. And this is definitely an issue for both genders and indeed much younger people. So that would be my main observation. In tunnelling, as I said, we typically have cases of chronic silicosis, so that's after 10 years exposure, but that does not mean that it's confined to gentlemen in their 50s. Indeed, there are cases of tunnel workers with silicosis younger than myself, without giving my age away, and so that is increasingly concerning.
Are there any other questions that have been presented? Well, if not, thank you very much. I suspect once we've had the opportunity to read Hansard, there may well be some supplementary questions if you're prepared to have a look at those. But once again, thank you for coming, in fact twice today. You bring a great deal of expertise to the table. I noted earlier, looking at the previous reports, your participation, and it's been very, very important contributions to have that continuity of expertise over a period of time to bring to the table. So thank you very much.
Thanks for having me. Thank you.
Thank you.
As being closer to best practice in terms of alleviating dust, as distinct from the, I'll call it the digging model.
Yep.
Why do we use the digging model? Is there can it only get through certain material and this one can't? Why?
Or is it cheaper?
I think we've only got two machines.
I'm wondering why.
Yeah,
I don't have that
I don't think we've got
expertise
many
on it.
machines.
There's two machines, and I think they're
They're called like.
Bertha and Agnes or something.
Yeah, that's
Yeah,
right.
yeah.
Yeah, right.
I remember that.
I was wondering the same thing myself, that if there is this,
We need
because
a
there's a range of
Well, that's what I mean.
different
We
tools,
need
range of different
perhaps to
machines.
hear from an engineer or something
Yeah.
to tell us why
Yeah.
they use this
true.
other form of digging when we've heard from others that perhaps it's not the best way. Maybe there's some engineering reason that we're not grasping that says that's in certain circumstances you can only use this type of machine.
Or different stone.
Yeah.
Or, yeah, exactly.
Might be
But-
good to get someone from transport and
Transport,
infrastructure
Yeah,
to
yeah. Well,
be good.
perhaps
some
maybe we can
engineering
look
type
at that
questions.
at some
No,
stage, Chair,
I
to
think
We
find
just
out.
write to them if we want an answer.
Yeah.
for
I
that.
think
We don't
it's a
even-
very good
It'd
question.
be helpful to have someone that we could talk to, because it'd be hard to exactly write the question, I think, and other questions would arise. Yeah.
Well, maybe
and the
it's,
differential cost and the cost of retrofitting for the positive pressure cabins and things
Yeah,
like
we
that.
had no success. Sorry, we're just not ignoring you.
Sorry.
Apologies.
Sorry.
We're talking amongst ourselves.
Yeah, sorry, we're having quite separate meetings, so apologies, but we didn't, or not able to capture any effective employer or employer groups in this related work to come and give evidence, which was, there was one that was up to the starting line and pulled out, so make no imputations about that, but that's who we really need, the operators of this machine.
Well, even if I may boldly suggest, if we can't get an actual operator, right, at a PBCU, perhaps some professor in engineering from one of the universities would say to us, well, you've got to use this machine in sandstone, that's the only one that'll get through it, and or you can use this one in a different depth or whatever it happens to be, so we get an understanding.
I think we need that understanding, yeah.
Or this one goes into a hospital and then we...
Yeah.
We're grappling with the detailed engineering of
Engineering, we
tunneling
know
in,
all know so much about.
the state of New South Wales, and I'm sure this is an area that you have some particular knowledge about as well. So thank you very, very much for coming along this afternoon to provide us with some evidence to our inquiry. Now, just to confirm who we have got, just forgive me. So I was just to confirm we got. Okay, so yep.
Oh, not my best at any time.
You are, okay. And then we got
Beginning to fall.
Yep. Okay, so if we just go through this to sort of coordinate, because we've got obviously people in the room and also people participating virtually, of which we've got 2 out of 3 currently online. So I won't even try and be clever and pronounce Doctor's surname. If I refer to you as Dr. Uvi, that's probably the easiest escape for me to say that as a way. But how do you pronounce your surname? Because I'm sure.
So Arivi's good. Thiruvarachelvan is the last name. I
Thank you
usually am all right with Thiru.
Thank you very much. That's appreciated. So I've got you here, obviously present, and we've got Dr. Muir.
Yes.
Thank you. And then presently online we've got Dr. C. and Dr. Brooke. Sorry, Mr. Brooke. Is that correct? Great. Okay. Well, thank you for that. So the first thing we need to do is have our witnesses sworn or affirmed to give their evidence. So if we start at the top of the table and move around. So I get you to take an oath or an affirmation. So I need you to state your name, your job position, title, and then an oath or an affirmation, whichever you choose, the words of which should be up there. So
Sure.
if we start with you, Doctor.
My name's Dr. Jane Muir. I'm an occupational physician representing RACP here today. And I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Doctor.
I'm Dr. Arivi Thiruvarachelvan. I'm a respiratory and sleep physician here on behalf of TSANZ. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now, if we go to Dr. Driscoll, if you could follow through with the formality.
I think he is coming.
I'm sorry, I apologise. Sorry.
Dr. C.
Dr. C. Yep, sorry, Dr. C. My
Thank
apologies.
you, Dr. Hayley C., Head of Public Affairs Research and Operations at the Thoracic Society of Australia and New Zealand. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, and apologies for that. And Mr. Brooke.
Good afternoon, Mr. Chair. It's Mark Brooke. I'm the Chief Executive Officer of the Lung Foundation Australia. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And I think joining us now is Dr. Driscoll. Is that correct?
Yes, that's right. Hello, I'm sorry I'm late. I had trouble connecting.
No, that's okay. That's okay. So if you'd be good enough to just go through the formality of the providing your name, your position, title, and swearing either the oath or the affirmation, whichever you prefer. If you don't have the words there, we can provide.
I do have them with me.
So please proceed, Doctor.
Okay, my name's Tim Driscoll. I'm from the School of Public Health, University of Sydney, representing the Royal Australasian College of Physicians. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, and can I commence by acknowledging this is a very important panel this afternoon with people who bring a myriad of expertise and knowledge to the table, which is going to be helpful for us in our inquiry in regards to the dust diseases scheme in New South Wales, but more broadly matters to do with silica dust around tunnelling and related sites. Now, if I move through and perhaps invite each witness, if you wish to do so, to make an opening statement, that will help set the scene, I think, for members when we come to it to frame some questions to yourselves. So you don't have to, there's no obligation to do so, but you'd be welcome to make one if you would like. So perhaps we'll start with you, Doctor, if you'd like to.
I'll just give a quick introduction about RACP and who I represent.
That
for the
would be
work
fine.
That I do.
Yeah.
So Royal Australian College of Physicians represents 32,000 medical specialists from 33 different specialities. I myself am an occupational physician, so I'm a member of the Faculty of Occupational and Environmental Medicine, and I am an expert in workplace health and how health affects work and how work affects health. In my line of work, I work with a lot of tunnellers, both performing health surveillance and managing those who have been diagnosed with silicosis.
Very good. That'll be very useful for us. Doctor, would you like to make an opening statement?
Yes, I have a little bit of a statement. So my name is Dr. Ruby Thiru. I'm a respiratory physician with a special interest in occupational and interstitial lung diseases. And I'm also a member of the Thoracic Society of Australia and New Zealand, which is the peak professional body for respiratory health in Australia and New Zealand. I see many patients with silicosis and other occupational lung disorders in my daily clinical practice, and I'm involved in research in this field and work alongside Professor Yates, who was initially intended to present today but is indisposed.
You're most welcome. Yeah.
I'd like to summarise the TSANZ's recommendations in response to the current review of the dust diseases scheme. There were two areas in which the Legislative Council invited submissions. The first was medical support mechanisms and assistance for workers impacted by dust disease. Our feeling is that respiratory surveillance in New South Wales needs standardisation. There's no central repository of data, system for quality control, or access to results by workers or healthcare practitioners. Contrary to the TSANZ's recommendations, iCare uses insensitive technologies and spirometry to detect dust diseases in workers who have a high risk of disease, meaning that early stage disease can be missed. In addition to the implementation of lower dust levels at source to reduce cumulative dust exposures, regulating a cap on working hours for dust-exposed workers should be considered. The feedback loop between iCare and Safe Work New South Wales is inadequate, leaving workers exposed to further workplace risk. Current support mechanisms, including medical and financial assistance for workers impacted by dust disease and job reassignment, are inadequate. Toxicology testing of emerging replacement stones should be undertaken before new products enter the market and not after potentially toxic materials have been introduced. Such products need clear labelling with a listing of all the constituents. The second area we looked at was the emerging areas of risk for silicosis in industries, including but not limited to tunnelling and quarrying. The TSANZ notes that there is no safe level of exposure to respirable crystalline silica, and that silicosis has been documented to occur in workers after exposure to products with low levels of RCS, where poor occupational hygiene exists. Silicosis has been described in a variety of industries, including jewellery making and dentistry, and therefore a high index of suspicion is required for every silica-containing product. Thanks for your attention. I'd be happy to answer any questions.
Thank you, Doctor. That was very precise and very clear and a very good opening statement. Perhaps move to the witnesses on the line. So just going down my list, so perhaps starting with you, Dr. C, would you like to make an opening statement?
Yes, thank you, Chair. I just wanted to reiterate the expertise and experience that the Thoracic Society is offering to the committee and the New South Wales Government.
Thank you. That would be valuable.
Thank you. The Thoracic Society of Australia and New Zealand is a leading authority on lung health with a professional membership base of over 1,800 individual members from a wide range of health and research disciplines. The Thoracic Society first raised the alarm regarding silicosis diagnoses in stonemasons back in 2016, and we've been advocating for elimination of engineered stone, protection of workers, respiratory surveillance, standardised care, and mechanisms to support lung health and workers ever since. During this time, we have worked alongside our colleagues at the Royal Australasian College of Physicians and Lung Foundation Australia in advocating to protect and support workers here in New South Wales and around the country. Our recommendations, which Dr. Thiru just described, prioritise evidence-based practices to protect workers and improve respiratory health outcomes, and these will deliver significant benefits in terms of both worker wellbeing and also cost savings in the long run by preventing disease and associated healthcare burdens. Workers deserve to be protected from harm when they're out earning a living. This committee can help to bring much needed standardisation of safety regulations, surveillance and implementation of clinical pathways to support workers, keeping them safe and cared for if they do come to harm. And we're happy to assist the committee today and into the future. Thank you, Chair.
Appreciate that very much, Doctor, and also happy to acknowledge the past contributions by the organisation as well. I've had the honour of being on the committee over a period of years and have always been impressed by the quality of the submissions and evidence, so thank you for that, along with the other participating with us today. Perhaps I move to Mr. Rook. Would you like to make an opening statement?
Yeah, thank you, Mr. Chair, and thank you for the opportunity to present today. I'll take our report as read, but we'd like to make 3 additional comments, if we may. First and foremost, you will have seen that the National Silicosis Eradication Agency released the National Silica Plan this week. The Lung Foundation was contracted by the Department of Health to deliver the forerunner of that document, and we're really pleased to see that the Commonwealth and all states and territories, including New South Wales, have adopted the plan. But its adoption will only be successful if the recommendations and actions within that plan are taken seriously by government. The second area we'd like to highlight is that over the next 12 to 18 months, we are in a really crucial opportunity with the introduction of the National Lung Cancer Screening Program by the Commonwealth to be able to see an increase in the number of patients potentially identified with occupational lung diseases, interstitial lung diseases in particular. And being prepared and leveraging that opportunity is something that we would encourage the committee to consider. And finally, as part of a Commonwealth-funded package, the Lung Foundation receives a substantial grant to support men and women and their families impacted by occupational lung diseases. We offer a specialist nurse program, a telehealth nurse program, and a specialist social work program that is free of charge and allows workers and their families to seek independent, confidential, and at times very sensitive information about not just their workplace and their rights and obligations, but also how they're managing their particular disease or whether they're at risk. And then finally, we just make the point that service is increasing. Silicosis did not go away as a consequence of the ban on artificial benchtop stones. As you've seen this week, it is a reoccurrence or an emergence in a number of industries, including tunnelling. But particularly, we'd like to highlight the TSAD's point and position that new products coming onto the market are arriving every day without sufficient testing or understanding of their impact on workers' health. But thank you.
Thank you very much, and I apologise. It remiss of me to not acknowledge the contribution through the submission, which stands as submission 10 to the inquiry, and that's been received, processed, and stands as a submission. And of course, the Thoracic Society's submission is same number 9 to the inquiry, has been processed and stands as a submission to the inquiry. Perhaps they're moving and finally on to Dr. Driscoll. If you'd like to make an opening statement, and then we can move on to the questioning from the members.
Yeah, thanks very much. I actually wasn't going to say anything, but I would like just to...
Please, please.
To strongly support the statements of the Thoracic Society and Lung Foundation in terms of what they say. We definitely support that. And the second thing is to keep in mind that although the problem with silicosis in Australia has been particularly brought to mind because of engineered stone, just to keep in mind that there is a large number of workers who work in other areas who are also exposed and potentially exposed to silica, and we need to make sure that their exposure is prevented or controlled as best as it can be, as well as what we've been doing in the engineering stable. Thank you very much.
Thank you, Doctor. That's an important point you make. Now, we'll open up for questioning. We have members on the committee from the government, opposition and crossbench. Now, we've got 3 online and 2 present physically in the room. So I just invite members that could you just name the individual going to direct the question to, particularly those online, so they can actually receive the question and answer it. So this is pretty free-flowing, so we'll move through now. Who'd like to kick off? Honourable Robertson.
One question, Chair, just to start with. To you, Dr. Arubi. You said in your opening statement something to these words, and I'm not quoting you exactly, but the loop between eye care and safe work is completely inadequate. Can we tease that out a bit more and explain to us why it's inadequate and the importance of it becoming adequate at least, and how do we rectify that?
So I guess the issue at hand here is the focus of the two different organisations. Safe Work New South Wales is present to create a safer working environment for the worker, whereas iCare and the Dust Diseases Board is more focused towards compensation and the care of the patient. So while the patient is being assessed and sorted out for compensation and routinely followed, they don't necessarily communicate the recommended dust restrictions to Safe Work New South Wales. So sometimes, in fact, some of these patients who have been found to have an occupational lung disease and been given compensation can actually return to the workplace in a similar capacity without any increase in their precautions. So in fact, they're continuing to do what they were doing before, just with compensation. And so I think potentially what might be beneficial is having a communication between iCare and their assessments and Safe Work New South Wales to impact the worker moving forward, rather than just focusing on their own side of the table, which is compensation and medical management.
Okay, thank you, Chair.
Sorry, it was just, I did say, yeah, and then Abigail,
please.
apologies.
Sorry,
Abigail,
and really a follow-up question from that, because I was interested in the same issue. You indicated that iCare used insensitive technologies for diagnosis. Why is that?
I think it's an interesting question, and undoubtedly it's to do with the development of new technologies and also the ability to use these technologies in the workplace in a sensible way. So initial screening, we were talking about chest x-rays and spirometry, but we now know that a chest x-ray is inadequate in the early diagnosis, for example, of silicosis, and spirometry will be normal until patients are quite impaired with silicosis and progressive massive fibrosis. So at the moment, the current recommendation would be to consider CT rather than chest x-ray early, and more complex lung function, including gas exchange, to try and accurately assess these patients early enough, or these workers early enough, that we can modify their trajectory. And potentially in the future there are other options like exhaled breath testing, which might be more amenable in the workplace than the current recommendations.
And are they much more expensive technologies to use, or?
CT scanning, and so complex lung function can now be done more easily in the workplace or the workplace health assessment setting, and is not necessarily more expensive, but certainly CT scanning is much more expensive than a chest x-ray.
Thank you.
Thanks. I apologise in advance. I'm going to have some pedestrian questions that you will probably find not very clever. But I'm trying to understand the process for, I guess, sorry, taking a step back, we had some submissions this morning from people saying, effectively, these silica-related diseases are not all lung diseases. At the moment, we only recognise, for the purpose of the Dust Diseases scheme, those lung-based diseases. If we were to include that broader group of diseases within the scheme, what level of, what level is the evidence at, and what would need to be shown in order to link it causally with the exposure?
That is a very interesting question, and it is a question that is actually currently being researched. So I probably am not best placed to give the details into that, but certainly at present there does appear to be an association between silica exposure and autoimmune diseases, which can affect the joints, the blood vessels, the skin. Any further detail I may have to defer to others or provide an answer at a later point.
So certainly can take it on notice.
Yes, I will take it on notice.
And just thinking of other witnesses online, or Dr. Jones? jump in?
Sorry,
I didn't mean to put you on the spot. I
No,
apologise.
absolutely. So in terms of the other extra lung diseases associated with silica, again, I know there's definitely an association that is heavily reported and recognised in the literature. In terms of any evidence for causation, I will have to take that on notice.
I'm just wondering, that's why I say I feel a bit ignorant in this space, because I'm trying to work out at what level or what threshold it would be then included in the scheme if we were to take, to broaden, which it sounds like we probably should do with, information getting better and sort of our understanding getting better, but then what level would we then expect there to be in terms of, I don't know, percentage causation to the exposure. But sorry, someone has their hand up on the video feed.
that's
Maybe
Dr.
they can
C?
help me.
Dr. Driscoll.
Sorry, Dr. Driscoll, apologies. Sorry, the hand, sorry. Yep, sorry.
Yeah, thanks. Yeah. Yes, I don't disagree with what's being said. Probably depends on who you are as to the answer you get to how strong the evidence is. I think there are some clinicians who would say, look, it's very clear there is a connection, and others who would be more saying, well, the evidence so far shows an association rather than really demonstrating a causal connection. I had a look at this probably 2 years ago, and at that stage, for several of the conditions you're referring to, I'd say the evidence was pretty strong, but not clear, not absolutely clear at that stage. As to whether it ought to be included or what level of evidence you would need before you would include it, it really depends a bit on the philosophy of the state in a way as to whether you want to make sure that if somebody has developed a condition as a result of historical exposure, you want to make sure that they are covered, accepting that there might be some people who are then covered where actually wasn't caused by their exposure. Or the alternative is, if you wanted to have a stricter definition, then potentially you'd be excluding people where the connection had been. In terms of what should come from the committee, I think it would be worthwhile recommending that somebody look at it, not me, but somebody look at it, the current level of evidence, so that you're well informed now. I think there has been quite a bit of evidence, some evidence available in the last couple of years that hasn't been summarised for you previously. So I think that might well be useful for you given the question that was asked. And it could be done relatively straightforwardly, I think.
Any other witnesses on the screen would like to make a contribution to? Do you have a go?
If I might, Mr.
Yeah,
Chair,
please.
It's a chicken and the egg scenario insofar as many of these diseases are diagnosed but not necessarily recorded in a register. So we're not able to we don't have the data points necessary in some cases that would enable us to make informed conversations about causality and whether it should be included in the scheme. And that's part of the problem that we've seen consistently, that it's been so narrow in its definition and not supported by good data registries that or funding hasn't been directed toward those data registries or the data reporting systems to enable us to be proactive. And it always seems, as we've said in our submission, that we tend to be reactive when patients are at their worst condition.
Thank you, that's incredibly useful. Can I just ask one more question before I hand over to someone else? We've heard a lot about people who are diagnosed with silicosis and then, or even haven't, sort of got to the point of actually making a claim under the scheme, who want to keep their job and want to keep doing their work. Are there ever circumstances where they can be put back into the same environment, or is it really a case of once you've been diagnosed, you should not be going back into any situation where you'd be exposed to dust?
So that's actually quite an interesting question, because I've been working with some of Jane's patients as well, Dr. Moore's patients, who are the tunnellers who have been exposed to silica dust, and they have been diagnosed with silicosis, but it is relatively, in the grand scheme of silicosis, relatively mild and provides no impairment. And in that particular situation, they do actually return to the workplace in their current role with clear guidelines about dust monitoring and dust management. So the decision of whether they can return to their current role or a modified role depends, it would appear, on the severity of the illness when it's diagnosed and at every reassessment point.
I might just add to that. So I have, in the course of my work in the last 18 months, diagnosed a lot of tunnellers newly with silicosis. Almost all of those workers are asymptomatic with normal lung function, with very early changes on their CTs. My recommendation to all of these tunnellers is they should consider another occupation with low dust exposure. Overwhelmingly, their position is that they don't have another trade and they have lots of other obligations, mortgage, young children, and that they can't afford to leave the industry. And my understanding is currently, because they have no level of disability, the vocational support or retraining support that's available to them from the dust disease scheme isn't available because they've got no level of disability, or isn't adequate to allow them to not be significantly financially disadvantaged if they leave the industry. So as their managing doctor and as the liaison between themselves and the workplace and the doctor who's putting restrictions in place, I've been working very closely with the operators to allow these workers to make an informed decision to stay in the workplace as safe as we can. So that includes mandatory use of power-assisted respirators, the PAPR VersaFlows, including a daily register to confirm they are wearing it throughout their full shift. I also have implemented monthly to 3 monthly personal exposure monitoring. So those workers who are actually exposed, we're having their actual gas, like their dust levels. So I can review that every 3 months and look at their readings with them. And I'm reviewing them every 3 to 6 months with this information. Repeat lung functions, repeat CT scans in consultation with Dr. Ruby of recommended frequency. Now, it's not perfect because whilst they've got those PAPRs on, it is still a high-risk environment. But this has been the compromise that's been made. So these gentlemen, all gentlemen, I've got one lady, a cleaner. To allow them to keep their occupation because they desperately don't want to be put out of work. And I've been monitoring them closely for the last 18 months to 2 years. So far, there hasn't been any disease progression. In the event of any disease progression in any of these workers, I would have a very, very low threshold to say, look, I can't support you staying in this high work environment, risk environment any longer, and would need to look at alternative duties. The issue is what alternative duties might be available for these workers with their operators, and whether or not there would be a job for them. And that's where I really think there's a big gap with the dust disease scheme support that's available to these workers, that they have to wait until they've got a certain level of disability rather than having that opportunity to retrain.
That's very good evidence.
Very useful, thank you.
Can I ask it just, so these patients coming to you because you're involved in a health monitoring scheme, so how does the disease burden look over the total population of the people in the scheme? And sort of follow on, and that is there specific worker functions that appear to be much more exposed and what are they?
Absolutely. So I actually did a case series analysis for one of the projects that I worked on for all the workers who had been diagnosed with silicosis to look at the demographics and the kind of exposure history they were having. The average age was late 30s, early 40s. The average exposure, and I think that's something important as well, a lot of tunnellers haven't just worked in tunnelling. A lot of them jump between tunnelling and mining, and so they have quite broad exposure histories. So on average,
Sorry, that's underground mining?
Underground
Yep.
mining, coal mining and hard rock.
Yep.
They're very similar roles, and a lot of the machine operators jump between the two as projects become available.
Yep.
So the average years of, and this is a very small data set, I would say, this is just based on 10 workers, but the average time exposed to silica dust was 15 years. The average time in tunnelling was just, sorry, off the top of my head, somewhere between 5 to 10 years. By far and away, the workers who are overrepresented in this group are road header operators. The other group were mechanical fitters, who aren't necessarily the obvious group, but my theory, and it's only a theory, is that they do a lot of work around the scrubbers. When the scrubbers break down, they're the guys that go in there and fix it, and so perhaps they're exposed to the dust through that.
Okay.
And related maintenance work that goes with those pieces of machinery.
But
Sorry.
when I did a very rough prevalence based on the cohort of patients that I had with either possible very early changes but not able to confirm the diagnosis, but someone we're going to watch very closely, or confirm silicosis, the prevalence in the group that I was doing health surveillance on was 8%, so not insignificant.
I note, in the Thoracic Society submission, there's a suggestion about capping worker hours. I wonder whether Dr. C or Dr. Thiru, whether you could speak to that proposal.
Essentially, so a lot of these workers that I've seen tend to work long hours. They tend to do 12-hour days, 7 days in a row, sometimes up to 10, and then have longer breaks. The reason for that recommendation in particular is it limits the period of time that they're exposed to the dust, and it also gives a period of time where they're not exposed to the dust, where the natural mechanisms in the airway can work towards clearing out the dust. So they're sort of, while they are exposed, at least there is a little bit of time frame to clear it out afterwards, and that's the reason for that recommendation.
Right, so it's a capping in terms of daily hours, not like a radiographer who might have to, like has a maximum number of hours that they work, and then they really have to get out of the industry.
Yeah, it's. I mean, look, potentially that may become relevant in the future, but I think at present the situation is mainly about sort of protecting them in the day to day.
Right. Okay.
Yeah.
Can I just those on the video link? Any observations or related comments you'd like to make over the last 5-10 minutes of questioning we've had? Dr. C.
Yes, thanks, Chair. I would like to draw the committee's attention to the early reports coming from the National Occupational Respiratory Disease Registry, which started in May, and the early data is, so there's mandatory notifications for silicosis, and early data already shows the main industries is construction and manufacturing, and the main roles are stone processing machine operators and stonemasons, and then those who are involved in cutting, shaping and sawing. And also the leading state for notifications is New South Wales, which is leading with 9 notifications for silicosis, where all the other states are under 5 at the moment. So the registry will continue to be improved in years to come, but it will be able to provide data for the committee to help them understand industries and trades which are leading being affected by exposures.
Thank you for that. We might go to Dr. Driscoll and then back to Mr. Brook. So Dr. Driscoll, you're next.
Okay, thank you. I just wanted to add a couple of things. One is the mention that James said of about roughly 8% in the small group, which is not atypical based on the little information we have in Australia, that a 10% prevalence of silicosis in tunnel workers is unfortunately what seems to have been found. So that doesn't surprise me. The other thing we were talking about, well, what to do with people who might have low levels of silicosis, and I don't disagree with what we said, but it's just worthwhile keeping in mind with them and for all the workers that people only develop silicosis if they're exposed to silica. And in tunnelers, you're not going to be able to avoid exposure entirely, but we have the systems in place, we know what to do to keep exposure the lower levels of whatever level. And the fact that people have developed silicosis and are developing silicosis is clearly reflecting a failure in those control mechanisms. And I'm not sure if that's directly in the focus of the committee and the inquiry we're doing now, but I just think it's very important that we keep that in mind.
No, it's very
that
relevant.
every one of these cases is, one, preventable, and two, reflecting a failure of the control that we should be able to have in place.
No, thank you. Mr. Brooke, did you have some additional comments?
Just two additional comments. I think it's really important to acknowledge that this workforce is at times transient and will go from state to state, and that the transfer of information, histories and data for patients is at best a leaking boat. And it is subject to the patient declaring their previous medical history or the clinician being able to find that. And just to, I guess the other point we would make, about 30% of everyone that is calling our specialist occupational lung disease nurse is now coming out of tunnelling. And that is increasingly stepping up. And as we see more data beginning to appear in the occupational lung disease registry, it will be really good to be able to identify not just those industries, but those workplaces that have repeated numbers of case presentations. Because at this stage, we're not at that point of having the granularity of understanding, is it firm A or corporation B that has better or worse practices.
Can I just follow on with a question, Mr. Brooke, and forgive me, I probably should know the answer to this, but with respect to the registry as it's set up here in New South Wales, does it contain the fields within it to enable the specificity of the type of information that you've just said would be important in terms of the monitoring of these affected workers, or you don't know the answer to that?
I might ask my clinical colleagues, but my understanding is that the information doesn't have that granularity.
Right. Well, that's something. Perhaps if I just press on then on that line of questioning about the registry here in New South Wales and how it's set up and it's operating, do any of the witnesses have any insights into, from their practical experience of working through directly or indirectly with the registry, any insights into how it operates? You can be as frank as you like too, Doctor.
So I was going to say, I will be frank. I haven't actually registered for the registry myself yet. We received an email a few months ago saying that the registry was up and running and that we no longer needed to inform Safe Work New South Wales, which I thought was a little bit premature because there should surely be a little bit of an overlap while clinicians acclimatise with the new process.
Sorry, can I just say, who sent you the email? Or if you can recall, as best you can. I mean, if you need to go back.
New South Wales Department of Health.
Right.
Yeah, so in the last few months, they sent an email essentially saying we no longer needed to notify New South Wales Health, sorry, not Safe Work.
Right.
Because there was now the national online registry, which is done online, as opposed to paper forms, which we used to fill out before. But registering, and to be fair, I have been shown how to register for it, but the registry link is associated with my personal Services New South Wales account, which creates an issue. In terms of if I want to, for example, enable a proxy person to help with the notifications, so it creates extra work to the practitioner themselves, and it creates sort of a privacy issue if you would try to enable a proxy in its current form.
So just to understand, so this work now has fallen onto your shoulders, and no doubt with your responsibilities, you're pressed with a lot of commitments to your time, so it's not reflecting on you, but I mean, that to do that and keep that updated at the level of professionalism that you would want it to be maintained at, that would become a bit of an impulse, wouldn't it?
Yeah. So
over time, anyway.
Exactly. I mean, look, there are a number of limitations with the registry, some of them purely to do with that, the fact that it's now on the shoulders of the practitioner to do it themselves after each assessment. But there's also so many limitations in terms of what would be classified as an occupational lung disease and whether the practitioner would make a notification for a lung disease or make the connection to an occupational exposure in order for that to be then registered with the registry. And then there are other limitations, including patients not wanting to come forward because it can affect their job prospects and career progression.
I think Mr. Brooke wanted to just jump in.
Yeah, I was going to say.
Just jump in and back to.
Yeah.
Mr. Chair, I'm going to try to wrap a ring of protection around our clinical colleagues and say it as clearly as I possibly can.
Please do.
It is a mandatory reporting requirement under Commonwealth legislation that clinicians complete that report. Mm-hmm. However, they are not compensated for it, and it only looks at one lung disease at the moment, which is silicosis. So I think we need to understand that whilst it's in its very early days, our clinical colleagues, my healthcare professional colleagues, have been given an impost, which they will complete because they're acting in the best interest of patients. Mm-hmm. But it would have been good had that have come with some form of NBS item or other reimbursement.
And I appreciate that contribution, really do. Any other final questions or comments about the registry before we move on?
Sorry, can I just I just wanted to clarify that, because when the regulation came out, I made a point of going and talking to Safe Work about this because I was worried about that lack of overlap between the two reporting requirements. So it's very disappointing to hear that has in fact rolled out in not a very effective way. Does that mean though that those registrations aren't being made? So if you're not registered yet, does that mean that you have cases you haven't yet notified?
No, I think essentially the situation now is when I need to notify, I will probably register at that point.
Okay.
Yeah.
All right, okay. But you have an obstacle to registering because of their making you do it through Service New South Wales?
Yeah, it's partly that and the whole registration process. So previously I would just fill out a paper form when I saw the patient or right immediately afterwards and give it to our administrative staff to send it on to the requisite fax or email address. Whereas now I would need to log on to that and go through the process online, and before I even get to that stage I'd have to register.
Yeah, okay.
So it sort of makes it a little bit harder to do with the patient in the room.
Okay. I have another question, but it's not on the register. So if you wanted, I think, is it Dr. Driscoll?
Sorry, Dr. Driscoll, apologies, your hand's up, sorry. Yes.
Oh, okay, sorry to pop in quick.
No, that's okay.
Mark's correct about the register only covers silicosis at the moment, but I just wanted to note that the College of Physicians and others have been pushing strongly that it should be expanded, and my understanding is that the Health Department federally agrees with that in theory. I just think it would be good for us all to do whatever we can to encourage them to actually have it in practice. That's one thing. And the second thing, Mr. Chair, you're asking about, was there information that would allow us to understand the exposure circumstances? And that is certainly something that we've pushed strongly have included in the register. I actually haven't got the field in front of me, so I can't remember exactly what in there. But my understanding is that there are fields can be completed to provide data that might be useful, but that it's not required. And as Mark was saying, because there's no recompense, and I'm not trying to push that barrow, but just noting realistically it takes time. And either the resources need to be put in the at the register end to support people providing the information, or there needs to be some incentive for those people to have the time to put the information in. So that's what we really need from a prevention point of view.
Thank you for that.
Thank you. Thank you. Just coming back to the evidence you were giving earlier, Dr. Muir, these workers who have the early stages of silicosis, and you were talking about how you could put them back into that environment if there was extra protection, etc. Which of course then begs the question: why don't all workers have that extra level of protection so that they don't get this in the first place?
That is, I mean, there has been a progression on most sites now where that protection is standard and mandatory for all high-risk workers. So certainly all the sites I've been working on now, VersaFlows, PAPRs, are mandatory for high-risk workers. If on some projects, other projects, they take a more risk-based approach, my understanding, and if the dust levels have been monitored and they are consistently below a certain level, they've been sticking with the P2 N95 dust masks. So there has definitely been a big, I suppose, recognition of or upgrade in respiratory protection. What I would say though is there is an over-reliance on respiratory protection. That should be the last level of defence, and there are many scenarios where workers do remove their respiratory protection, either to communicate to one another, they're incredibly difficult to hear in, or I will commonly hear from the electricians and the fitters, they need to get into very small tight spaces, and it can be very difficult to get in with these big bulky headsets. And one of the issues is now there's no longer a clean-shaven policy because all of the workers are in these, that there's no longer the backup of putting on that P2 mask when they can't get into the small spaces. So, and this is why we don't want to rely on respiratory protection as an adequate control, because it's not perfect and there's times that it will fail, which is why the higher order controls need to be better.
Yeah, okay. Thank you.
Any further questions? I've got further questions. Anyone? Members got? The issue of the challenge with respect to the tunnelling exposure for workers, there's much tunnelling work being done much tunnelling work being commenced and completed in New South Wales, much underway, and one may reasonably speculate there could be more into the future. So a lot's been done, but there's still plenty being done and may come. A fear that I have, and speak for myself, others may or may not share it, is that I've used this sort of comment before. There's been a long tail associated with dealing with the manufactured stone, and it moved with what I judge to be reasonably rapidly when the Commonwealth came to terms and got people around the table, and the consensus concretised, and then there was the movement towards the banning, and much flowed from that as we find ourselves where we are today. Given that New South Wales is the sort of heartland for the tunnelling, and that we can see things coming down the pipeline, the impact on workers, surely there's a problem, would there not be, for New South Wales to accept the proposition that, listen, this in all good time will move, the state and federal will sort of come to a point where we're getting this addressed far better than we are now, but looking down the line, that could be quite a while. Surely there's an argument that New South Wales, whilst we obviously want to work and have comity with the other jurisdictions, have got so much skin in the game here that well, dare I say, obligatory on the government to move on this and move with some serious momentum to do what needs to be done to address it. I'm just wondering, that's an open question. I'd welcome any comments that people might have about that proposition. Starting with whoever would like to jump in. Or disagree, and please explain.
I think
I'll jump in if that's okay.
Yeah, please do, yeah.
Yes, I would probably even go further than what you said, Mr. Chair, and say I think there's an obligation for the government, whichever government it is, but particularly New South Wales, to act to make sure that exposures are appropriately controlled so that people are not developing silicosis, and also keeping in mind that exposure to silicosis also increases the risk of lung cancer. So it's not just the silicosis problem.
Yeah.
And yeah, I'm just repeating what I said before, that we know what to do, we know how to do it, we know how to control the exposure. And all the cases of silicosis are showing that for whatever reason, these control measures haven't been put in place appropriately. And so I think, as well as encouraging the employers to make sure they have the correct systems in place and knowing the importance of that, also it's important that there be strong enforcement, and hopefully the enforcement wouldn't be needed, but having strong enforcement I think is important to ensure that this over control is appropriate. So I do strongly support what
please, yes, Mr. Brook, yeah.
Only, Mr. Chair, that I think we do need to refer to the National Silica Strategy that the Commonwealth and the states and territories have recently signed up to, and it gives us the three aims. The priority number one is workplace risk reduction. And I think it's really, recently Professor Driscoll and colleagues worked with the Lung Foundation to set up the national research priorities for silicosis. And the industries and the impact or prevalence across industries is one of those key research questions. So what are high risk industries? How can a worker return safely? Under what circumstances, if at all? Are all things that the research and occupational physicians want to be able to see investment in. So I guess from our perspective, those first four priorities of workplace risk reduction, education and awareness, health monitoring, screening, surveillance and support, and research and development, we would warmly welcome if New South Wales worked with the Commonwealth to start leading the way, given it has a very high number of large and ongoing tunnelling projects.
Any other comment? Like to jump in, Honourable?
Yeah, I wanted to ask about. I think in one of the opening statements there was a suggestion there's no safe exposure level. We have a workplace exposure standard that was set on the basis that it was what we could measure at the time. I heard evidence earlier today that the technology is now advanced. We can measure at much finer particle sizes. So do you think there's any merit in changing the workplace exposure standard, lowering it further?
Yes. We know that silica dust, the health risks of silica dust is accumulative. And so there's plenty of research that shows the level at which there is no risk is much lower than 0.05, which is the current limit, closer to 0.02 or 0.025.
Yeah.
But also, we know that I'm obviously predisposed to thinking about tunnellers because that's the group that I'm working with. They're starting work at their late teens, early 20s for 40 years. And there's that cumulative dust exposure. And so obviously the goal is to reduce dust exposure as much as possible. And having that lower level of daily dust is going to reduce the cumulative dust exposure for workers and reduce their risk over their working lifetime.
Dr. Driscoll?
Yep.
Yes, I support what Jane said, and just to add that from the positive business point of view, we strongly think there should be a health place limit. There's very good, and we strongly think that any health place limit should be based on the public evidence. And there's very good evidence to show that 0.05 is too high, and the very good evidence that we support having a standard at about 0.025. I think that's what most people say, some people might say 0.02. I'm not a hygienist, so I can't really speak to the controversy about whether it was possible to measure down to that level, but I'm pretty confident from what I've read and been told that it is. And so I do think that there's very good reason that the standard should be at 0.05 and not at 0.0. Thank you.
Mr. Brooks, I think you had the thumbs up emoji, but that doesn't get picked up in the Hansard, so I might give you an opportunity to put that on the record.
Yes,
please do, yes.
Yeah, one of the things, Mr. Chair, that again the national strategy wants to look at is reducing that exposure level to 0.25, 0.25. It is overseas. It is certainly becoming the norm in most developing countries. So most developed countries, we need to be able to adopt international best practice.
Is there any dissent on the panel? No one disagrees with that? Right.
Can I just go back and re-prosecute, hopefully more effectively, my argument that I did earlier about New South Wales having such skin in the game with respect to the tunnelling work it does and the consequential exposure of workers, that there may be, I don't say there will, but there may be, through working through, as one needs to do, patiently and correctly through a national framework to deal with this matter, I won't say deliberate for a moment, but just because we've got 6 states, 2 territories in the Commonwealth, so effectively 9 jurisdictions operating to wrestle with this, it is going to have an inhibiting effect on the time taken to come to some specificity around certain key aspects of this, as opposed to if New South Wales, and I'm not just saying go it alone because we obviously operate within the Commonwealth, but the real fear being the additional time that's taken, as we saw in the context of the manufactured stone, and for the citizens of New South Wales and for the government of New South Wales, whoever the government of the day is, that's something that ought to be pushed back on, because there are now many tunnellers burrowing around in our metropolitan area right now being exposed, and to think that we just may have a brake put on the speed at which this can be addressed, I find pretty challenging. Or am I missing something here?
No, I agree. New South Wales has the most skin in the game currently, and I think it would be really beneficial for us to lead here and start the process. There's other tunnelling projects starting in other states. So I should mention a lot of my workers, a lot of the projects I'm working on are finishing, and they're leaving the state to go to other tunnelling projects. So there's new projects starting in Victoria, new projects starting in Adelaide.
Right.
And so the problem will start to be seen in other states.
Yeah.
I think we've had that 20-year head start on these infrastructure projects, and we would serve the workers well if we can start putting our learnings into action ready for the other states to take on board.
Yeah, I mean, I'm not arguing against the national approach, and national because we obviously are a federation, but in some sense, and this might sound an odd way to put it, but we have a comparative advantage with the disadvantage being the exposure, but we've got a comparative advantage because we've got so much experience in dealing with it, and to sort of not, in a sense, take that and use it to advance the cause, if we can get the other states on board through a national approach, would obviously, I would have thought, be something that we should at least try and explore. I'm just conscious of the time, and it's been a very, very valuable session, I have to say. Any of the members got any final questions they'd like to ask? Well, if not, on behalf of the committee, thank you all very much.
Can I add one point?
Please,
Sorry, I've been
please,
meaning
Dr.
to add
Miller.
it, and one of the biggest limitations for doing health surveillance is the lack of a central register for the results of the health surveillance, and that's one of my biggest issues that I have. So I see a worker, I'm nominated by their employer to see them, so often I will only have the results for the duration of their employment with that employer to refer to and look for that longitudinal change, which is a key part of health surveillance. So you've got, Queensland Coal, resources, they have a central repository where all the spirometries must go into there, so you can see for the duration of the employment what the lung function has been, what the previous imaging has been, and look for changes. One of the biggest limitations, there's no connection of the people doing the health surveillance. It's with the individual medical organisation, whether it's iCare or my company or another private company. And I will often reach out to other companies to get old results, but again, it's very, very time consuming, and it's really difficult to make that decision when you're there with the worker, whereas if there was a central register to follow these workers through, and as I say, they're very transient, so each tunnelling project is 2 to 3 years, and then they go to the next one, and then they go to the next one, and there's an absolute disconnect between each of those jobs and no ability to follow through their medicine. So whilst I think the National Register for Silicosis has been a really big step, I think the next step needs to be where the results of health surveillance go into a central register so we can follow workers through their career, rather than, because a lot of, I know workers have told me that they're leaving, going for a new job, and they're not going to declare their silicosis diagnosis, and I can't tell, it's not my, I can't, it's their personal medical information, and they're making an informed decision. So I think that's a really important gap.
Yes, well, particularly with the needing that continuity of information and being able to, from a medically scientific point of view, track what's actually happening with some.
And we do it in mining, so we should be able to do it for all silica workers.
Sure we can. Well, on that note, thank you all very much. You've brought some serious horsepower to the inquiry this afternoon, lots of experience and knowledge and information, and appreciate that very, very much, and all the wonderful work you do in your respective organisations. Can I indicate, I expect there'll be some supplementary questions arising from members having read the Hansard and wanting to do a bit of follow-up, so if it's okay with you, through our Secretariat, we'll follow that up with you and provide you with a suitable amount of time to consider those questions and provide answers back. So once again, on behalf of the committee, thank you very much. Thank you.
Thank you.
Thanks. Thank you all, one and all. Yep.
Thanks, Mr. Chairman.
Afternoon tea. Sorry, Hansard, yeah. Thanks, Hansard. Can I welcome everybody back to what is the final session for today's hearing for our inquiry. And can I welcome our final set of witnesses for today, last but certainly not least, representatives from Safe Work New South Wales. We've got with us Mr. Curtin, who is the is it Assistant Deputy?
Acting Deputy.
Acting Deputy Secretary of Safe Work New South Wales, and Mr. Nand, in his capacity as the Manager of Occupational Health and Safety Environment Team, Specialist Harm Prevention Director at Safe Work New South Wales. So thank you, gentlemen, both for coming along. Appreciate you carving out some time for us. Now, we've received the submission from Safe Work that you'd be aware of, and that's been processed. That's submission number 13, and stands as a submission out to the inquiry being processed and uploaded onto the inquiry's webpage. What we'll do, if you're agreeable, is that we'll go through the formality of having you sworn or affirmed in for your evidence, and then we'll provide for an opening statement or statements if you wish to do so, and then run with some questioning, which we'll share between ourselves, running through at about 4:30. If that's is that agreeable? Is that okay? Excellent. Okay. Well, listen, we'll deal with that formality then. So, Mr. Curtin, get you know, although I've just gone through it, your name, title, and then swear either an oath or affirmation, whichever you prefer, the words of which should be before you. So, over to you.
Thank you, Chair. Good afternoon. Trent Curtin, Acting Deputy Secretary for Safe Work New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And Mr. Nand.
Okay. Akhilesh Nand, Manager Occupational Health and Environment Team, Specialist Harm Prevention Directorate, Safe Work New South Wales.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks, Sean. That's great. So, an opening statement, if you would like to do so. Obviously the submission can be taken as read, so add to it as you see fit, and then we'll open up for some questioning.
Thank you. Good afternoon, everyone, and thank you for the opportunity to appear before the committee today. Silica remains a high priority for Safe Work New South Wales and the New South Wales Government. This year, the New South Wales Government has committed an additional $2.5 million to support Safe Work's enforcement team to ensure the enforcement of the ban of engineered stone and stronger silica regulations. Our efforts are always guided by the Australian Work Health and Safety Strategy and the recently launched Safe Work New South Wales 5-year strategic plan and our annual regulatory statement, where silica is called out as one of our regulatory priorities this year. We are committed to achieving no new cases of accelerated silicosis by 2033. Significant progress has been made in regulatory reform since the last committee hearing of 2021. A code of practice for managing risks of respirable crystalline silica was published in 2022. The Work Health and Safety Act was amended to establish a silica worker register framework in 2023. In June 2024, reporting requirements for silicosis cases through the National Occupational Respiratory Disease Registry were implemented. On 1st of July this year, a prohibition on engineered stone with over 1% silica content was implemented. And on the 1st of September this year, strengthening of the Work Health and Safety Regulation to capture high-risk crystalline silica processes for all materials across all industries was implemented. Safe Work New South Wales is currently leading the development of a silica worker register to enhance health screening and to improve protections for at-risk workers. Consultation closed on the 3rd of November with input from industry, unions and health professionals. And we're working closely with iCare in the design of the register to make sure that we can track silica exposure and enable timely health screenings. Importantly, tunnelling workers will be captured by the register where they're also exposed to high-risk crystalline silica processing. You'll be aware that Safe Work New South Wales is going through a period of reform, guided by the McDougall Review and the recent Audit Office performance audit. We've implemented, since those reports were released, a scalable organisational restructure which has resulted in the increase in the number of Safe Work inspectors from the previous 370 to 418 inspectors within our existing budget. We've established an operational intelligence function and improved data governance to better target regulatory activities. We're increasing our focus on high-risk workplaces and repeat offenders, and we've secured $4.4 million from the government to redesign SafeWorks technology platforms. We'll be working on strengthening our partnerships with stakeholders particularly health and safety representatives and union delegates, with a new team dedicated to that. And that was evidenced by a recent health and safety representative training refresher that we did with Unions New South Wales, where we had 200 health and safety representatives from across New South Wales attend. We're in the process of setting up an interim tripartite reference group with representatives from unions, industry, WHS experts, and those with lived experience to make sure that we further guide SafeWorks reforms and regulatory priorities. Inquiry submissions have highlighted that there's more to do to improve awareness among PCBUs and workers, particularly in the tunnelling industry. With engineered stone now banned and a number of education and enforcement activities taken, our new silica compliance team will expand its focus on other industries, starting with tunnelling. Regarding information access concerns raised in the media in the last week or so, SafeWork New South Wales is restricted by confidentiality provisions under the Work Health and Safety Act when considering whether to release information that we've obtained under notices and where consent hasn't been given by PCBUs to release that information. Importantly though, PCBUs have a specific obligation under Clause 50 of the WHS regulation to ensure that air monitoring carried out in workplaces is readily accessible to workers who may have been exposed. This supplements existing rights for entry permit holders and health and safety representatives. And I'd like to call on workers and health and safety representatives and union delegates to report any breaches of this part of the regulations. Given the recent strengthening of the regulations from 1 September this year, requiring notification air monitoring exceedances to SafeWork New South Wales, I think there's an improved opportunity for us to work together to collaborate with unions and stakeholders to improve the way silica safety is achieved through access to air monitoring information, and we'd like to work with our stakeholders to continue to work on that. So these reforms reflect SafeWorks' commitment to working with industry, unions and other experts to improve conditions around silica-related risks and to ensure safe workplaces. And we remain dedicated to working with those people to ensure compliance and pursuing regulatory reforms to improve safety for workers. Thank you for the opportunity to be here with you today.
Thank you very much. That was a very good opening statement and scoped it out very nicely, so appreciate you doing just that. So we'll open up the questioning. Now we've got members here around the table from government, opposition, crossbench, and we'll, if you're agreeable, share the questions. They'll flow, I think, in a pretty fair and reasonable way. So we'll commence. Abigail Boyd.
Thank you very much, and good afternoon. Thank you for coming along. I just wanted to just test this issue around the GIPA and the evidence that the AWU were talking about this morning. So my understanding, and what you've just said in your opening statement as well, is that there's sort of a threshold of once you've obtained information through a notice, you are then obliged under the Act effectively to not release that information unless the PCBU has given some approval for that. Does that then mean that SafeWork has never issued under a GIPA information it's obtained through a notice without consent of the PCBU? Has there ever been an exception made, or is it just not possible?
The requirements under GIPA start with a premise to release the information that we've got, except where there are concerns in the public interest in relation to secrecy or confidentiality of information. Section 271 of the Work Health and Safety Act provides for those confidentiality clauses that provides that where SafeWork has issued notices to obtain information from PCBUs, that information is protected by those confidentiality clauses. In this case, the assessor has gone through a range of tests to determine whether the information can be released, and given that these details were obtained under notice, the Section 271 confidentiality provisions applied. Mm-hmm. That would allow them then to consult with the PCBUs that provided the information to obtain consent to release the information, and that consent was not given in this case. And therefore the determination was made based predominantly on Section 271 that those details wouldn't be released in this particular matter.
Okay,
I would have to take on notice your question as to whether we have never done that.
Thank you, that would be very helpful. We also asked the unions this morning about there is that right to be able to seek the information when you're a worker, or an HSR, or for a union official to request it. But in practice, we're told that workers are too afraid to, a lot of the time, and that even when a request is made, that there's this strange legal privilege placed over it, which doesn't seem to stack up. But the only way of then getting past that is to take legal action, which is expensive, etc., etc. Is that something you've heard about before? And is there a role for Safe Work to get in there and say, no, you can't claim legal privilege over this?
Yes, there is a role for Safe Work to play. We would like to see workers having access to the information that relate to their health and safety in workplaces, and the legislation provides for a specific clause for workers to have access to air monitoring information as it relates to their health and safety. Inspectors undertake ongoing inspections in infrastructure projects and in tunnelling, and in their observations they'll have seen air monitoring results on pinboards or other places, and they make sure that they observe those air monitoring results and that they make sure that they're available to workers. I would encourage workers that are working for an employer that's not making those air monitoring results readily available to them to make contact with Safe Work, whether that's through our 131050, or importantly, if those workers are concerned about raising information with Safe Work in this way, that we would encourage them to use the anonymous pathway through our Speak Up Save Lives app. That can be more difficult for the Safe Work inspectors to identify the particular place and time and the issue to deal with when it's anonymous, but there is an anonymous pathway for workers to use where they've got concerns.
So I'll just ask one more question, then I'll hand over so other people can get a go.
Can I just pick up on that?
But just on that, sorry, just one last question on that issue. So if basically the reason, or it looked like one of the reasons that the companies didn't want the information to be released is that it could be prejudicial, does that imply then that information's been given to Safe Work that Safe Work should have acted on, and have you acted on the information that was given to you by those companies?
So that set of information was obtained by Safe Work under notice, as I understand, for the purpose of undertaking compliance activities.
Can I just pick up on that? Because it seems odd, right? So the union makes a GIPA, they want the information, presumably on behalf of the workers. You go back to the company says no because you've obtained it under notice. Doesn't that trigger to Safe Work a suggestion that they're not providing the information to the workers and that you should be actually then initiating some form of compliance activity? Did you do that?
I can't say. I'd have to take on notice in this case whether we initiated a compliance activity. This was part of a compliance activity process in any case where we were seeking information from the PCBU to make determinations on compliance.
Doesn't Safe Work say to the employer in that circumstance, look, you should have given them the information anyway. I strongly suggest you provide the information. You're required to provide that information to workers. Surely that process should have happened if the regulator was being diligent in terms of enforcing the law.
Yeah, we would absolutely like to see more availability of this information to workers. There should be no reason why workers can't have access to information, particularly around air monitoring results. I know that Transport for New South Wales released a range of information to the AWU, and that's pleasing to see that they've got access to that information. From 1st of September, any exceedances in the WES will be required to be reported to Safe Work, and we've started to see some of those results coming through. We'd like to work over the next period with our stakeholders to find out how it is that we might best be able to use that information to provide that information to workers and to stakeholders more broadly to make sure we can look at the trend and analysis of that. Where those exceedances occur, they trigger a compliance activity, and Safe Work inspectors will be undertaking those compliance activities.
I think I was jump in.
Yeah, just a quick
on that point.
follow-up to this. So a worker uses your anonymous complaint line or makes a direct complaint. You then approach the PCBU for the information about air monitoring. If you have to get that under a notice, how does the worker ever find out what the air quality is?
The information we're obtaining under notice might be a whole range of things in terms of...
No, but in that example, because you said the worker can use the information, the anonymous complaint line, or can come to you, how do you then get the information and give it to the worker?
So we would engage with the PCBU to ensure that they're complying with their obligations to provide that information directly to the workers. If they're in breach of that,
and how
there's
do
a
you
penalty.
follow up to make sure that the worker who cannot get the information about the air quality gets that information?
We would do an inspection and we would speak to the workers about that. If it was anonymous, we would speak to a sample of workers available or the health and safety representatives or union delegates.
So when you say you would speak to the workers, you would speak to them and give them the air monitoring information?
Yes, we'd expect the PCBU to do that, but yes, if we had to intervene to obtain that information and pass it to them, that
But
would be
if you
quite
obtain that information under notice, how do you give that to the workers?
In this case, we wouldn't need to obtain it under notice. If we're entering the workplace, they're up on pin boards and they're available to the workers.
Well,
if for some
there
reason
may be some places where they're up on pin boards, but we've heard evidence that they're clearly not up on pin boards in every workplace. And I suggest if a worker is ringing you, there is not current information up on pin boards, otherwise there'd be no need for the complaint.
Yeah.
in which case we could issue an improvement notice and ensure that the PCBU provides that information.
From
to
the time a worker calls you, what is the time lag between calling you and that worker receiving the information about the air monitoring?
I'm not sure. It's a hypothetical.
Well, no,
it depends on.
it's a direct. You've said the mechanism is call us if you can't get it from the PCBU. How long would that take for the worker to get the air monitoring information?
We would triage that through our process. It could be 1 to 3 days before we attended. Usually 1 day we would attend and we'd be able to obtain that information.
So you obtain the information in 1 day and the PCBU will just hand it across to you, no questions asked?
If it's available, if they weren't going to hand it over to us, we would issue a Section 155 notice and obtain it under notice.
And if you obtain it under notice, how does the worker get it?
They're required to provide it to the worker, and so we could issue them with a penalty for not doing that, and we could issue them with an improvement notice to make sure that they do
So
that.
you can't give it to the union under a GIPA, but you can give it to the worker?
The PCBU can provide it directly to the worker.
But they didn't in the case that you're actually, like you've got an actual example. You say you're speaking in, this is what we would do, this is what we would do theoretically, but in the actual example, you didn't do that.
So
why not?
In the GIPA example, this is information obtained in relation to 2015 to 2020, and that information was obtained under notice. It's a new requirement from 1 September of this year to provide the information to workers under the regulations.
But they were supposed to provide that information anyway. The worker should have access to that information under the current arrangements. Prior to that change, there was a right for the worker to have that, and Safe Workers failed to enforce that because the AWU asked for the information, they were denied it, and the workers clearly didn't have it, and Safe Work hasn't done anything about it. Like, what do you say to that regulatory failure?
Under this particular example, it's through the GIPA process that they requested information obtained under notice. That information could be different to the information available to the PCBU or to Transport for New South Wales. They were able to obtain that information from Transport for New South Wales and through the PCBU. I would certainly encourage, where there are circumstances where workers who have a right to the information of air monitoring information and they're unable to get that information, that they should contact Safe Work New South Wales and we can go out and make sure that they get access to that information. The example here with the GIPA is a different circumstance where information was obtained under notice for the purpose of compliance activities.
But are you saying that the process for dealing with the GIPA was completely separate and siloed from the actual enforcement process, which was the object of the reasons behind the union seeking the information? Like, it seems like the GIPA consideration was made over here, and the actual question of why the information was being sought, no one in the organisation bothered to think, oh, okay, well, why are they asking for this? Clearly there's a problem over here, let's do something about it.
Yes, and we should absolutely be making sure that those workers got access to that information.
Can I just clarify?
So I think the Honourable was to jump in.
Just on the following on of that.
Point.
Sorry to interrupt.
Right.
Did you follow it up? We should have. Did you?
Yes, I have followed this up. So as a result of it coming to my attention, I've initiated a request for service for the team to make sure they follow up with those PCBUs to make sure they're compliant with our current laws in relation to providing information to the workers.
Can I just clarify your responses though? Is there a difference then here between the right to receive current information versus the right to receive historical information? Is that what the difference is here? So we had a 2015 to 20, that was obtained by you, but isn't something that could be obtained by a worker? Or could a worker go in and say, I want this data from these 5 years?
Under the new regulations,
workers are entitled to access to that information, and an employer has to keep that information for 30 years.
So when you say that information, does it apply, so under those current regulations, is a worker entitled to receive the 2015 to 2020 data?
So that's historic information.
No, that,
if the PCBU has the data and the worker is working on site, they are entitled to ask for and look at that information.
Including historic information.
Yes.
Okay, which is then goes directly to Anthony's point that clearly then the moment that you receive a GIPA request from a union for information, that should tip you off that the PCBU hasn't been giving the information to the worker. So that's at that moment you should be going in and asking why.
Yeah, and we're in the process of asking why at the moment, why those people weren't given access to that information. Yep. The consultative
Well, while we're on that then, so we've heard from AWU this morning that they successfully under GIPA got information from Transport for New South Wales, that released data that show high exposure rates in many tunnelling projects. As a regulator and enforcer of the regulations, what have you done about that information that's come to you then?
Yeah, so I've initiated a request for service to the team. We've got an ongoing presence in tunnelling projects and in other infrastructure projects in New South Wales to make sure that organisations are complying with the laws and the regulations. In regards to that specific information, I've initiated a request for service for the team to go out and specifically look into that to make sure that those exceedances are checked and to make sure that the right conditions are in place.
Well, hang on, no, this has all happened already. Yes. Right? I'm not worried about what you're doing in the future. What we have here is evidence provided by Transport for New South Wales under GIPA of overexposure of dangerous levels of dust containing silica. You are the regulator. That information is now public. What are you doing about the investigation of those breaches in the past? What have you done about that?
Yeah, that's what we're looking into at the moment. So the team will engage with the PCBU, workers and union representatives. I've initiated contact with the AWU to talk to them about their concerns and how we might work together to look at them getting access to the information that
They've already got the access to the information. The GIPA's provided it.
And I'd like to see them continue to get ongoing access through the current regulations.
We're not worried about current. You're not answering my question. There has been a clear breach of the regulations in the workplace of which you are responsible for enforcing. What investigations are you undertaking at present about those previous breaches of the regulations?
Yeah, we're undertaking compliance activities at the moment to look into those previous breaches of the regulations.
Explain to us how then. What are you doing? What in practice are you doing?
So our teams will usually go in to talk to workers. They'll talk to the health and safety representatives. They'll make observations in the workplace. They'll request documents.
Mate, well, stop. Sorry to rudely interrupt because I want to give you fairness, but they're not making observations in the workplace. We're talking about previous breaches. What you observe today is not what was observed 2 or 3 years ago under that information provided by Transport for New South Wales, a government entity. They provided that information, that there has been a number of high exposure levels to the safety of workers. You, sir, and your department are responsible for that. What are you doing about those breaches?
Our role is to make sure that when we those things are identified to us, that we make sure that those organisations are compliant with our laws, and where they've been in breach of those laws.
Well, clearly they haven't complied. They haven't.
Where they've been in breach of those laws and we form the opinion that we should undertake an investigation, we'll undertake the investigation, and then information will be gathered and the investigation may result in a prosecution.
So we could sit here as the parliamentary committee that has responsibility for overseeing the dust diseases scheme with a great deal of confidence that you and your department are back capturing and back investigating those breaches from the past. And we can expect to receive from you at some time in the future a detailed report and response as to those breaches that have clearly happened in the past as identified by Transport for New South Wales.
Those breaches are being looked into at the moment, yes.
So at the next committee hearing, you'll be able to produce to us documentation and evidence as to the depth of those investigations, the results of those investigations, and one would expect, if there's been numerous high exposure rates, potential prosecutions on behalf of, prosecutions because of those breaches? Can we expect to see that?
That'll depend on the information that becomes available during the investigation process.
What happens with exceedances? Sorry, just a basic question, but if there's a number of exceedances, at what point is a penalty imposed? So what happens? So at the moment you're getting notified of exceedances, correct?
Correct.
How many have you received since the scheme went
We've
live?
received 36 since the 1st of September.
Okay, so of those 36 exceedances, how many of them are in tunnelling?
I would have to check.
We don't have that breakdown with us, but we can take that on notice.
Okay, and so you get the notification, and then what do you do?
We undertake a compliance activity, so we go into that organisation and we check that they've got the right systems in place, that the right ventilation's in place, that the right respiratory protective equipment's been used, that workers have been consulted on the work health and safety systems, and make sure that the right systems are in place to minimise those exceedances.
And so at what point would a penalty apply for the exceedance?
It would depend on the observations made by the inspector at the time as to whether there's been a breach of the regulations that have a penalty attached.
Okay, I see. So if there's been an exceedance, you get told about it. And if, for example, you went in and there had been a sort of a blatant not using of appropriate technology or something to, manage the filtration, I don't know how it works, then that might lead to a penalty. But in most cases, would it just be advice in terms of you need to do a bit more of this, or what are we?
It could involve advice, but usually if there's been a breach, it could involve the issuing of an improvement notice. If there's an imminent threat, it could result in a prohibition notice, or it could result in a penalty notice. There's a whole range of regulatory tools available to us in terms
How
of
many
undertaking.
penalty notices have been issued in relation to tunnelling and exposure?
I don't have that breakdown with us here today. We'd have to take that on notice specifically.
Can I just quickly ask, of the 36 that you've been notified, how many of those are repeat notifications, so the same PCBU?
This process only commenced 2 months ago, and I haven't been able to have a look at the breakdown of the data.
I'm sorry, with respect, 1st of September, 36 notifications, 3 months, and you can't tell us how many of it's the same PCBU that has exceeded more than once?
It could well be multiple PCBUs. It's a data. The notifications go to a different team than myself. But as the previous witnesses have explained, especially Ms. Kate Cole, she's a well-known hygienist. One of the biggest challenges is that the exposure assessment that is done today, the site may not get the reports back on that until a couple of weeks later.
Thank you. I think we're focusing on enforcement, and I would think that a PCBU who had a pattern of exceedances would be highly relevant for enforcement. Of the 36 notifications, how many improvement notices have been issued?
I'd have to look into that. I don't know that there's been any improvement notices at this point in time in relation to those 36 exceedances. We're in the process of undertaking compliance inspections.
So how long do these compliance inspections take?
Well, they get prioritised and we work through them. The Silica team.
So you notified on the 1st of September. We're sitting here on the 29th of November. Has there been a compliance inspection from a 1st of September notification?
We have been in tunnels between 1st of September and today. I'd have to get details exactly when that's occurred, but we have had inspectors.
Have you had a completed compliance process in relation to any of the exceedances that have been notified since the 1st of September?
I'd have to check because...
If you could, thank you.
Yeah.
How does it operate to... Sorry, just one... How does it operate to protect workers then? If there's been an exceedance, at what point do workers know that there's been an exceedance?
When the inspectors receive the exceedance, they are triaging those matters, and they're programmed to go into those tunnels to check the work health and safety systems, have discussions with the workers and representatives.
It could be months then.
Well, not necessarily. We've, in early September with the new regulations coming in, we had focused some attention on engineering stone to ensure compliance in that area as well, given the new bans and the regulations that have come in there. And now we're looking to shift our focus towards tunnelling to make sure we've got the right
regulation enforcement in place there. So that will take into account those exceedances in the design of those compliance activities.
Mr. Curtin?
Just give a bit of context, and I appreciate that you're doing best endeavours to sort of respond to probing questions, but to give the context of the probing questions, I mean, the committee, some of the members have been on the committee for a long period of time over a series of cycles of dealing with reviews, and very much were there, some going back to when the whole momentum was still pretty latent with respect to dealing with manufactured stone, and Honourable Rod Roberts in particular pushed very hard over various cycles of inquiries along with others. Chris Rath was the chair in the previous parliament. So there is a degree of intensity by committee members with some real basis of having seen things dealt with in a way that we would judge as being certainly unsatisfactorily very slow. Now, I mean, ultimately it got not resolved fully because obviously we've still got compliance matters, but obviously there's the ban on the manufactured stone, and that obviously was done through a process which involved states and the Commonwealth, as you know, the history to it. I suppose what's causing a degree of anxiety around the table that you might be observing is that we're saying to ourselves, we just can't, we collectively as a committee, just can't allow there to be a repeat of the whole manufacturing stone saga, if we can put it that way, which took so long to get to the point where, as plain as the nose is on our faces from the evidence, not just to this inquiry through submissions, but through what was evidence in previous inquiries, which I have to say with, I suppose, some degree of regret, we had to try and deal with what was the one moving the most rapid to get that pushed along, which was the manufacturing stone. It didn't mean that the silicosis around the mine, around quarries and tunnelling was not there, but it was a case of what we could push. Now the evidence from the unions this morning, there's a very interesting table, I think on page 4 from memory of the AWU submission, are all of the actual tunnel projects. And it's got the ones which are completed and the ones still on foot, to say nothing about those that are obviously being planned. Now, what's exercising our minds, I'm sure, for the members, is all that's on foot and what's to come, and we can sort of, rake the coals over why there's been this slowness, tepidity, lack of resourcing. We don't actually know with absolute precision why within WorkSafe there's been this, but now the belled the cat, that's really been belled pretty loudly, and understanding obviously in your roles that you've had, you're becoming more and more aware of this. The desire to push and shove, if I could use those words, and really make it very clear that we're very, very concerned. And you can sort of bet your house that when it comes to the report that we produce, without foreshadowing what's in it and its findings and recommendations, they'll be pretty strong findings and recommendations. Now, I'm not saying that in a threatening way, but there is a degree of anxiety about the speed in which this is being now dealt with, given what we know to be the case. It's like the elephant in the room. Sorry, that tended to be more of a statement than a question, but hopefully give you some context about why you're probably sensing some, firm pointed questioning to probe and push you pretty hard.
I share your passion, Mr. Donnelly. The impacts of silicosis and other diseases similar are so devastating on workers and their families and our community, and I understand the impact that's having on workers all the time. There is an obligation for employers to make sure they're providing all of the right health and safety systems in their workplaces, and where they're not doing that, we have an important role to undertake compliance and enforcement activities to ensure that we're doing that. I'd like to see increased consultation with workers and increased collaborative arrangements where workers are identifying issues and concerns and they're raising those with their employers, but importantly, if they're not getting the traction they need, that they're raising those into Safe Work, and that we've got the information and the support that we can use to go in and undertake compliance activities, and where necessary, undertake enforcement activities raising these concerns is a great opportunity for us to be able to target our attention to those areas where that might be most needed. I think the change in the regulations to allow the submission of the exceedances, where we'll be able to take those exceedances and look at where there might be patterns of concerns and opportunities for improvement. The observations of our inspectors, and Mr Nance are closer to the inspectorate than I am, but the observation of our inspectors is that there has been some improvement in tunnelling, and there's been some changes in respiratory protective equipment, in ventilation, and in atmospheric monitoring and health monitoring arrangements. But we agree that there's more to be done to make sure those workers are safe.
Can I just ask a question on the back of that then? Because so we had the SO52 and the whole thing with the GIPA with the AWU. We have two focuses in this particular dust diseases review, and one of them is in relation to tunnelling. When we asked you about exceedances, you could tell us very quickly how many you'd got since 1st September. Is your evidence that you did not seek to find out how many of those 36 were in relation to tunnelling, knowing that this is what this inquiry is about?
I just knew that there were 36 registrations on our website. I just don't have in front of me the information as to which organisations they've come from.
Okay. Because it's difficult, because we're hearing, yes, SafeWork's taking it very seriously. These are, this is an issue that you're now aware of. We think that it's probably better these days than it used to be, but then we have this live data. We have 36 instances. Where are they? And what you're telling us here is that you haven't found that out, and that's quite concerning. So, I guess, can we get on notice then some data around what the 36 are? How many are in tunnelling? How many are repeat offenders?
Yeah.
To that, let's be a bit more bespoke, because that's exactly what my next question was. You've told us since 1 September to today's date there's been 36 notifications. Can you on notice then identify each and every one of those 36 notifications, the dates they were received, the dates they were first actioned, what action's been taken so far, where the sites are, the whole details of each and every one of those notifications? Can we have that, please?
We can take that on notice.
Yeah.
Can we also...
Go.
Sorry.
Anthony.
So, Mr. Curtin, I think it's fair to say that the regulator can't be everywhere, and that the system is premised on working with a range of stakeholders in the system, one of which is HSRs, and another is the unions with their authorised officers who are able to be the eyes and ears of a broader compliance system. We heard evidence earlier from the CFMEU that one of their frustrations with the regulator is that they don't prosecute breaches of the consultation obligations. Actually, this whole question around providing information to workers is symptomatic of a disregard from employers around those sort of lower level obligations. What do you say about the question of enforcing those consultation and information provision obligations? Can you perhaps make some comment about that? And perhaps secondary to that is, have you prosecuted? What kind of compliance action have you been taking around those obligations for information provision and consultation?
There is no doubt in my mind that those organisations that are performing well in terms of health and safety and performing well as an organisation have high quality consultation mechanisms in place with their workers. In all of the organisations, large and small, that I've visited across New South Wales in this capacity, it's obvious to me that those organisations that have good consultation mechanisms are better businesses and they're safer businesses. In terms of those consultation mechanisms, we've been doing a whole lot of work to increase awareness around health and safety representatives and to provide increased support for them. In our recent restructure, we have dedicated a new team focused specifically on health and safety representatives and union delegates to provide more support for them. That team's only just started and they haven't yet filled out the number of people.
But that's, for that purpose of that team is to make sure that we're providing support to health and safety representatives who are in many businesses right across New South Wales to undertake those important functions. I know that health and safety representatives often do that in very difficult circumstances where they're an employee and they're also a representative of the employee at the same time. We are strong advocates for better consultative mechanisms. In terms of your specific question about how many that we've prosecuted for or what compliance activities, I'll take that on notice so that I can come back to you with a full answer in relation to those places where we may or where we have done compliance activities in relation to consultative mechanisms.
Mr. Mayor, just to direct a question to you. Far be it from me to be claiming any expertise in sort of running what is in fact the important role that you have and the inspectors that sort of obviously articulate into your role. But would it not be the case that given that, you know, as I said, as far as silicosis goes and its effect on workers, that the tunnelling now is the pink elephant in the room, or whatever colour elephant you want, that there is surely a case that amongst the inspectorate, and if this has been done so already, please tell me, that there is a dedicated cohort of inspectors who become essentially the inspectors with the expertise around dealing with everything to do with tunnelling. So they become, you know, the elite group, if we sort of use that phrase, of the inspectors who are trained up on all aspects of getting on top of all the matters that need to be, well, that are being submitted as issues to be got on top of in terms of tunnelling. So I wonder if you could sort of elucidate on the deployment of the inspectors, and are they receiving particular training and obtaining through that some historic knowledge about, dare I say, the lack of enthusiasm by certain companies or businesses or head contractors to cooperate, etc., etc., etc. Because all this information that's coming to us is coming to us from people who are on the job and associated with tunnelling work and what have you. So it's not as if they're state secrets. It's information which is readily available if you go and harvest it.
No. You're correct, Mr. Donnelly. There is a dedicated infrastructure team that looks
I'm talking about tunnelling.
Yes, so it is called the infrastructure team, which also looks after all the tunnelling workplaces.
No, sorry, I'm saying dedicated to tunnelling, not also tunnelling. Do you have a dedicated group of workers who occupy expectorate positions that are dedicated to dealing with what is compliance matters in tunnelling? Full stop.
They look after tunnelling plus other infrastructure sites. So, and there is one of the inspectors is a person that has got a great expertise in tunnelling because he was a former tunnelling worker himself.
Yeah, well, that's, with the greatest respect, one individual with a level of expertise, which I don't cavil with you. If you say he or she's expert, I take your word for it. But just think of all the tunnelling work which is happening under our feet right now in Sydney, and you're talking about one person.
No, but all of those inspectors in the team go through the tunnels as part of their regular work.
Suppose I'm advancing the case, is there any merit for having, given that we're dealing with something which is a present clear danger, the bell's being rung, that within safe work there be a discussion at that high level about is there efficacy or value or some, you know, good purpose in having dedicated workers in the expectorate team, you know, soiled onto the tunnelling work in New South Wales.
Mr. Donnelly, the SafeWork has a range of general inspectors that work across all sorts of industries to ensure compliance.
Yeah.
Because of the specific nature of construction industry, of a dedicated construction group, because of the very specific nature of critical infrastructure and tunnelling, we have a dedicated team focused on tunnelling. We have a separate team focused specifically on silica, and we have another team focused on engineering. So in some cases we have dedicated groups and expertise and inspectors that provide support to other parts of SafeWork New South Wales in a kind of networked approach to make sure that regardless of the issue that's being dealt with in any particular business, we've got the expertise available to support our inspectors. We think that tunnelling and infrastructure projects have such a specialist nature to them that they do need a dedicated team, and we have a dedicated team
specifically set aside predominantly for tunnelling, but for also infrastructure and renewable projects.
I don't want to hog this, and I know Abigail won't secure, but these tunnelling ones then, these individuals who are focused on tunnelling, how many of those are in that cohort?
I'd have to come back with the exact number. I think
if you could take that
10
on
or 12.
And indeed the other two categories you.
Thank you. Just we heard about the code of practice, the tunnelling code of practice, and how that was sort of promised, and then there was a change in it was maybe going to be done federally, and where are we up to with it now?
So the current status of the code of practice is that we finished consultation late last year with an industry and sector group to progress that work. There's a number of other activities underway at the moment that support and impact the tunnelling code of practice, including the National Code of Practice for silica. And so we're in the process at the moment of engaging or taking steps to engage some expertise to support the progress of that code of practice. Mr. Nan's been closer to it than I have, and he can provide more context, but we'll be progressing with gaining some expertise and bringing that group back together early next year to progress that as quickly as possible.
Yeah, if you could sort of an estimate of when it might be ready would be good to know.
Yeah, we're hoping that the code of practice will be ready before the end of next year. We don't
Next
have
year?
Next year, 12 months from now.
Yeah,
2025.
It is a very complex document. We have a document that is a national guide on tunnelling. This code of practice is an old document that was developed in 2006. We had commenced the process of updating it, but we recognised that we didn't have the technical expertise within Safe Work New South Wales, and we are sourcing the technical expertise from outside. And we will try and get that hopefully sooner than 12 months, but at least we want to no longer than that.
Is there something that can be done in terms of, frequency of air monitoring, of air quality monitoring, and simple things like the equipment that should be fitted and whether or not it should be worn on workers, those sorts of things. So there's some basic parameters that could be placed earlier, because my understanding at the moment, for example, is in relation to frequency, under the current rules you could do it once every 3 months for a single shift, and that would meet the requirements for monitoring. That's clearly insufficient. Is there something we can do more immediately to tighten up those bits of regulation?
We'll look to bring that group together as quickly as possible to progress those sorts of things. The code of practice in its totality will take some time to complete, but there's no reason that we can't bring that group together to try and progress those particular elements.
Thank you. Just a real quick one. I'm wary of the time, but we heard earlier that there was a memorandum of understanding between Comcare and Safe Work. Is that something you could provide to the committee?
Yes, we can provide the documents we've got in place between Comcare and Safe Work. We've got an ongoing relationship with them, and we, at times co-regulate in these tunnelling projects where we've got federally regulated entities working alongside state-based entities, so we can provide the documentation that outlines that process.
When you say you co-regulate, does that mean that Safe Work inspectors are able to exercise powers under the Commonwealth Act?
No. So
how
when
does that work?
if we're working on a project with a PCBU that is under the Commonwealth regulatory framework, where we do not have jurisdiction over those organisations, but we do have jurisdiction over the workers in the subcontractors, for example, that are under New South Wales regulatory framework.
Is there a capacity to effectively have an inspector exercise that kind of authority by agreement with Comcare?
They would need to be delegated under the Comcare arrangements, yes.
Is it? My question is it possible?
I understand it is, yeah. We'd have to look at it specifically, but my understanding is that is possible, yeah.
Right.
Have you ever explored that opportunity before?
Yeah, we've had discussions with them about doing that. I don't know that Comcare have had the appetite to progress that in terms of a formal arrangement, but those have been preliminary discussions. If the committee has a recommendation, we can continue to work through that
to see whether there's some improvement. What we use is, because of the current arrangements and framework, we meet with them regularly. We work collaborative with them to make sure that if there's concerns in relation to principal contractors, where we're seeing concerns in the tunnelling projects, that they're aware of those concerns, and we work as closely as we possibly can with them to share information and to meet with them regularly.
Deputy Chair, I appreciate we've gone slightly over time, so forgive us for that, but Deputy Chair...
Just a question. I know you probably didn't get to hear the evidence of the witnesses before you about the new online reporting system, the NORDR. Are you worried at all that as you're moving towards this new online reporting system from the old paper-based system, that there might be cases that slip through the cracks and it's going unreported? Do you have any views or evidence on that? Because that was some of the evidence we got from the last witnesses that might be happening.
Yeah, I don't have any evidence of that occurring. We have moved for silicosis to the national model. That creates some benefits in terms of we're more readily able to access that information faster than we were under the previous arrangements. There's some benefits in terms of workers that might move interstate and other things under the new model, but no, I'm not aware of circumstances where workers have fallen through the crack in that reporting.
Yeah, I think
mechanism.
it's because the directive was that they no longer need to report it to the Department of Health, and that may have happened a bit prematurely as people transition from the paper-based system to the online system. I don't know if there's anything you could provide to us, maybe you take it on notice about how that transition's working from and I know it's probably more Department of Health, but from one system to the next would be helpful.
We can take on notice to seek that information, yes.
Thank you.
Well, if there's no...
Just one last
Carter.
question. Are you able to give us an update on the progress of a new data management service so you can report adequately about incidences of silicosis?
You're referring to the SafeWork WSMS system?
Yeah, the response to the Auditor General's report and the issues raised there.
Yes, the government's provided $4.4 million to SafeWork to undertake a process, not just to replace the technology, but to look at our processes and systems to make sure that we've got the most efficient processes and systems for our compliance activities. That piece of work is in the process of, we're currently doing that work, and we're also scoping out a business case in order to go back to government for more funding in order to replace that technology. It's a 20-year-old technology, and by the end of this financial year we'll have that business case ready.
I think originally the agreement was the business case would be done by the 1st of December.
Yeah, that's right, and we received funding this financial year. But since we have to go through the process of undertaking the analysis, rather than buying a technology that replaces the existing technology that would not be the best use of our funding, we've gone through a process of understanding what are the right processes and systems, what's the data management, what's the data governance look like in order to build the business case.
And what's your timeline on that?
End of the financial year. 30 June next year we'll have the business case.
Thank you.
Did you want final one from...
Yeah, I just want to ask on notice if you could look at the evidence from the previous panel about reducing the workplace exposure standard, so bringing it down further, and whether there's any issues that SafeWork see associated with that, or what the sort of extent of consideration around further reduction in the workplace exposure standard is.
Yes. We'll take on notice, but just a very brief comment is we do have the lab we have a dedicated lab at SafeWork New South Wales that has the capability to do the laboratory analysis that is needed for the low exposure standards. But the bigger challenge will be in terms of monitoring compliance, because it is such a lower level and the increased reliance on personal protective equipment to provide the controls. But we'll reply on notice.
Okay, well, thanks very much. As I said, we want to press you pretty hard. I think we've done that up to a point. We can be harder, but I mean, we thought we'd not go any further. But seriously though, as I think you can appreciate, there is a depth of feeling about this because of the historic nature of what we're dealing with, and we just don't want to see a repeat. And I know that's not your intention, and we appreciate the work that you're doing, but it's just the behemoth size of the tunnelling industry in this state which is going on right now. And I've just got this awful feeling, not reflecting on you personally here, that you may not have the resources and be up to taking on the job the size that it might be. I mean, if you've got your inspectorate stretched out as far as it is, trying to cover all the myriad of calls on the demands for the Inspectorate of WorkSafe New South Wales, I just wonder how much time is capable of being devoted to dedicated work in the tunnelling industry. Now that's a political issue, obviously, to be raised, I suppose, by us through the processes and through with government. But I suppose we want you to understand, or yourselves to understand, that we want to do what we can to do the strongest nudging as possible. So that's what we need, in a sense, your full cooperation to help us understand the complexity and not be left to sort of just pick up pieces of information, put it all together ourselves, and then come at you and say, listen, are you not doing this? We know this has developed over a period of time, it doesn't get resolved overnight, but you know, the red lights are flashing, and that's the feeling we have around the table, and we want to push the government as hard as we possibly can to get yourselves in a position where you have the resources on the ground to do the work that needs to be done, because we know that the players play pretty hard. It's the building and construction industry. We know it's hard hard business, and you're up against it. And if you're saying no, we're not up against it, we've just got to need a little bit more time, well, I think you'll need to persuade me. These are hard operators, and you just will need the resources to do it. The question that I have after what we've heard this afternoon is whether or not so much whether you're up to it, but whether you've got the resources to do it. I mean, did you want to comment on that? So there's an open invitation to say we need more resources. We need more dedicated resources, more money from the government to do what needs to be done for the tunnelling industry.
Thank you, Mr. Donnelly. Our role is to secure safe and healthy workplaces in New South Wales. I wish I were here to tell you that goal's been achieved and that everything's safe and everyone's healthy every single day, and that's just not the case. Any further support that can be provided to Safe Work to make sure that workers can go home safely to their families every day, we would welcome, and I look forward to seeing the recommendations of the committee and working forward to make those changes to make sure we can do everything we possibly can. Any further support would be a matter for the government in terms of resource allocation, but Safe Work New South Wales would welcome any help from anywhere to make sure that we can do everything we can to protect our workers.
So I'll just push it one more time. So you're not prepared to say that you feel in the circumstances you don't have enough resources. You believe, because if you're saying you've got enough resources,
you can't say it. He's
just pushing you. I mean, you've got sufficient resources.
It's a matter for government.
Well, a matter for government.
Government
but I
might know unless the
hate
regulator
to know. Hate to know. Come back. No further comments.
You have to ask Mookie and Cotsworth.
You're putting it in a hard spot.
Okay, that's okay. We didn't want to leave any stone unturned, so appreciate the answer. So on that note, thank you very much, gentlemen. Appreciate your frankness. We pushed you hard. I hope you appreciate we did it for good reason. Appreciate the honesty of the answers, and it now falls to the committee to do what we need to do to help you get the job done. So thank you very much.
I appreciate your work. Thank you so much.
That concludes the hearing for today. So we just have a very short deliberative meeting.